Madam Court Officer, court's audio seems to be muted.
Hello?
Court's audio seems to be muted, madam.
So you're not. Sir, can you repeat, please?
It is now audible. It's now audible. Thank you very much, madam.
Your voice is low, sir.
Low is it? Now, madam?
ನಂಬರ್ ನನಗೆ ಹೇಳಿ
Now is it all right?
ತಂದ್ಮೇಲೆ ಮಾಡಿ ಆಮೇಲೆ ಎಂಡಾಸ್ಮೆಂಟ್
ವಾಯ್ಸ್ ಲೋ ಐತಿ.
ಹೌದಾ ಮಾಡಿ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಇವಾಗ ಯಾವತ್ತು ಅಲ್ಲ ಅಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ಎಷ್ಟು ಟೈಮ್ ಕೊಟ್ಟರು ಗೊತ್ತಿಲ್ವಲ್ಲ ರಿಜಿಸ್ಟರ್ ಎಷ್ಟು ಟೈಮ್ ಹಂಗೆ ಬರುತ್ತೆ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್ ಥರ್ಡ್ ಡೇ ಬರುತ್ತೆ ಸರ್ ಫೈಲ್ ಆದ್ಮೇಲೆ ಥರ್ಡ್ ಡೇ ಎಂಡಿಂಗ್ ಒಂದು ವಾರ ನಾಳೆ ಅಂತ ಬರೆಯಲ್ಲ ಅದು ನಮ್ಮ ಪ್ರೊಸೀಜರ್ ಇದೆಯಲ್ಲ ಅವಾಗ ಮಾಡೇ ಮಾಡ್ತೀನಿ ಯಾವಾಗ ಗೊತ್ತಾ ಅಡ್ವೊಕೇಟ್ಸ್ ಎಲ್ಲ ಟೈಮ್ ತಗೊಳ್ಳೋರಿದ್ದಾರೆ ಮೆಮೊ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಆಮೇಲೆ ಕ್ಲೋಸ್ ಮಾಡ್ತೀನಿ 1 2 3 ಕರೆಕ್ಟ್ ಶುರು ಮಾಡಿದಾಗ ಮಾಡ್ತೀನಿ ಥರ್ಡ್ ಡೇ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದ್ರೆ ಬರಲ್ಲ ಒಂದು ಇಲ್ವಂತೆ ಅವ್ರ ಹತ್ರ ಫೈಲ್ಸ್ ನಮ್ ಕೋರ್ಟ್ಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದು ಸ್ಕ್ರೂಟ್ನಿ ಮಾಡೋದು ಒಂದು ಹಂಗ್ ಬರುತ್ತೆ ಹಂಗ್ ತಗೊಂಡ್ ಮಾಡಿ ಲಿಸ್ಟ್ ಮಾಡ್ತೀವಿ ಅದು ಫೈಲ್ ತಂದ್ಮೇಲೆ ಹೇಳಮ್ಮ ಅದು ನನಗೆ ಫೈಲ್ ತಂದ್ಮೇಲೆ ನಾನು ಇಲ್ಲಿ ಬುಕ್ಕಲ್ಲಿ ಹೊಡೆದಾಕೊಂತೀನಿ ಡಿಸ್ಪೋಸ್ ಕೇಸ್ ಇದೆಯಲ್ಲ ಸರ್ ಮಾಡಲ್ಲ ಫ್ರೆಶ್ ಬರುತ್ತೆ ಆಟೋಲಿಸ್ ಸೀನಿಯಾರಿಟಿನೇ ಬರುತ್ತೆ ಯಾವ್ದು ಕ್ಲಾಸಿಫಿಕೇಶನ್ ಯಾವ್ದಪ್ಪ ಇದು ಎಲ್ ಬಿ ಇಲ್ಲಿ ಬರೋದಿಲ್ಲ ಇದೆಲ್ಲ ಎಲ್ ಬಿ ಬರ್ದಿದ್ದೀರಾ ಇಲ್ಲಿ ಬರೋದೇ ಇಲ್ಲ ಫ್ರೆಶ್ ಥರ್ಡ್ ಡೇ ಬರುತ್ತೆ ಫೈಲ್ ಆದ್ಮೇಲೆ ಲಿಸ್ಟು ಸೀರಿಯಲ್ ನಂಬರ್ ಜಯಪ್ರಕಾಶ್ ಶೆಟ್ಟಿ. ಓ ನಾನು ಹೇಳ್ತೀನಿ ಒಂದು story. ಕರ್ನಾಟಕ ಇಂಗ್ಲೆಂಡ್ ನೆನ್ನೆ ಏನ್ ಮಾಡಿದೆ ಗೊತ್ತಾ? ನೀವೇನ್ ಮಾಡಿದ್ರಿ? ನಾನು ಫೋನ್ ಮಾಡೋಣ ಅಂತಂದ್ರೆ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಇದೆ ನಂಬರು. ಅದು ತಗೊಂಡು ಸೇವ್ ಮಾಡಿ ಮಾಡಬೇಕು. ಅದಕ್ಕೆ ಗ್ರೂಪ್ ಹಾಕ್ದೆ ನಾನು ವಿಡಿಯೋನ. ವಿಡಿಯೋ ನೋಡ್ಲಿಲ್ವಾ ನಾನು ಹಾಕಿದ್ದು? ನಾವು ಕಾರ್ಡ್ ಸ್ವೈಪ್ ಮಾಡುವಾಗ್ಲೇ ಹೇಳ್ಬೇಕು ತಾನೇ ಅವರು. ಅದಕ್ಕೆ ಹೇಳಿದಿದ್ರೆ ಹಂಗೆ ವಾಪಸ್. ಹೌದು, ಅದಕ್ಕೆ ವೇಸ್ಟ್ ಆಗ್ಬಾರ್ದು ಅಂತ ಅಲ್ಲವರೆಗೂ ಹೋಗಿ ಬಳಸ್ಕೊಂಡೆ ನಾನು. ಆಮೇಲೆ ನಿರ್ಮಲಾ ಅವ್ರ ಜೊತೆ ಮಾತಾಡ್ತಿದ್ರಲ್ಲ, ಅವ್ರ ನಂಬರ್ ಇತ್ತು. ಅವ್ರಿಗೆ ಮಾಡಿದ್ರೆ ನಾಟ್ ರೀಚಬಲ್ ಬಂತು. ಅವ್ರಿಗೆ ಹೇಳೋಣ, ಇಲ್ವೇ ಇಲ್ಲ. ಇಪ್ಪತ್ತೆರಡು. ಈಗ ನೆಕ್ಸ್ಟ್ ಸಿಕ್ಸ್ತ್ಗಿದೆ. ಸಿಕ್ಸ್ತ್ಗೆ ಹಾಕೋಣ ಬಿಡಿ, ಎಲ್ಲ ಅವತ್ತೇ ಬರೋದು. ನೋಟಿಸ್ ಆಗಿದ್ಯಾ? ನೋಟಿಸ್ ಆಗಿದ್ರೆ ಬೇಡ ಬಿಡಿ, ಮಾಡಿ ಸಬ್ಮಿಷನ್ ಮಾಡಿ. ಅದೊಂದು ಫೈಲ್ ತಂದಾಗ ಹೇಳಿ ನನಗೆ. ನೆನ್ನೆ ಲಿಸ್ಟ್ ತೆಗಿಬೇಕು. ನಾನು ಇವತ್ತು ಬಂದಿದ್ದೀನಿ. ತೆಗಿಬೇಕು, ಅಲ್ಲಿವರೆಗೂ ಏನು ಗೊತ್ತಾಗಲ್ಲ. ಮೊನ್ನೆದು ಯಾವುದು ಸೀರಿಯಲ್ ನಂಬರ್? 20 ಅದೇ ಸ್ವಾಮಿ. ಯಾರು 6 ಪಾರ್ಟಿ ಯಾರು? ಯಾವುದು? ಏನ್ ಸಬ್ಜೆಕ್ಟ್? ಏನೋ ಆಯ್ತು. ಇಷ್ಟ ಆಗ್ಲಿಲ್ವಾ? ನಾಳೆಗೆ ಹಾಕ್ಸಲ್ವಾ? ಅಲ್ಲ ಅಲ್ಲ, ಡೇಟ್ ಕೊಟ್ಟಿದ್ರ? ಸೇಮ್ ಇದ್ರೆ ಹೇಳು, ಮಾಡಿ ಸತೀಶ್. ಯಾವ ಡೇಟ್?
ಮೇಡಮ್ ಲೈಫ್ ಸೇವಿಂಗ್
ಆಯ್ತಾ? ಆಗಿಲ್ವಾ?
ಬರಲೇ ಇಲ್ಲ.
ನಾಳೆಗೆ
ಹ್ಯಾಂಗ್ ಹೋಗಿದೆ? ಯಾವ ಪೇಪರ್?
ಲೈಫ್ ಸೇವಿಂಗ್
ನಾಳೆ ಬರ್ರಿ.
ಅದೇ ನಾಳೆ ಡೇಟ್, ಅದೇ ಇವತ್ತಿದ್ದು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಾಳೆ.
ಅದರಲ್ಲಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕು.
ಏನ್ ಬೇಡ, ನಾನು ಇಲ್ಲಿ ಚೆಕ್ ಮಾಡ್ತೀನಿ. ಇವತ್ತಿತ್ತು ಅಂತಂದ್ರೆ ನಾಳೆಗೆ ಹಾಕ್ತೀನಿ.
ಮೆಮೋ ಮಾಡಿ
ನೋಡ್ತೀನಿ,
ರಿಪೋರ್ಟ್ ಮಾಡಿ.
ಹೌದು, ಇವತ್ತು ಮತ್ತೆ ನಾಳೆಗೆ ಬೇಡ. ಅದು ಪಾಠ ಮಾಡಿರೋದಲ್ಲ, ಪಾಠ ಬೇಡ ನಾಳೆ. ಫೈಲ್ ಹೋಗಿತ್ತು. ಫಸ್ಟ್ ಆಗಿದ್ಯಾ ನೋಡಿ, ಅಪ್ಲೋಡ್ ಆಗಿದ್ರೆ ಮಾತ್ರ ಬುಕ್ ಚೆಕ್ ಮಾಡ್ಲಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಬೇಡ. ಸುಮ್ಮನೆ
ಇಲ್ಲ ಮಾತಿಲ್ಲ ನೋಡ್ತಾನೆ ಹೇಳ್ತೀನಿ.
ಸ್ಟೂಲಲ್ಲಿ ಇರುತ್ತಲ್ಲ. ಹಾ, ಹೌದು, ಹೌದು. ಇಲ್ಲ ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ 1960 ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ಬರಿಬೇಕಿತ್ತು. ಬರದೇ ಹೋಗ್ತಿಲ್ಲ.
ಎಲ್ಲಾ ಕಡೆ ನಮ್ದು ಅಪ್ಸೆಟ್ ಆಗ್ತದೆ. ಹೇಳು. ಹ್ಮ್ 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 ಓಕೆ ಓಕೆ ಓಕೆ
ಅಲ್ಲಿ ನೆನ್ನೆ ಹೇಳಿದ್ರ ಕೊಡ್ತೀನಿ ಅಂತ, ಇಲ್ಲ ಅಲ್ಲ ಸಬ್ಮಿಷನ್
ಓಕೆ
ಮಾಡಿ ಕೊಡಿ. ಇದೆಲ್ಲ ರೆಫರ್ ಮಾಡ್ಬೇಕಾಗುತ್ತಲ್ವಾ, ಅದಕ್ಕೋಸ್ಕರ. ಅದರ್ ಸೈಡ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದೀರಾ? ಅದರ್ ಸೈಡ್ ಸರ್, ಅದರ್ ಸೈಡ್ ಕೊಟ್ಟಿದ್ದೀರಾ? ಅದರ್
ಮೇಡಮ್ ಅದು ವೆರಿಫೈ ಮಾಡಿ.
Lordship, kindly, my
Matter.
lord.
Memo for withdrawal, it may be less than 230 or
Kodi. Not 230, it'll come.
One memo for urgency, my lord. The petitioner has approached this honorable. The petitioner has approached this honorable court to direct the representation.
Ms. Kapoor, please mute yourself.
And same was directed to consider within a 4 months, my lords. Now, my lords, the respondents authorities are directing, are interfering with the peaceful possession of the property, my lords.
The matter is pending, disposed.
No, my lord, scrutiny, fresh filing, my lord.
Fresh filing. Kodi.
Tomorrow, my lord.
Fresh filing, my lords. Date was given for today. We had intimated senior counsel and it is not listed. Senior counsel.
Akkama, idu list dated matter ಯಾಕೆ ಬರ್ತಾ ಇಲ್ಲ?
There was one office objection. They wanted us to file an affidavit.
ಇವತ್ತು 18 ಡೇಟ್ ಆಗಿ ಬಂದಿಲ್ವಾ? ರಿಜಿಸ್ಟರ್ ಜುಡಿಷಿಯಲ್ ಬರಕ್ಕೆ ಹೇಳಿ.
Can I request for tomorrow's date? Tomorrow.
Tomorrow they are already 9. ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗ್ಬೇಕಾಗಿದೆಲ್ಲ ನಾಳೆ ಲಿಸ್ಟ್ ಮಾಡಿಸಿ ಬಟ್ ಬರಕ್ಕೆ
Watch out.
Pending matter, my lord, this is tender matter of a life saving that I moved it on the earlier occasion. Just before vacation, we were on caveat, we have filed statement of objections also. Just before vacation, because of the paucity of time, the learned judge said, don't precipitate the matter post after vacation.
ಪೆಂಡಿಂಗ್
Now,
there's so many pending matters.
now, my lord, 60, this is a peritoneal dialysis drug, my lord, we have to give. 60 children are there, my lord, their life is in right track.
30th. Passed by this court or by another court? By this court. Hmm. That we have actually listed tomorrow, I think. ನಾಳೆ ಇರ್ಬೇಕಪ್ಪ. Mr. Malsoon Rao mentioned it, saying that you are not at home and you are hospitalized in Sakrati. Niman's team went there and came back empty-handed. ಯಾವತ್ತು ನಾಳೆ ತೊಗೊಳ್ಳಿ. Yes.
And we were directed to pay the balance payment which we deposited before that.
KDB, 34B.
Deposited the amount of around 10 crores, my lord.
So it's a pending matter.
Pending.
It will come in the sequence, in the seniority. Seniority, it will come.
Like 2 weeks back, we already moved the mandate from
2 week pending matter, fresh matter.
pending matter.
Pending matter will come in seniority. Fresh matter will come in 3 days' time. Extreme urgency idre ಹೇಳಿ, otherwise.
Respondents, they are not allowing them to enter the club, my lord. Kindly be good. They are Monday at least.
Madam, it will come in seniority.
So the petitioner is a club minutes. Election of the club is scheduled on 28th. Most of the process is completed. Nominations, filing of nomination, list of final candidates also done. District registrar yesterday communicated an order to postpone the election. He has no authority. Can I request
How
to
can
have this
district
matter
register do that?
around 2:30 minutes?
When is the election?
28th.
Tomorrow we'll have it.
Great,
Yes, so
great.
Mr. Jaffa will get information, instructions.
My lords, my
Give the
case was
number
listed
and
on
details.
Monday. My case was listed on Monday, but it could not reach, and today the date was given, my lords. But it has not been listed, my lords.
It's like some 18 dated matters have not come.
Retender, 2:30, my lords.
200
please.
matters have been listed.
Kindly, my lords, because
They
30th
also
is
have
the
little
last date.
difficulty in, we understand their
Yes, my
position
lords.
also.
Yes, my lords.
Whatever is not been listed today will be listed tomorrow.
The end
If
of
dated
the
matter is not been listed tomorrow, today will be listed tomorrow.
30th is the last.
Naale 25th amma.
Much obliged.
Lord's heard the matter reserved for orders. Furnishing the citations, my lord.
You have served it on the other side?
No, I will
No,
serve.
if you have not cited the citation, you can't just give the citation like that. Whatever you argued, yes, we'll consider it. After the argument, you can't come and give a citation.
My lord, yesterday not play on the one judgment I
You
relied on.
can't
my
be
lord.
doing like that. We can't tell you behind their back, you can't come and give a citation. We won't
Request
accept.
your lordship kindly.
We won't accept it behind their back. So if you have to do something, you have to do it properly.
Tender.
Hmm.
Following the procedure. Tender has been allotted to the bidder. Work order has been issued already. Work is not commenced now. It will happen tomorrow, madam.
Work order has been. ನಿಮ್ಗೆ.
No, but work is not yet been commenced as of now.
So what is your ground? What is?
No, but the procedures for the tender process. Some of the steps has been not been considered by the.
Yes, regular course.
My lordship.
Testimony is before you.
ನಿನ್ನೆ ಲೀಸ್ಟ್ ಆಗಿ ಅದು ರೀಚ್ ಆಗಿಲ್ಲ.
ನೆನ್ನೆ ಎಲ್ಲ ರೀಚ್ ಆಯ್ತು ಎಕ್ಸೆಪ್ಟ್ ಯಾವ ಡೇಟ್ ಇದೆಯೋ ಅದು ಬರುತ್ತೆ.
ಇಲ್ಲ, ಆಲ್ರೆಡಿ ಮೈ ಲಾರ್ಡ್ಶಿಪ್ ಇಂದ ಆಲ್ರೆಡಿ ಬೇಸ್ಡ್ ಆನ್ ದಟ್ ಇಂಟ್ರಿ ಆರ್ಡರ್ ದೇ ಆರ್ ದಿ petitioner is sold the entire my share properties. 50%.
Everybody has urgency. We will only go by the seniority in the sequence. ಯಾವತ್ತಿದೆಯೋ ಬರುತ್ತೆ ಅದು. Short validity passport. Trial court has allowed you to travel? Then how will they give you? The trial court hatra permission ತಗೊಂಡ್ಬೇಕು ಇಲ್ಲಿ ಬಂದ್ರೆ ಏನ್ ಪ್ರಯೋಜನ ಆಯ್ತು ಲಿಸ್ಟ್ ಆಗುತ್ತೆ ಕೊಡಿ ಬಂದ್ಬಿಟ್ಟು ಅದೇ ಅಬ್ಜೆಕ್ಷನ್ ಹೇಳ್ತಾರೆ ಆಮೇಲೆ ಮತ್ತೆ ಅಜ್ಜನ್ ಆಗುತ್ತೆ ಅಷ್ಟೇ ಎಸ್ without a criminal case.
Your lordship are directed to both the matter is not directed. Not a single criminal case.
It must have been dated matter. All of them we give dates.
Date ಕೊಡ್ಲಿಲ್ಲ post ಮಾಡಿ immediate ಆಗಿ ಅಂತಂದ್ರೆ ಅದು ಆಗಿಲ್ಲ ಸರ್.
Date ಇಲ್ಲದೆ each and every matter there is a date given by this court. Yes. Vacating will come in seniority. ಏನ್ ಕೊಡೋದ್ ಬೇಕಾಗಿಲ್ಲಪ್ಪ ನೀವು ಸೀನಿಯಾರಿಟಿ ಅಲ್ಲಿ ಬರುತ್ತೆ ಏನಪ್ಪ ಮೆಡಿಕಲ್ ಪರೋಲ್ ಕೊಡಿ ಏನಾಗಿದೆ ಇಷ್ಟುಲಾಗ ಏನ್ ಅರ್ಜೆನ್ಸಿ
My lords, we filed this petition in Feb 2025, my lords, and it hasn't been listed. Notice has been issued to the respondents, but after that it hasn't been listed, my lords.
Has the notice been served?
Notice has been served, my lords. We filed a memo for deletion of one of the parties because the address is not found, my lords. So a date may be given for sometime next week, my lords.
Yes. Tomorrow it will get listed.
Memo for withdrawal. Already memo filed.
Court it will come.
Find evidence tomorrow.
ಏನ್ ಅರ್ಜೆನ್ಸಿ ಏನಪ್ಪ withdrawal?
So writ petition filed before for cancellation of the 1960 society in the apartment complex, my lord. We've already filed the case in the January, my lord. They're already the notice already been sent only once, and your lordship
Notice has
already
been
heard the
served?
matter once, my lordship. Only once it's heard.
A notice has been served.
Yes, yes. On
For
Monday, my
consideration
lordship.
of interim prayer next week.
My lord, missing complaint is registered against petitioner, my lord. I informed the police that I am not missing, I am safe at my native place. But they are harassing me to come to the police station, my lord. Kindly at 2:30, my. They may, if I go to the police station, they may detain me.
Missing person has come himself.
Yes, my lord, 2:30, my.
ಏನತ್ತೆ
2:30, my.
tomorrow?
Much.
My lord, urgency this matter is that the petitioner is 47 years old. She was adopted by German citizens, German couple. My lord, senior counsel, the notice has been issued. Senior counsel has asked her, requesting for the date on Monday.
That cannot be done. It will come in the usual seniority. Yes.
Without any order, penalty compounding notice has been issued. So
What notice
no
has
penalty order has been issued. So without any documents, they wish
Who has issued?
FCRA, under FCRA Act, Your Honor.
FCRA.
Correct. Foreign Contribution Regulation Act.
See, all you juniors get this opportunity to mention. We spend time for you to make your submission. Read the file and make a proper mention.
Yes, sir. Sorry. Under FCRA Act, a penalty order has not been issued, and yet the compounding notice has been served. The 30 days has been expired, Your Honor.
1st July.
If it could be taken up tomorrow, Your Honor.
1st July it will come. Yes.
The allotment was dated 1995, because the matter has, I have moved the memo twice.
Allotment of what?
Allotment of land by the KIDB, my lords. With respect to that, my lords, I have sought an direction to allot the my lords. So I seek a short accommodation. Any date may be fixed for
Pending matter.
pending matter.
Pending matter will come in senior.
Several memos have been moved, my lord. Twice date also has been given. Petitioner is an old man, constantly not putting where it's very simple.
If it's a pending matter, it will come in seniority irrespective of the memos that you move. It will come in seniority. Everybody is waiting.
Some date may be given, my lord.
You can't give a date to ascertain the seniority. Fresh matters you move. Pending matter will come in seniority. It will be taken up in seniority.
Adjournments. List number 1, page number 5, serial number 25 and 26.
Serial number 21, Your Honor. On short account may be given, Your Honor.
You are for?
Petitioner, Your Honor.
Have you informed the respondent?
I will inform Your Honor.
Don't mention without informing.
ಅವರು ವಕಾಲತ್ತು ಕೂಡ ಫೈಲ್ ಮಾಡಿಲ್ಲ.
Don't mention without informing. Yes.
Page number 6, serial number 27 to 29. Page number 7, serial number 30 to 33.
27. At the request of counsel for respondent released on 16 July. Interim order and unread the note.
Page number 7, serial number 30 to 33. Page number 8, serial number 34 to 36. Page number 9, serial number 37 to 41. Page number 10, serial number 42 to 46. Page number 11, serial number 47 to 53.
My lord, serial number 53. I appear for the petitioner, my lord.
Serial number
53.
53.
53.
Mike is that side, madam.
My senior is out of station, my lord. Kindly grant short
At the
accommodation.
request of counsel for the petitioner released on 16th July.
Much obliged.
Page number 12, serial number 54 to 59. Page number 13, serial number 60 to 66.
Serial number 61, my lord.
60?
61. First or second of next month, please.
Next date is 16 July.
First or second, my lord.
If you want the adjournment, 16th, so is today if it reaches.
16, please.
At the request of counsel for the petition, 16 July.
Submission.
My lord, so serial number 69. Serial number 69.
69?
For the respondent, my lords. Senior is out of station. His mother passed away.
Have you informed the petitioner?
Yes, my lords.
Inform him, if not inform.
Great, my lords.
It's submitted that there is a bereavement in the family of the arguing counsel for the respondent. Released on 16th July, IA 1 of 24 is allowed. IA 1 of 26 will be considered along with the main.
But submission.
Serial number 75, my lord. Petitioner counsel is also present. I will inform them. Senior is out of it. Any date in the upcoming week.
No objections. I request a date may be fixed, preferably to
75
July.
at the request of counsel for the respondent, released on 16 July.
Interim order may
What
be
about this
extended.
impleading application? Who has filed this impleading application?
We have 75.1. We have filed.
To implead whom?
Ours, he's the father of that child.
75.2, IA 1 of 23 and 2 of 23 are allowed. Released
Interim
on
order may be
16. Interim order
extended.
earlier granted is extended till next day.
Grateful.
Serial number 53. Interim order kindly extended.
53 interim order.
List number 1, fresh matter, serial number 1.
My lordship, I'm appearing for the petitioner.
Yes.
My lordship, the petitioner is a service provider who has, he's an intermediary who provides services to MSME banks. So if there was an agreement between the petitioner and the syndicate bank, and the syndicate bank got amalgamated with Canara Bank. And Canara Bank had done an illegal termination of the agreement.
There's no interim order that you. Canara Bank, Karama?
TP Muttanna.
TP Muttanna is directed to accept notice for respondent. Counsel for the petitioner to serve 2 sets of the petition along with annexures on the said counsel. Released on 16 July.
Serial number 2, Samaj Shriza.
Petitioner in this matter had
Yes.
qualified for a technical bid and thereafter disqualified. It was a 2-bid system. Initially, I was qualified under the technical bid and thereafter disqualified. I may make one submission. There's a similar matter, connected matter with the same parties listed at serial number 54 today.
We will take it up with 54.
Great.
Serial number 3, Venkatesh Dalwai.
Yes, Ms. Dalwai.
But the respondent granted OTS. Respondent, my lord, granted OTS. My lord, of course, there was a delay in payment, my lord.
This will have to go before the other bench. OTS,
classified as
surface, ಎಲ್ಲ ಅಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು.
yes, surface ಎಲ್ಲ.
Bank, DRT, surface. Perusal of the above papers indicate that the matter relates to a one-time settlement. Registry to verify and place before the appropriate bench. Great.
Serial number 4, Ajay T.
For the petitioner in service.
ಇದೆಲ್ಲ ಇಲ್ಲಿ ನೋಡಿ. Bank ಎಲ್ಲ ಇಲ್ಲಿ ಬರ್ತಾ ಇದೆ. ಪಾಪ ಅವ್ರಿಗೆ ಬಿಲ್ ಆಗುತ್ತೆ. Yes, madam.
I'm the petitioner in this case, Lordship. I'm the manufacturing of the lift and its spare parts, Lordship. And I'm protected under the Micro, Small and Medium Enterprises Act.
You're asking for
And since there is
certiorari,
an-
no interim relief.
Lordship.
Who is for the respondent? Anybody, any standing counsel for the respondent? Is there a standing counsel for the respondent?
No.
Micro and Small Enterprise Facilitation Council ಯಾರಾದ್ರು ಇದ್ದಾರಾ? Issue notice to the respondent, returnable by 27 July.
Lordship, can I make one submission on similar 4 matters connected? Parties are different, but they are the similar nature. I have filed 4.
Has notice been ordered in those matters?
Sorry, Lordship.
Has notice been ordered in those matters?
No, it's yesterday it's complied, Lordship.
And then you
Before
should
the
move a
registration.
memo for listing.
Yes,
We connect ಮಾಡಿದ್ರೆ notice ಆಗಲ್ವಲ್ಲ?
Serial number 5. Sadhana is there, sir.
Yes, madam.
My lords, what I've challenged is, my lords, at Annexure A, page 21, wherein, my lords, a notice is issued to me seeking to enter my name as a rowdy, my lords, in a rowdy sheet. The only 3 grounds I'm canvassing is this, my lords. I will place before my lords, I'm relying on regulation 1059 of the police manual. May I please
Are there any
pass-
criminal complaints pending against you, proceedings pending against you?
So, my lords, please, I will take my lords to page 21, which is the impugn notice, my lords. In that, they have given about 4 to 5 matters, my lords. The first one, my lords may see, Kodihalli Police Thane Mukaddame number 95 of 2023. This is the one which is already quashed, my lords.
It's quashed.
Yes, by this honorable court, and I produced a judgment also. Second one, my lords, Kodihalli Police Thane Mukaddame Sankhe 32 of 26. This one is pending. However, when I moved for quashing, this is for the offense of 109 and coupled with atrocities offenses, my lords.
Yes.
Atrocities offenses is stayed, 109 is not stayed, my lords. Then all the other what is mentioned is NCR. NCR by the police only. So nothing is pending.
And AG accepts notice for the respondent. He seeks for and is granted 10 days time to obtain instruction, make a submission as to why the show cause notice for opening of the rowdy sheet in the name of the petitioner has been issued when the submission of the counsel for the petitioner is that crime number 95 of 23 has been quashed and crime number 32 of 26 insofar as
Section 109.
Section 109 is proceeding.
Please, my lords. It's
Is
attempt to
proceeding only
murder.
in respect of section 109, offense and section 109 of BNSS, and the other
Provisions
proceedings
under-
cited in the notice are all NCRs, which cannot be a ground for issuance of for opening a rowdy sheet in the name of the petitioner. Released on
Well, it's, may I please
2nd
seek a
July.
stay of this impugn notice, my
The
lords.
operation of Annexure A is stayed till the next day.
Please, I'm so grateful.
Serial number 6. Girish R.
We have a petitioner in this case, madam. Emergency parole matter, madam.
In emergency,
His father, prisoner father is admitted on chest pain, madam.
What is the document you have produced?
Document number, page number 22, madam. Annex C, madam.
Annexure C.
Yes, madam. Page number 22.
Stable angina.
Earlier also, one surgery is carried out agi ಮಾಡಿದ್ರು ಸ್ವಾಮಿ. ಮತ್ತೆ repeatedly ಆಗಿ ಆಗ್ತಾ ಇದೆ. He is aged about 65 years, madam.
Just came here. Where's your imprisonment certificate?
Annexure B, madam. Page number 21.
Page number?
21. As on 2/11/25 ಗೆ 2 years 17 days ಆಗಿತ್ತು ಸ್ವಾಮಿ.
At least verify. He is only 2 years. And AG accepts notice for respondent. He seeks for 3 days time to verify the contentions taken in by the petitioner and make a submission released on 29 June.
Serial number 7. V. Jawar Babu.
Defreeze the accounts.
Lord, I beg to appear for the petitioner.
Yes, Mr. Babu.
Let's 3 credits are disputed consequent upon second respondent instructions. However, the entire account has been frozen. Let's the total sum in dispute is about 59,130. It's a salary remittance account. I have no
Yes.
money for sustenance also.
Yes. State Bank of India.
Vignesh Shetty.
Vignesh Shetty for respond number 1.
Complaint ಮಾಡಿದ್ memo ಎಲ್ಲ.
Onambal for respond number 2. Relist on yavatadu outside state.
10th July.
10th 3rd.
Sir, out of state ಎಲ್ಲ 10th July. sir.
Monthi ಬಂದಿದ್ದು 3rd ಅಲ್ವಾ? 10th July.
Millets, in the meantime, Millets may make one submission as an interim measure. At least rupees 10,000 can I withdraw per month for sustenance?
No, we don't know what are all the.
No, I have produced everything. Millets only 59,130 is sum total.
You have made it. We don't know from the bank and NCRB.
Very well, very well.
Because we find petition says something, when they come up with a different figure. Whatever figure they come up, we'll restrict it to that figure.
Very well. Highly grateful to your lordship.
Serial number 8. Mithun GA.
Petition. The reason I've sought for leave is because this prior to this order.
No, just one.
Please.
Why is the numbering FR to this?
Leave I've sought for your lords.
Change agidi process.
I believe this is circular that if I've sought for a leave, then it's going to be on FR number. The leave I've sought for is because there's an order of takeover in favor of the petitioners allowed on Section 8 of the RERA Act by the RERA authority. Now, subsequent to that, there's some orders that is passed that's impugned a lot under serial number 8, 10, 11, 12, and 13, where certain vendors and also certain apartment purchasers have filed certain complaints against the promoters. Since promoters have abandoned the project, association, the petitioner has been handed over the project under Section 8 a lot. Certain orders have been passed without impeding us in those complaints, stating that the money has to be recovered from the complainant, the association. Therefore, we are aggrieved by those orders.
It says association. It says recover from Buyers Welfare Association to refund with interest.
Please.
So you will become the owner of the apartment.
So therefore, we've sought for leave, your lords.
Is Mr. Ullal here? What is the reason for this order?
Though the authority is the one which handed over the project to us, we don't see a reason why there was such an anomaly while passing such an order. The takeover orders also produce a loss.
So now once you take over the project,
please, Lords,
you step into the shoes of the promoter.
Please. Now the money is taken by the promoter, Lords. I can only hand over the project.
What happens to this apartment? Who will be the owner of this apartment?
Lords, now if they don't complete the project and if they want to refund the money is already taken by the promoters. Now those promoters have been abandoned. Since they've collected the money, they have to repay the money, Lords, because that is what even the takeover order states. Any money that is received by the promoter before the takeover, they are responsible for those payments.
Fair enough. But now that you are taken over,
please, Lords,
to whose credit would this apartment be? Who would be the owner of this apartment?
Lords, if they hand over the apartment back to the association, then we will be responsible for completing the project, Lords, with respect to that particular apartment. Right now, it's not been handed over to us because the takeover is only with respect to what is been not sold, Lords. What has been unsold has not been handed over to us as yet.
But this apartment is also not complete.
It's not completed, and it's already sold to someone else.
So when you complete the project, this apartment will also get completed.
It also has to be completed.
You can't leave out this apartment.
We can't leave out the project. So they can.
So after you complete, who will be the owner of this apartment?
Let's then ultimately, if they proceed to, let's say, Lords, perhaps to pay the balance amount, then we will complete the project by receiving the balance amount or whatever the escalation it is. Now, the point here is they're seeking for refund. If it's a refund, then the promoters who have taken the money, then they have to pay the. I understand. I understand your Lord's point.
Within word, if now they're asking for refund, they don't want the apartment.
They don't want the apartment.
Now the promoter is not there. The purchaser doesn't want the apartment. The only person in possession of the project is you.
Please.
So A plus
I
B
mean, I'll have
equal
to
to
invest,
C.
association has to
Will
invest
be,
money.
association will become the owner of this
But
apartment.
I'll have to invest money for the amounts which is collected by the promoters. That's the Section 8 order.
Correct. Then if this becomes the asset of the association can probably sell it and recover the money. So why should person?
Because takeover order is that, your lords.
We'll have
The
to
takeover
hear you
order
on
is
this.
that the promoters have to pay the OD amounts that is.
Why we are flagging it is for you
understand,
to
Lords.
do a little research on this and get back.
Please.
Because this will be a.
This
if it
will
has
be an
been
important.
dealt with in any other matter, fine.
That will be an
If
important
not,
issue.
that will become the fulcrum of this whole thing.
Please.
IA 1 of 26 has been filed seeking for permission to prosecute the above appeal on the ground that the association, though not a party to the proceeding in CMP, in complaint 507 of 25, the direction has been issued to the association to refund the amount paid by the complainant along with interest,
To the promoters.
which was paid to the promoters. The affected party being the petitioner, who has been directed to make payment of the said amounts, this court is of the considered opinion that the petitioner would be entitled to prosecute the above writ petition, challenging the order passed against it without it being on record. Hence, IA 1 of 26 is allowed. Registry is directed to register the matter as a regular writ petition. Sri Gautam Deve Sullal is directed to accept notice for respond number 1, issue notice to respond number 228. Did any counsel appear before the RERA for them?
Please, I can also serve to the concerned authority, the concerned advocates.
Counsel for the petitioner is also permitted to serve the respective counsels who appeared for the respective respondent before the RERA authority. The issue in the above matter would relate to who would be the owner of the apartment. The facts giving rise to the above matter is that the complainant had entered into an agreement with the developer to purchase an apartment. The apartment complex not being completed, the association made an application in Section 8 of the RERA Act 2017-16 to take over the said project, which was so granted, and thereafter the association has taken over the project and implementing the same with contributions from the other purchasers. In the present case, the complainant, not wishing to continue with the allotment, has sought for refund of the monies which have been directed to be paid, directed to be refunded, albeit by the association, since the association has taken over the project. The submission of Learned Counsel for the petitioner is that since the monies were paid to the developer and the association has taken over the project only to complete it on account of default of the developer, the association cannot be mulcted with the cost of refund of the monies received by the developer. This incidentally, and this raises another question, in as much as since the project has been taken over by the association and the developer is no longer available, who would become the owner of the apartment in question, since the purchaser does not wish to take the purchase of the property and only wants a refund? Whether this apartment will go back to the share of the developer or it would fall to the share of the association who has taken over the project would be an important question to be decided. Hence, the operation of the order dated 23rd April 2026 at Annexure A is stayed till the next date of hearing. The counsel for respond number 1, Sri Gautam Dev Ullal, is also directed to address this court on the above issue.
10, 11, 12, and 13, it's the same series matters.
10, same order, 11, same order.
12.
10 ಅಲ್ಲಿ dispense IA2 is also allowed, 11 same order, IA2 is allowed, bari complaint number check ಮಾಡಿ. 12, 13.
That's it.
Connect to each other.
It's great.
Serial number 9, MB Chandrachuda.
Yes, Mr. Chandrachuda.
Petitioner is an association registered under the Societies Registration Act
Now an order has been passed by the government appointing an administrator. Respondent number 5 is one of the member of the association. Went on filing a complaint before the registrar of societies contending that there is misappropriation by the societies concerned. Kindly take Annexure C, page 20.
First problem would be that this association is not permissible.
That is how it starts.
Because
said-
the division bench has held that Society Registration Act cannot carry on apartment maintenance activities.
Certainly. So someone has to look into it.
How
Someone
can
has-
you continue?
He filed a writ petition before this court for cancellation of the registration of the association, Annexure F, page 83. Is pending before this court.
I will take it up together.
My submission is 603 apartments are there. Someone has to look into it. Day-to-day management has to be done.
Someone has to do it, but not a society under this act. That's what the division bench has held, and the division
If
bench has
that were
said
to
what
be
you
the
have to
case,
do.
if that were to be the case, registrar has no authority to appoint an administrator.
You are carrying on a business which is not permitted. Obviously, he can appoint.
It is not the business as it is. The inquiry has been conducted. I have been exonerated from the charges leveled against me.
Then today, you know the division
And
bench.
I requested a registrar to register the society under the Apartment Ownership Act. They said it can't be registered. Kindly see the
He
endorsement
can't
issued.
do it. You have to do it under KOA.
No, I requested, kindly take Annexure J, page 30, 130.
Page
130.
130.
I requested for registration of Apartment Ownership Act.
Have you
Not
filed
done
a? You
Kindly
want
see-
this to be converted into one under KOA.
Kindly see 131.
What is the
131
provision
reply.
to convert it under KOA?
Please,
Show us the provision.
there is no provision
But
at all.
how can they do it? Request
Kindly
not.
see reply given by them. It is matter under consideration before the government, page 131.
You can request, provided it's permissible under law.
Please.
If that is so, we'd have directed. But you can't convert a society to one under deed of declaration has to be filed. You file the deed of
And
declaration.
separate registration, page 131.
And AG accepts notice for respond number 1 to 4, issue notice to respond number 5, returnable by 21st July. Connect with, what is the other number?
It's not for writ petition number 13,406 of 2000.
Please write it down and give it.
It's not for stay of Annexure S. Now the administrator appointed.
Yes.
If that were to be the case, there is no question of appointment of administrator to the society. If the society itself is not in existence.
So that you don't do the illegal activities. Next.
Serial number 14, K.S. Venkataramana.
The date may be given.
21st July.
Petition this case, my lord.
Yes, Ms. Venkatraman.
Seeking for a mandamus, my lord. Seeking for a mandamus
Huh?
of enforcement of the order passed by the Assistant Commissioner in the Senior Citizen Act, my lord. The petitioners are the, my lord, senior citizens. They obtain an order, Annexure D. My lord, the daughter-in-law and the son, my lord, they are not vacating the property. That is the reason, my lord, I have approached the judicial police, but there is no assistance, my lord. That is
We
the
had
only
asked
grievance.
you, Jafar, we had asked you another matter. How does the enforcement happen
Yes, sir.
of the orders in the
The
administration?
enforcement is by the judicial police.
Hmm.
The tribunal does not have any authority to enforce it. In
So
fact,
is this order, I
They
think that,
give some time to, in case if there is a eviction, there are two aspects. Enforcement of payment of the maintenance if ordered under the act, and other aspect is the recovery of property or eviction of the property. Recovery and this one, my lord, the Tahsildar has the powers. They direct the Tahsildar, or they take the police help. The Tahsildar, while evicting, can take the help of the local police.
so they'll have to approach for either recovery or on
Yes, sir.
to the Tahsildar.
Tahsildar, 160.
There's nothing in the act which says so.
Nothing in the act which says so, my lord. They are applying that 168, my lord. Arrears of land.
Should not the people be informed about the procedure so they can follow the procedure? Now they're not gone to the Tahsildar.
No, man.
They've gone to the police station.
Please, my lord.
Police station says, police says,
We will not
we can't do
recover.
anything.
It should be done through the Tahsildar, my lord.
That is what you are saying.
Delegate the power.
But neither we are aware of it, nor the parties are aware of it.
I will place it before the court, my lord. One of the matters, your lordship may
In this
kindly
one
observe
only
that,
you do.
and then they can follow that.
In this matter, my lord, one submission, my lord. My lord, admittedly, the property is belonging to, my lord, the petitioners. There is no claim by the respondents. Despite, my lord, they are not vacating.
But you are asking for implementation of the
Please,
Assistant Commissioner's order.
please.
It has to be done in accordance with
Please,
law.
please.
So what you have to do is,
I
you
have
will
to approach
record
the Tahsil.
the AGS submission. Please. That you will have to, we'll
Approach
keep this
Tahsil.
pending.
Please.
You approach the Tahsildar.
Please.
Tahsildar will follow the due procedure and
Please.
get it implemented.
With the,
If it doesn't get implemented, it will be pending.
please.
These are all tribunals that are like RERA, my lord. Even they don't have their own executive authority. Same thing. Your
So
lordship,
they have to
observe
bite.
that. I will,
Only the order passing is of no use.
of no use unless it is toothless.
It's
I'll
toothless.
place it before the, we can observe in one of the matters now. Lordship, I'll get the information.
Learned AG accepts notice for respond number 3. Issue emergent notice to respond number 1 and 2 written on by 20th July. The grievance in the above matter of the petitioner is that the order passed by the Assistant Commissioner
Annexure D.
under the senior so and so has not been implemented despite the petitioner having approached the third respondent police authorities. Learned AGA submit that the police authorities would not get direct jurisdiction to implement the order passed by the tribunal, inasmuch as it would be for the petitioner to have approached the Tahsildar, who would have taken up the matter and passed necessary direction to the concerned authorities, depending on the nature of the order passed by the tribunal. This aspect, there are several matters which are coming up before this court relating to matters relating to proceedings under senior citizen so and so. One of them is as regards the implementation of the orders. The AGA is directed secure instruction and place on record the process and procedure followed for the purpose of implementation of the order of the senior citizen tribunal. Relist on same so and so.
Oh, please.
Serial number 15, Vinay N.
Liberty is reserved to the ಕೇಳಿ Mr. Venkatramana ಅದು ಕೇಳಿಲ್ಲ ನೀವು ನಾವು ಮತ್ತೊಂದು liberty is reserved to the petitioner to approach the jurisdictional Tahsildar who is directed to comply with, who is directed to implement the orders passed by the tribunal.
Assistant, please. Oh, please.
15, Vinay N.
My lordships, senior is held up in court hall 1, my
Pass
lordships. Kindly pass. Oblige.
Serial number 16.
15, my lord, it may be taken up along with WP 7194, my lord. That is coming up tomorrow, my lord.
Tomorrow.
Please, my lord.
16, my lords.
What is 7194?
I am mentioning in serial number 15, my lord.
15.
15. Yes, 15 or ಎಲ್ಲೋದ್ರು?
Vinay N.
Mr. Vinay.
Please, ma'am.
He is
Pass,
not here.
please.
So when he comes, you can make that.
Please, ma'am.
16.
16, I'm appear for the petitioner, my lords. I'm challenging Annexure A, auction notification, my lords. Petitioner is a successful bidder in the year of 2020-21, my lords, regarding the right of fishing livestock of Subedar Lake, my lords. I'm seeking for extension of this lease, my lords, on the ground that page 38, Annexure E, my lords. Respondent number 3, BBMP has issued a work order for providing chain link fencing to the Subedara Lake, my lords. By that time, my lords, lake water was completely drained by the opening surface channel, my lords. Large
No
number
water
of
for you to
fishes were
fish.
died on that time. I'm
Verify.
relying on the this lease fishery rights of lease fishery rights, my lords, is
We'll get
regulating under
instructions from them. Learned AG accepts notice for respond number 1 to 3. The submission of learned counsel for the petitioner is that for over a period of 8 months, there is no water in the lake and the to enable the petitioner to fish in terms of the fishing license issued. And it is in that background that the extension has been sought for. Learned AG is direct secure instruction and make a submission. When is the notification?
29th, my lords. 29th is the auction.
29th. Relist on 29th. I-1 of 26 is allowed.
In the fresh matters, my lords.
Fresh matters, in fresh matters.
17, Ajaya.
Yes.
There was tender matter, miscommunication between two government departments itself, my lords. One is minor irrigation and the other one is fisheries. I was allotted a tender in the year 2021 for 5 years. Then what happened because of there was a particular order in 2014 by the government of Karnataka. Ativrashti, Anavrashti, ee ತರ ತೊಂದರೆ ಇದ್ರೆ it can be extended for 2 years. So based on that, my fishery tender
granted in
it
2021.
was continued for another 2 years. The order is passed, which is at Annexure F
Yes.
This one is passed by the Fisheries Department, page number 44. Page number 44.
44.
Yes, page number 44.
Yes.
The order is passed. Page number 45, my name is there. Mulubaglu, Krama Sankhya 4. Nangli Dodkere.
ಮೀನುಗಾರಿಕೆ ಇಲಾಖೆ, this is
Yes.
Fisheries Department.
Yes.
You are which lake?
1,35,519 ಕಟ್ಟಬೇಕು ಅಂತ.
You are which lake?
Right?
ಯಾವ ಲೇಕ್ ನೀವು?
ನಂಗ್ಲಿ ದೊಡ್ಡಕೆರೆ.
ನಂದಲಿ
ದೊಡ್ಡಕೆರೆ. Page number 45.
ನಂಗ್ಲಿ ದೊಡ್ಡಕೆರೆ, yes.
So 1,35,519 I had to pay. The next page, Manoj, Annexure G, 46. I have paid the same on the very next day. 18 June 2026, the payment has been made.
Yes.
Now, Annexure A, Manoj, which is at page number 21, starts from 19, page number 21. The same lake, Nangli Dodkere, first item, Kolara Jille, Mulabagalu Taluku, Nangali Dodkere. Maton tender raise ಮಾಡ್ತಾರೆ. This one is by minor irrigation.
My lord, I'll seek instructions, my lord.
But
Today is the last.
The money.
My lord, they are seeking extension based on the.
Order has been passed for
No,
extension.
my lord, I'll seek instructions.
Not seeking instruction. They are not
That is passing,
seeking
my
extension. Extension has been granted.
Please,
Amount has been directed to be paid. They have deposited the money. Maybe the delay or not, we don't know. But on the same day, it's been issued.
That is the reason, my lord. I'll seek instructions, my lord. All these tender matters, my lord.
15/6/26
Please, my lord.
to be paid by 36/26. So they had time till 36/26 to pay. How could this notification be issued on 18/6? They should have waited for 36.
And there's a communication by the
Could it
Fisheries
be taken
Department
tomorrow,
also.
my lord?
Manoj.
Please.
We'll take it up, but today is the last day.
I'll seek instruct, pass over, my lord.
Pass over.
Please.
Pass over is better.
Please.
Please.
Both of you are saying the same. First time you are taking.
They have sought for adjournments previously as well, my lords.
All councils seek for adjournment. What is new about it? When do you want it? One date and the problem is that it goes to 16. At the request of council for response
That'll be
number
too
7,
long, my lords.
released
Short
on
date.
16th, it is made clear that no further adjournment would be granted if
As any
arguments are
date-
not advanced by respond number 7, 8, 9, 11, 14 and 15. It is made clear that on that date, the matter would be taken up for consideration on the basis of submission made by the councils present and arguing.
Request at least it be taken up in list 2, my lords.
We are not even started it. How do you get that priority?
If I request for next week, my lords, because the matter reached on the previous.
Next week, it won't reach.
I'll take
You
a chance,
already
my
have
lords.
more than 120 matters each day.
I'll take a chance, my lords.
Bad up. Next.
Serial number 19.
May I play lordships?
Yes.
Lord, this matter may kindly be passed over, my lords. We'll have to argue the matter.
Last time also, my lord, he sought Passover. The afternoon, my lord, did not reach. My lord, it's a matter, my lord, where, my lord, election result has been withheld by order of this honorable court, my lord. That's the reason.
It will reach Passover. Allegation ಮಾಡ್ತೀರಾ?
ಇನ್ನೆಲ್ಲ ಅಲಿಗೇಷನ್ ಮಾಡ್ತಾಯಿಲ್ಲ. ಲಾಸ್ಟ್ ಟೈಮ್ ಆಯ್ತು ಅಂತ ತಮ್ಮ ಗಮನಕ್ಕೆ ತರ.
Serial number 20. Ajay Prabhu.
For petition.
Petitioner in the connected read petition. The connected read petition was filed by the.
So which matter do you want us to take up?
Both the matters.
Both the matters we'll take up. Which matter first?
Lord,
Both matters we can't take up at the same time.
And my matter could be taken up, my lord, for convenience of my lord, to 12059 of 26.
ಇದರಲ್ಲಿ ಏನು mandamus grand over the keys of locker or temple matter.
How?
20.1 you challenge
for a writ of mandamus, my lord, directing to hand over the keys of the management of the
Yours will have to be taken up depending on this one. Yes.
My lord, the impact of the interim order passed in the writ petition, my lord, has resulted in the present writ petition.
Hmm.
My lord, in the serial number 20, my lord, writ petition, main prayer was, my lord, to hand over the keys of the temple, my lord.
Consideration of a representation, not hand over.
My lord, it is as good as, my lord, interim order prayed in the writ petition was, my lord, without making the committee of management as a party, which was well within the aware of them, my lord. An interim order was sought, my lord. May turn to interim order passed by the Honorable Court in the writ petition, my lord, at page 178. And 179 would be, my lord, a relevant portion in my writ petition, my lord. In the interim order, my lord, a final order as good as, my lord, came to be passed by the Honorable Court, my lord. May I read that portions, my lord?
Yes.
Learned AGA is directed to accept notice to respond number 1 to 4. The impugned endorsement issued by the respond number 2, Deputy Commissioner prima facie appears to be in clear disregard and contrary to the order passed by this court in WP number so and so, and thus gives rise to a serious concerns of willful disobedience. The coordinate bench by detailed order rendered upon consideration of section 42 and
What has happened to the? It's been disposed. 34468.
Yes, my lord.
Hmm.
That has been challenged in the writ appeal, my lord. Writ appeal is pending consideration.
Hmm.
My lord, what was challenged in the writ petition was, my lord, government, my lord, proposes to take, my lord, declare the institution, a temple as a declared institution, my lord. Recommendations were made by the government, and that recommendations came to be challenged in writ petition number, my lord, 34468 of 24. My lord, that writ petition came to be allowed, my lord, as per annexure Q, page 152. But holding that there was no foundational effort by the government to declare the institution as a declared institution, requirement of section 42 were not followed. Therefore, my lord, that communications were quashed by the honorable learned single judge, my lord. My lord, it was nothing to do with the management of the committee of management or the temple, my lord. Then, my lord, the private respondent who claims to be the hereditary trustees of the temple makes representation to the commissioner and deputy commissioner to hand over the keys of the management, my lord. Alleging that, my lord, that representations were not considered, writ petitions came to be filed for a writ of mandamus. But interestingly, committee of management was not made as party to the writ petition, my lord. An interim relief was spread, my lord, directing to hand over the keys. My lord, this honorable court ex parte passes an interim order, my lord, directing the, my lord, that operative portion.
The committee is the administrator or?
My lord, it is a committee formed by the public, my lord. There is no dispute.
What is the legal status of it?
My lord, the temple was a public.
Where's the order in 34468?
Please, my lord, annexure Q, page 152, my lord.
152.
Please. There, my lord, committee was respond number 6.
Committee was not respond number 6.
The president, Sri Vishnumurthy Temple, my lord,
Vishnumurthy Temple, but you are calling yourself something different now.
No, my lord.
The committee of management.
Same, my lord,
What is your legal status?
My lord, so far as the petitioner is concerned, my lord, they are managing the, my lord, the temple administration.
What is your legal status?
My lord, the legal status is, my lord, by custom, my lord, for decades together, public have elected the committee of management, and management has been done by the public, my lord.
Where is the details of those?
Yeah, my lord, they themselves admit, my lord.
That there is a committee?
Yes, my lord.
Where have they? Then why haven't you made them a party?
Please, my lord.
Yes. Let us see this order.
Now, my lord, interim order came to be passed. Lordship may kindly turn to page 179, my lord.
Let us see. The final order has been passed here.
Yes, in the writ petition.
And this is what the other coordinate bench on that
Yes,
basis
yes.
passed the interim order.
Annexure Q, my lord. My lord, the writ petition proceedings arises out of, my lord, proceeding initiated by the government to declare the institution as a declared institution, my lord, because there was a mismanagement where the reports. Then this honorable court has proceeded to allow the writ petition and quash the such communications, holding that, my lord, there was no foundational reports, my lord, to declare the institution as a declared institution. That operative portions, my lord, get it at page 176, my lord.
Yeah, just 1 minute.
It is fallen in their court. They claim to be the hereditary trustees. Suddenly,
So what was in the question was
Section
declaration for it to be a notified temple.
Yes, my lord. But there was no, my lord.
And that notice was issued to the petitioners in the other matter, not to you.
Yes, my lord.
You are not a party to the notice.
No, no.
You did not challenge it.
No, my lord.
You are only your so-called respondent by showing yourself as the president.
And they are pleading to, my lord, declare the temple as declared institution. They are in favor of the government recommendation. Now they want management.
But then the state stand is that it was erroneous and has been remitted to deputy commissioner. Your committee came to be formed in 2023.
No, my lord. There, my lord, my lord, committee was there from, my lord, for several decades. My lord, they admit it. 2023, my lord, they form a trust, my lord, private trust, stating that, my lord, this is a hereditary temple. We form a trust and we will manage it. Then, my lord, government noticing it, my lord, initiates proceedings under section 42. My lord, honorable learned single judge quashes the proceedings on the ground that there is no foundation or report to invoke section 42, my lord.
Yes.
My lord, there is
Within
nothing.
20 days.
Yes, my lord. There is, my lord, nothing to do with the management of the committee of the temple, my lord. That order, my lord, does not touch, my lord, who is in management. But only proceedings under section 42 cannot be invoked by the state is the order, my
The
lord.
trust would continue.
Please, my lord.
The trust, effect of it is the trust would continue.
My lord, the difficulty would be trust has to take, my lord, possession of the, my lord, declaration that there is a hereditary trust. Then, my lord, they have to, my lord, take the management of the temple in accordance with the law, my lord, if they want to do so. My lord, admittedly, my lord, the temple is run by a public.
The learned single judge in the coordinate bench has
Yes.
taken into consideration that they wanted to initiate proceedings under section 42 against the said trust.
Yes, ma'am.
The single judge coordinate bench has taken into consideration and affirmed that the trust is managing the affairs of the temple.
No, ma'am.
And for that is what the judgment says. No one tell that.
My lord, the
Then the 42 proceedings were quashed.
yes,
That means the trust will continue to manage the affairs of the temple.
my lord, the other aspect would be, my lord, so far as this order is concerned, it is pending before the honorable division bench, my lord, in the writ appeal.
It is coming up on 29th.
Then
on this basis, the another coordinate bench has passed the interim order. When the trust is there, they were the petitioners there.
But there, my lord, like lordship may kindly see, my lord, we are not made as a party in the writ petition. Interestingly, my lord.
You are not required. You are nobody.
My lord, I am the.
They have the trust,
My lord, we are.
which has been recognized in this matter.
My lord, custody of the temple keys are with the petitioner, my lord.
What are you now challenging in this?
Now, my lord, an impugned order in my writ petition is, my lord, directing me to hand over the keys, my lord, without a notice, without an inquiry. Annexure A is the order in the writ petition, page 20, my lord.
One
That is called in question.
One correction. 23, Tahsildar takes over the charge. Lord, it is illegal. He takes all the keys. In respect of, Lord, I will give a representation after disposal of the writ petition, Lord, to give hand over all the keys and the Garbhagudi decree also. Lord, he doesn't care. That is why I filed writ petition. My lord, they cannot say that I have taken it from them.
When a writ appeal is pending, why are you filing a separate writ petition? You should have gone in the writ appeal and asked for all these reliefs.
Lord, there was difficulty for us to, my lord, manage the temple.
Difficulty, if you can file a writ petition, you can file a writ application in the writ appeal.
Lord, in fact, my lord,
Without bringing to us, to the coordinate bench, the notice of the writ appeal, you file a separate petition here. You should have gone there.
Lord,
Both of you are in the wrong.
Lord, in fact, my lord, my lord, in writ appeal, the question is, my lord, section 42.
Now, if you wanted the handover,
Please.
how do you maintain a separate writ petition when it's subject matter of that writ appeal?
Lord, there was no statement. I brought to
We
the
will come to
my lord,
your
kindly-
petition later. Let us finish his
Please,
petition.
please.
My lord, page 179, interim order passed by the honorable.
So, but what is the annexure A?
That is the order, my lord, pursuant to the interim order passed by this honorable court. My lord, for that, before reading that, may I show the interim order of this honorable court, my lord, page 179. Therefore, my lord, page 179, last para. Therefore, pending consideration of the present writ petition, and having regard to the fact that the recommendation has been already been quashed and no interim stay has been granted by the division bench in writ appeal 19919 of 25, this court deems it appropriate to direct the respondents to forthwith hand over the keys of the locker after duly drawing an inventory of the temple ornaments maintained by the trust.
Yes.
However, such handing over of the keys to the committee constituted by the petition shall be subject to outcome of writ appeal.
Yes.
But now,
What is wrong with this?
Honorable Learned Single Judge, I have no difficulty with this interim order, my lord. They direct the respondent in the said writ petitions were the state authorities, my lord. We are not parties to that writ petition. My lord, interim direction was to hand over the ornaments locker key, my lord. My lord, Honorable Learned Single does not say management has to be handed over. Therefore, my lord, forthwith hand over the keys of the locker after duly drawing an inventory of the temple ornaments maintained by the trust. That is the interim direction.
Correct.
Now kindly turn to page 20, page 20 impugned order, my lord. Para 2, my lord. ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಉಲ್ಲೇಖ 2 ದಿನಾಂಕ 24/3/26 ಆದೇಶದಲ್ಲಿ ದೇವಾಲಯದ ಆಭರಣ ದಸ್ತಾನಗಳನ್ನು ಲಾಕರ್ ಕೀಗಳನ್ನು ತಕ್ಷಣವೇ ಹಸ್ತಾಂತರಿಸುವಂತೆ ಪ್ರತಿವಾದಿಗಳಿಗೆ ಸೂಚಿಸಲಾಗಿರುತ್ತದೆ. Then my lord, kindly next para. ಆದುದರಿಂದ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ದಿನಾಂಕ 24/3/26 ಆದೇಶದಂತೆ ಮೇಲಿನ ಉಲ್ಲೇಖ 1ರ ಪತ್ರದಲ್ಲಿ ತಿಳಿಸಿರುವಂತೆ ತಮ್ಮ ಸುಪರ್ದಿಯಲ್ಲಿರುವ ದೇವಸ್ಥಾನಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಎಲ್ಲಾ ಸಾಮಗ್ರಿಗಳನ್ನು ಇಡಲಾಗಿರುವ ಲಾಕರ್ ಕೀಗಳು, ಗೋದಾನು ಮತ್ತು ದೇವಸ್ಥಾನದ ಕೀಗಳು ಮತ್ತು ದಾಸ್ತಾನು ಪುಸ್ತಕಗಳನ್ನು ರಿಟ್ ಅರ್ಜಿದಾರರಿಗೆ ಹಸ್ತಾಂತರಿಸುವಂತೆ ಮತ್ತು ಹಸ್ತಾಂತರಿಸುವ ಸಮಯದಲ್ಲಿ ಅರ್ಜಿದಾರ ಉಪಸ್ಥಿತಿಯಲ್ಲಿ ಪೊಲೀಸ್ ಬಂದೋಬಸ್ತಿನೊಂದಿಗೆ ವಿಡಿಯೋ ಚಿತ್ರೀಕರಣ ಮಾಡಿ ಮಹಜರು ನಡೆಸಿ ಸಂಪೂರ್ಣ ಮಾಹಿತಿ ದಾಖಲಾತಿಗೊಂಡು ಈ ಕಚೇರಿಯಲ್ಲಿ ಸೂಚಿಸಿದೆ. The impugned order, my lord, says everything has to be taken over and possession has to be
This is by the deputy commissioner to the Tahsildar.
Yes, my lord.
Yes.
Tahsildar, my lord, comes and forcibly takes the charge of the management of the committee temple, my lord, where there is no such interim direction.
Your management has not been established. That's what we are telling
My lord,
you.
they admit, my lord, kindly see, my lord, their statement of objection in the writ appeal and the trust deed itself.
So all these issues you raise in the writ appeal, because both of you are filing separate petitions when a writ appeal is pending.
My lord, I have no, my lord, my difficulty is, my lord, when the impugned order was passed, my lord, directing me to hand over the possession, my lord, in the writ petition, I have no other option.
You were not directed to hand over.
My lord, now difficulty is,
you have not been recognized by any of the courts.
My lord, courts have recognized my right, my lord.
In which matter?
My lord, in the, so far as their statement of objection, they admit that the committee is maintained.
In the first matter, the trust was recognized to have been formed in 23. 42 proceedings were initiated. That was quashed. It was the trust managing. This court permitted the trust to continue the affairs. Taking into account, in the second matter, the interim order had been passed directing the respondent authorities to hand over everything to the trust.
Yes.
Which is under challenge in the writ
My
appeal.
lord, authorities, my lord, takes possession from me, my lord. My lord, authorities, if they hand over the keys, which are with them.
Where is that?
My lord, that is the effect of annexure A order, my lord. After passing this order, immediately they come and take the, my lord, the entire charge of the temple, my lord. My lord, publics are, my lord, under a difficulty. My lord, considering this, my lord, misrepresent.
verify who was in possession because the order says it's the trust. Please file your objections or
No, no.
report as to who was in possession, from whom were you taking possession. Because the Tahsildar, Deputy Commissioner directed Tahsildar to hand over. Was
Their
it
writ
in
petition
your
itself
possession,
says-
was it in the possession of Tahsildar to be handed over to them? Or did you take it from somebody else?
My lord, noticing this, my lord, how the misrepresentation made by the private parties, my lord, this honorable court has also passed an interim order, my lord, directing that Tashildar, my lord, take, my lord, supervise, my lord, the ornaments of the temple.
In which matter?
In the same matter, my lord.
Huh.
The order dated, my lord, 16/4/2026. After, my lord, noticing that, my lord, everything from the petitioner was taken away in a high-handed manner, my lord, by misinterpreting the interim order passed by this honorable court.
16/4 in which
WP 12059 of 26, my lord.
12059 order. 16/4.
Please.
Yeah, notwithstanding the handing over, Tahsildar to maintain, yes.
Yes, my lord.
Because you are fighting between each other.
Honorable Langal CJ said, my lord, notices, my lord, without making committee of management as a party, interim order was obtained, directing the management committee to hand.
That is pending in the writ appeal. We cannot encroach on that
My
jurisdiction.
lord, so far as the writ appeal is concerned, my lord, with respect, I may submit, my lord, a proceeding under section 42, whether it initiated is proper or not is the subject matter of this.
We cannot get into that
Yes,
when the division bench is seized of it.
My lord, my entire difficulty would be, my lord, for decades together.
And it's not for you to argue that here. You can argue that there, not here.
That could be done, my lord. My endeavor would be, my lord, public has been running the temple management.
We don't know. We'll get that report. You've
Yes,
been
ma'am.
saying that, that's all.
Yes,
But the orders are otherwise.
Yes.
And AG,
Lord,
My lord, let them, my lord, say from whom they have taken possession
your
of.
writ petition, you should have gone in the
Understand,
writ
I
appeal.
understand. But one submission is that, my lord, when, my lord, there is a specific order of my lord, appointing administrator, that is Tashildar. When he has handed over, my lord, taken the charge of temple.
That is why we are
My
asking.
lord, they cannot say that, my lord, they have taken it from them, my lord. Because even if it is true, my lord, it will be illegal. Because, my lord, Tashildar.
With due respect to both of you, we won't believe either of you.
Yes.
We will believe the state. Let us see what they say. You will have your allegation against them, they'll
If
have
they
their
say that, my
allegation
lord, it
against
is
you.
taken from,
I
my
have
lord,
the-
the
my lord, I
petitioner
have-
in
my
that
lord,
connected petition, it will be, my lord, have a consequence.
Temple is a good business, lot of money involved.
My lord, I have
That
the
is why.
documents placed
See,
on.
jewelry, locker, that is what you are fighting.
Jewelry ಅವರು ಕತ್ಕೊಂಡು ಹೋಗಿದ್ದಕ್ಕೆ FIR
My
ಆಗಿದೆ
lord,
ಸರ್. Annexure FIR ಅನ್ನು ಹಾಜರು ಮಾಡಿದೆ.
Lord, I
Annexure
will-
M ಅಂತ.
Lord,
ದೇವಸ್ಥಾನಕ್ಕೆ ಭಕ್ತರು
ಅವರು-
ಕೊಟ್ಟ ಜ್ಯುವೆಲವನ್ನು ಕತ್ಕೊಂಡು ಹೋಗಿ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಮಾರ್ಗೇಜ್ ಮಾಡಿ
they should not, my lord,
ಹ್ಯಾಂಡ್ ಓವರ್
say,
ಮಾಡ್ತಾರೆ.
my lord, half-baked, my lord, information. They should, my lord, from FIR to till the judgment have they produced documents.
please
They should not only rely upon FIR.
Everybody is hearing your submissions.
Understood.
Please understand, the allegation made by I is that you are stealing the jewelry of the Lord, the deity.
Yes, my lord.
What kind of it? What do we have to say? And AG is direct secure instruction and make a submission as to who was in possession of who was administering the temple as on 9/4/26.
Lord, kindly see the order itself, my lord. Kindly see Annexure A, my lord.
He'll get that report from him, please.
Andre,
9/4/26. Who was in possession of the jewelry, the records, etc., and from whom the possession of such articles have been taken by the Tahsildar and handed over to the trust. ಯಾವಾಗ ಕೊಡ್ತೀರಾ?
Next week. Next week.
Released on 2nd July. Before it gets into a law and order problem, please give the details.
They are directed to make inventory, my lord. That itself show, my lord, who is in possession. Let them place that also. Please.
He is also directed to place on record the inventory prepared.
it's already placed on record.
Here,
Please.
Interim order in my report.
20.1 IA 1 of 26 is allowed. The interim order earlier passed continues till the next day.
21, Kiran Kumar.
Short adjournment.
Jagdish, to the scheduled caste, scheduled tribes, or is it OBC?
Scheduled petition.
Scheduled. At the request of counsel for the petitioner, released on 16 July.
Thank you.
22, Nandish Patil.
Lordship may grant me 2 weeks time, my lord. Your lordship had directed us to produce some documents. We've applied under RTI, my lord.
Tender matter, if you keep on taking time, what will be there?
Work order is still not issued, my lord. We'll produce the document.
The request of counsel for the petitioner, 16 July.
23.
May I seek for a passover, my lord?
23.
23.
Ah.
Is in court hall number 4, my lord.
Passover.
Passover.
For dismissal, serial number 24.
Yes, Mr. Mohan.
Sorry, Your Lordship, I could not be present on the last day.
Not that day, earlier also is not been.
I have sent my colleague ಅವರು late ಆಗಿ ಬಂದ್ರೆ ಅಷ್ಟು ಕರೆದು ಬಿಟ್ಟಿದೆ. See, the short point is that
When regular counsel appear, if they don't appear, many a time it is the matter doesn't survive for consideration. That is why you are not appearing. And without putting you on notice, we can't dismiss it.
Your Lordship, in this matter, the petitioner husband was working on an honorary basis before the horticulture department. That is third respondent on honorary basis. That appointment is at Your Lordship will point at page 13.
13. Yes.
V. Babu, serial number 15.
Babu.
13, page number 1. V. Babu, last 15. Jenu Krishi Gauravadana. 25,997 in the and his honorarium is 5,009. Thereafter, Your Lordship.
It is not Vetana, it is honorarium.
15 lakhs eligible.
And then what happened, Your Lordship? As per Annexure C, page 22.
Yes.
The BBMP has put him on the duty of COVID. Page 22, Your Lordship, Annexure C.
Yes.
He was put on as a nodal officer. His serial number is, Your Lordship, serial number 10, page number 23.
Gunjuru.
Gunjuru, Kaigarika Ilake, KR, because he was on deputation to Kaigarika Ilake. So now what happened, Your Lordship?
How did the BBMP deputy?
Then he died due to COVID, and on the ground what they are saying that since he is on a honorary basis and directly not in contact.
We will come to that. He is the horticulture department.
Yes.
BBMP deputed him.
BBMP has drafted him for the COVID duty, and he died because of the COVID contact.
Yes.
Relief is sought against the horticulture department only.
But you deputed.
My lords,
You are the one who deputed. On what basis did you depute?
during COVID time, BBMP was supposed to look into all the inter-jurisdiction of
So you
Bangalore.
exercised interdepartmental powers.
It was probably given that powers. My lords.
That is why we are asking under what powers. So if you had done that and at your instructions, you were deputed, was working at your supervision, especially on the COVID aspect, then you are responsible. It's not horticulture department. Or whoever is responsible between you, you sort it out.
Yeah, right.
It's not for them to be.
Collect the samples and submit.
And he suffered from
Annexure
COVID.
J, Your Lordship.
He suffered from COVID and expired. Yes, compensation.
Annexure L is the endorsement now given by the horticulture department. The director duty is also.
After L, what do they say?
ಏನ್ ಹೇಳ್ತಾರೆ ಅಂತ? ಓದು.
Page 36.
36. Last para, my lords.
ಮುಂದುವರೆದು ಉಲ್ಲೇಖ 4ರಲ್ಲಿ ಉಲ್ಲೇಖ 4
ನೇರವಾಗಿ
ನಿರ್ದೇಶಕರು ಆರೋಗ್ಯ ಮತ್ತು ಕುಟುಂಬ ಕಲ್ಯಾಣ ಇಲಾಖೆ ಅವರ ಪತ್ರ.
Annexure J, as per Annexure J, Your Lordship. Anybody who is a health or even a private under Pradhan Mantri Garib Kalyan package, page 30, Your Lordship.
You are responsible for all of them.
My lords,
You are responsible for all of them.
my lords, we only had to get people to help us out with the COVID work then. But the compensation, if any, has to be paid by the department, parent department itself.
Sort it out amongst both of you.
We'll do that, my lords.
Why should they be run? You are making them a football, go to that department, go to this
The
department.
endorsement which is given by the horticulture department.
And
is
when we died when? 2021.
Correct.
And you have been making the widow run around for 5 years.
Agreement. I'll look into this.
And,
There's no representation which is sent to BBMP, so I could not answer this.
next time, if you ask them to come and volunteer for something, will they do volunteer?
Even Annexure E, Your Lordship, BBMP
No
has
more
approved, it's
representation.
carried out
Anything.
duties.
Please get
You have
your
to sort it out
instructions,
between
sort it out, and
One of them has
let
to
us
take
know
it.
by next date. We'll give you 2 weeks time.
Yes,
Please
ma'am.
sort it out.
Yes.
The petitioner is before this court. The petitioner is the wife of one Shri V. Babu, who had though initially been appointed on an honorarium basis with the horticulture department. During the COVID period, the erstwhile BBMP had designated him as a nodal officer in Gunjuru when he contracted COVID and expired. Representations after representation have been submitted for compensation by the widow. No action was taken by the horticulture department. By endorsement at Annexure L, it was indicated by the horticulture department that proceedings would be taken up under the Pradhan Mantri Garib Kalyan scheme and compensation paid. Till date, no compensation has been paid by the
My lords, the
authorities.
endorsement says he is not eligible to get it. ಮುಂದುವರೆದು ಉಲ್ಲೇಖ 4ರಲ್ಲಿ ದಿವಂಗತ
Sorry, it's not eligible under the Pradhan Mantri Garib Kalyan scheme and as such requested the request. It is challenging same, the petitioner is before this court. Sarshara ಕೇಳಿದಿರಾ?
mandamus.
Sarshara ಇದೆ. In most cases, it's only mandamus you ask. Mr. Mohan knows. At this stage, this court is unable to accept the said endorsement in as much as the facts are undisputed. The husband of the petitioner was employed by the horticulture department. Apparently, the BBMP excising cross-department supervision during COVID period had deputed him as a nodal officer for monitoring COVID-related issues. He contracted COVID and expired from it on 4/6/2021. It is the responsibility of the government, whether it is the horticulture department or the BBMP, to have made due compensation and not deny it on the account that he was only on an honorarium and not on regular appointment. Irrespective of whether being on honorarium or regular appointment, the fact remains, which cannot be changed, is that it is BBMP which had appointed him as a nodal officer in
It says that direct agi
In
he was not
Gunjuru.
involved in that.
But Annexure C is,
Endorsement says that the horticulture department not on because he was on honorary basis,
but
because he was not directly involved in the COVID.
No, Your
patient
Lordship, may
treatment.
kindly
Other
say
endorsement
Annexure C.
nodal office. Honorarium ಅಂತಾನೂ ಹೇಳ್ತಾರೆ.
Annexure C, the word, what is word, Annexure C, ತಾವು ನೋಡಿದ್ರೆ, page 22.
Sir, ಒಂದೇ ನಿಮಿಷ.
He has to collect samples coordinated.
There can't be any dispute.
ಮುಂದುವರೆದು ಉಲ್ಲೇಖ 4ರಲ್ಲಿ ದಿವಂಗತ ವಿ ಬಾಬು ಜೇನು ಕೃಷಿ ಸಹಾಯಕರ ಕೋವಿಡ್ ನೋಡಲ್ಸ್ ಅಧಿಕಾರಿಯಾಗಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದು ಕೋವಿಡ್ ರೋಗಿಗಳ ಚಿಕಿತ್ಸೆ ಅಥವಾ ಶುಶ್ರೂಷೆಯಲ್ಲಿ ನೇರವಾಗಿ ಭಾಗಿಯಾಗಿರುವುದಿಲ್ಲ ಎಂದು ಪ್ರಧಾನಮಂತ್ರಿ ಗರೀಬ್ನಲ್ಲಿ ಎಲಿಜಿಬಲ್.
Do you want us to comment on that?
No, my lords, we'll consider this. I'm only saying what has been written there.
Then we'll have to ask you what are the duties of nodal officer. Then you will be in serious trouble.
No, I'm not interjecting. I'm only saying what is to be done. What was there in the
It is for the horticulture department and the BBMP sort out as among themselves as to who is going to make payment of the compensation, since ex facie it is clear that compensation amounts have to be paid. Relist on 16th July.
B group matters, serial number 25. Parshuram
I
AL.
appear for respondent number 2 and 3, please.
So I appear for the petitioner. In the lead
Service
petition
is not complete in the second matter.
Your Lordship, in the lead petition, they have already entered appearance. So, Your Lordship,
25.1 Kodi.
direct. We'll serve a copy on them today itself.
No, I have the copy.
You are appearing for respondent number 3 in that also, Bharat.
Please, 2 and 3, please.
1 and 2 is AGA.
My lords, one is the state, my lords. 2 and 3, they have nominated a standing
2
council.
is Inland Water Transport Department. Infrastructure Development, Ports and Inland Water Transport Department, you are appearing.
Director and port officer.
Port Officer is 3, Director, both of
Director
them.
also.
25.1, Registry is correct the appearance of the Council for Respondent as learned AGA for respondent number 1 and Bharat Kumar V as that are paying for respondent number 2 and 3. And there would be no requirement for making payment of any process fee. 25, Kodi?
Your Lordship made one humble submission, my lord.
1 nimisha. Same, correct the appearance. AGA for so and so, 2 and 3. So, yes.
Lord, Your Lordship may kindly see the daily order of 6/3/2026.
In which matter?
6/3 in seal number 25, 14592, my lord.
Order sheet. 6/3.
Yes.
Yes.
The learned additional government appearing for the respondent state to obtain instructions as to whether after cancellation of the lease in the respect of the land in question, it has been allotted to some other person or not. If the land has not been allotted to some other person, the government shall invite fresh tender to which the petitioner may also participate. Now, my lord, regarding the calling of the fresh tender, now that my learned friend is appearing, if that information is placed, that this is essentially government land which is being held. It was allotted to him to set up an ice manufacturing plant, which he has not done. From past 8 years, my lord, there are two matters. In one matter, he was supposed to pay the lease amount which he had not paid. 50% was paid in the other connected matter, and he's holding over the government land without even developing the plant, nor
Here, what is saying?
or he himself has said that there are some difficulties, some objections from land. Then if there's some objections from thing, he should give up land, and alternate land he has to ask. He has not done that also. He just held over the land for this long period of time.
Please, one submission.
Your Lordship, the land was just on. Yes.
Lords, the land of 800 square meters was allotted to him in the year 2013, please, Lords, which mandated at page 36.
800 square meters.
800 square meters.
8,000 square feet.
Around 8,000.
For setting up of an ice plant, please, Lords. By page 36, an agreement was entered into wherein it was agreed that immediately he will obtain all permissions to erect the factory and the same will be completed in 12 months. And he does not do so, please, my lords. He pays the rent, which is at a nominal rate, up to 30/11/2018, which is 2,60,000 or 2,70,000, please. And subsequently, in the year 2019, page 47, when a demand has been raised with respect to the payment of rent, he keeps quiet. And thereafterwards, a proposal goes for cancellation of lease in year 2020 at page 48. It goes from the port officer to the director. And from the director to the
Page
government,
48.
it goes.
Yes.
From the director to the government, it goes at page 51, which is on 25/1/2021. It is only after that, at page number 53 on 18/2/2021, he raises an objection saying that I am unable to utilize this land for XYZ purposes.
Then why? Okay, we'll ask him.
So even according to him, the first order, which is on 4/3/2024 of this honorable court,
Various persons have objected.
please.
What has he paid till now?
No, it's 2,63,701.
How much was he to pay?
He was to pay, my lords, the demand.
Demand was 6,14,000.
Well, it's 583,046.
Now, if he is surrendering, you are willing to refund the monies?
My lords, I have sought instructions with respect to that. If it comes as an order from this honorable court.
The orders from the court. That because that will be one of the issues that you can't keep it if he is to, unless there is a forfeiture clause which you can point out.
That is the reason, by virtue of order dated 4/3/2024, it was directed that he would further submit that he would seek instructions whether the property would be required or not for the petitioner in the future. And subsequently, this honorable court also felt that if it is already given to somebody else, he may participate. But in the second writ petition, he has challenged that now it is required for Mangalore Smart City project, please. And we have not done so because of the pendency of this writ petition.
Yes.
Lordships, the lease period ends in the year 2029. We had made representations to them saying that we were being prevented from developing an ice plant for the purpose which was the lease was granted.
You're being prevented. You
Please, Your
can't do. There's no fault on your part.
They have
There's
submitted a
stone
report.
pelting. Neighbors have stopped you from getting into the property.
Please, Your
You don't have the money. All those things you said.
It is accepted by them also.
We'll also accept it.
Please, grateful.
So how can you still retain the property?
Your Lordships, now my instructions are that if they were to forfeit, if they seek instructions and come, then
That's
I'll
all.
seek instructions.
So you're ready to give up your this
I'll have to
one.
seek instructions on that.
If you don't give it up, then we'll forfeiture will apply.
Make the submission. If he makes a representation, we will take decision in accordance with law. That may be ordered.
We have already made a representation and their report has already been submitted, Your Lordships, on that aspect. They have
Refund if he
admitted it.
makes a representation.
Where is the representation?
It is at page number 53. He makes a representation only in their 2021.
And that 53 is, he can't do it is what he
Can't
said.
do it. That's what he's saying.
21.
For refund, if he makes a representation, we will consider it.
Not
as
for
my-
refund. He is only
It is not
noting
for
that I can't pay their rentals.
He has not made that refund.
He's not claimed for that.
He has not.
And he's still asking you to hand over the possession.
In 2021, my lords, when we try to determine the lease because he has not.
He is admitting that you are in possession.
There you go. Please.
What is the issue?
Lordships, I believe that subsequently the possession has been handed over to the petitioner.
That is not stated anywhere. Your role, this one is that they are in possession, hand over the possession.
No, Lordships,
Don't
the-
cancel it without handing over
The
possession.
interim order states that the cancellation of
Correct.
is carried-
Cancellation is state.
Please, Your
But
Lordships.
possession is with them as per the records, as per your
Apparently
own
your own-
representation.
That's a previous representation, Lordship. Subsequently,
Where is the subsequent representation?
There's no subsequent representation, Lordship, but following the interim order passed by this honorable court.
After that, nothing has happened.
After that, on that part, I'll have to seek instruction.
Have you put up any construction? You are not put up.
We've been prevented from doing that, Your Lordship.
You are not in possession. So find out the status of refund. If that is so, we'll make it part of it so that you are in possession is already there.
There.
And it can be closed and used for the smart city.
Parts are the parts. Very well.
Madam, first, please. First.
16th.
Please.
Great. Interim order in both the
Bharat Kumar, we seeks for and is granted a week's time to place on record the status of the property as on today, along with photographs, as also to make a submission on the payments which have been made by the petitioners. Since the petitioner himself claims that he is unable to implement the project due to the neighbors not allowing the petitioner to implement the same, as also that there are law and order problems which have resulted in the said property as per his representation. Shri Bharat Kumar is directed to ascertain from the respond number 2 and 3 as regard the stand of respond number 2 and 3 relating to the payments made by the petitioner, whether it will be refunded to the petitioner on surrender of the allotment. Released on 16th. Interim order earlier granted is extended till next day.
Grateful.
Obliged.
Serial number 26, Vijay Kumar, for connected matter.
I'll appear for the petitioner matters in 26.1.
Yes. Two 11 of 24, 218 of 24. Filed by different allottees.
Yes.
What is his objection on the affidavit?
My lords, I appear in 26.1, my lords. The counsel on record, previous advocate, my lords, is on dialysis.
Okay.
He could not give me NOC, my lords. That is why, my lords, I have filed an affidavit. And I have filed my wakalat, my lords.
Now, your affidavit is also not sworn to before the competent authority is the objection.
There cannot, because he cannot sign. The previous counsel cannot sign, my lords.
Who cannot sign?
The previous council.
Affidavit, not wakalat.
Huh.
Objection is not on NOC. Objection is on your affidavit. Where is your affidavit? When did you file your affidavit? See the affidavit that you have
Because
filed.
I'll comply it, my lords.
Counsel for the petitioner seeks for and is granted 2 weeks' time to comply with the office objection raised on the affidavit filed in 26.1, released on 16 July.
Grateful.
Serial number 27 urgent,
Obliged,
28.
my lords.
Yes, Mr. Somshi.
Yes, accommodation, madam, kindly.
Yes, ಆಗಲ್ಲಪ್ಪ ಲಿಸ್ಟ್ ಆದ್ರೆ argument
Monday or Tuesday, madam. I have to get the instructions, madam.
3:10 they have taken.
ಇಲ್ಲ, ಇಲ್ಲ.
My lords,
One day, madam.
order sheet.
Monday, madam. I will not seek much time. I have to get
Mr. Somshi,
instructions.
we
madam.
adjourn this matter enough
ಅಲ್ಲ,
time.
ಒಂದೇ ಒಂದು.
Sandesh is opposed
ಅಲ್ಲ,
earlier
I have to get
also.
some instructions, madam. Monday I will go on
To
with.
get your instruction, we'll pass over.
madam. No, madam. ಶಿವಮೊಗ್ಗದಿಂದ ಬರ್ಬೇಕು ಅವ್ರು.
Shimoga in the phone al matter.
ಅಲ್ಲ, ಅದಲ್ಲ.
Shimoga instruction can come on the phone.
There are some other things.
can't
Monday,
be a-
ನಾನು ಜಾಸ್ತಿ ಇದು ಮಾಡ
My
Monday.
lords, Monday
Positively, I will go on with the matter, madam.
See, our schedule gets filled up.
Please, madam.
ಇವಾಗ adjournment ಅಂದ್ರೆ 16th. 16 ಮತ್ತೆ ಬಂದು ಇನ್ನೊಂದು
ಬೇಡ,
adjournment
ನಾನು
ಅಂದ್ರೆ
ಕೇಳಕ್ಕಿಲ್ಲ.
ನೀವು
Definitely, I will not ask.
get your instruction on phone. Next.
Monday or Tuesday.
Ajay Prabhu.
Please, madam.
Not adjourned.
Madam, ನಾನು ಅಲ್ಲಿ ಆರ್ಗಿದ್ದೆ.
ಇವಾಗಲೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೊಂಡು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ
ಇಲ್ಲ, ಅದು ಬೇರೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್.
ಬೇರೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಮತ್ತೆ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳ್ಬೇಕು ಅದನ್ನು ಫೋನಲ್ಲೇ ಬರುತ್ತೆ. At the request of counsel for the petition released on 16th July. It's made clear that no further adjournment will be granted. If arguments do not advance, petition would be liable to be dismissed for non-passage.
Grateful, my lords.
Who is appearing now? Uday Prakash.
My lords, he's out of station. His mother passed.
Is
For
entered appearance for
respondent
respondent 1 to delete Suyog earlier as that appearing for 1 and 2. And who is appearing? Sandesh TV has entered appearance for respondent number 9, delete Vishwanath HM as that appearing for respondent number 9. Yes.
29 Ajay Prabhu.
Lord, appearing for the respondent, my lord, your instruction in this matter, my lord, 2 weeks time may be granted.
ಏನಕ್ಕಪ್ಪ ಲಿಸ್ಟ್ ಆದಾಗ why do you advance?
Lord, the copy
You
was
know
served
everything.
last week to us, my lord.
1 week is enough.
My lord, it's a medical reimbursement case.
Huh.
Secure instruction, I'll file my objections. 2 weeks time, date will be fixed, my lord. I'll secure instruction in this matter.
Counsel for the respondent seeks for and is granted 2 weeks time finally to file a statement, file a statement of objection, get ready and address his arguments. It is made clear that no further adjournment will be granted. If objection not filed by 9th June, it will be taken as not filed and matter proceeded with by drawing an adverse inference, released on 16 July.
It's a reimbursement of medical bills.
30 Ravindra V. Reddy.
Petitioner, my lord, last occasion, my lord, directed for the inspection
Inspection.
by the Karnataka State Control Board.
The basement, counsel.
And they have filed the report also, my lord. They have admitted that
Report
Petition has been filed on 1st December 2025, your lordship,
1st December.
2025. The STP indeed is existing in the basement unit, your lordship.
STP is in the basement.
Please.
page number 1, point number 1, my lord.
Last para, point number 1, your lordship.
What is the relief which you sought for here?
Inspection report 26/11/25.
Pollution Control Board is a party?
Please, Your Lordship. Respondent number 1.
You are appearing.
Please, Your Lordship.
So you're given a CFO
Your
for
Lordship.
the STP. It's not clear from this report.
CFO obtained, if Lordship, page number 1, the tabular column, consent status.
Correct.
CFO obtained from the board, white consent order dated, and the CFO is valid till 30th June 2027.
Now, is this for the STP or is it for the building? Because the wording is very inappropriate. They have obtained CFO from the board white so and so for residential apartment.
Apartment with, along with STP of capacity at above said premises.
Oh, that is down below, yes. And above it. There's a CFO.
My lord, the BBMP plan which STP should be installed, that is reverse opposite side it has been installed. The BBMP plan says it should be installed on the front of the apartment, but it is installed on the page number, my lord.
Where is the BBMP plan? Approved plan?
76 page number, my lord.
76. '76 is photograph.
Yes, my photographs that shows clarity of the picture. Now the STP is under the flat number 83 and 84. And actually, as per BBMP sanction plan, it should be under as per photo 76. And
Everybody becomes smart without giving the details. Now, next question we have to ask, again, you'll take adjournment. Is it in the location that it was supposed to be and approved for by the BBMP sanction plan?
it is in 72 page number sanction
We
plan.
have to verify.
So what is the purpose of carrying out this inspection, coming up with these kind of reports? You only very blindly said there is a CFO for that, but whether it's at that location.
Your Lordship, there has been violation because as per KSPCB SOP also, STP cannot operate in basement.
In basement.
In page number 62, it is admitted, my lord, STP guidelines, which is issued by the Karnataka State Control.
What action are you going to take against this?
Your Lordship, we'll have, if the court, our instruction is if the court directs Your Lordship in 4 weeks.
Why should the court? This is your duty. Somebody has set it up in a basement where people go and park. All the fumes will be there. There's health danger for everybody who goes to the basement. And if methane gas or something gets accumulated, there could be an explosion. It's a dangerous situation.
Then may I seek 2 weeks only to file?
Thankfully, nothing has happened till now.
Only to file the affidavit of the further action plan, Your Lordship.
My lord, the petitioners
Report
are facing.
of the environmental officer, report of the environmental officer Elanka has been filed on 1/12/25. As per the said report, it is indicated that there is a consent for operation from the KSPCB wide CFO dated 9/9/2022 for the residential apartment consisting of 360 flats along with STP of capacity 235 KLD, which is valid until 30/6/2027. The report further goes on to state that the STP is in operation. There is foul smell which is generated. There's also a generator which has been, there's already a 250 kVA generator which has been installed. The report is silent as regards whether the STP could have been set up, installed and operationalized in the basement. It is also silent as regards the location where the sanction plan permitted an STP to be set up. These two aspects are assumed significance for the reason that if either of them are answered in the negative, then it would have been required for the KSPCB to have initiated action as regard the concern. There being also issues of safety and danger to the to the building and the persons resident in the building. This court is of the opinion that these two issues, apart from any other incidental issues or violation of any other environmental laws, would have to be considered and report submitted by the concerned environmental officer and not seek to but what we get is impression is it's evading,
Please,
but we are not recording it now. But
please,
please convey it to them.
please.
Relist on 1st July
Great.
for the for KSPCB to make his stand clear.
31, Badrinath R.
FF for petitioner, yes. Petitioner is a society run by the petitioner. That for last 8 years, 9 years, there is no election for the society.
No election.
No election. Where now the society is run by the respondent number 3. With the finding recorded by the respondent number 2, there is a 2 groups are there. Let the authorities to be appointed by any one of the group to approach the management before the earlier occasion before this honorable court. I filed a writ petition.
How can you ask for an administrator to be appointed? You can go for a site.
Where
file a
administrator
suit.
were appointed in the year 23,
Huh.
but no action has been taken by the respondent number 1. Till that the matter has kept pending.
So now the administrator is running the.
No.
Who is running the institution?
Now is run by the respondent number 3. No administrator is appointed. Where in the year 25, the
Respondent number 3 is running.
SC is running.
Yes, madam. If administrator has been appointed in 20.
No administrator is appointed.
You said administrator.
Where administrator letter has been issued in the year 2024. As on that, there no action has been taken on that.
Then they're not required to appoint an administrator just because you ask for it.
Not by me itself, where the 2 groups are there. Petitioner as well as the respondent 3.
Correct.
Based on that, the respondent 1 has been issued a letter to the respondent number 2 to appoint an administrator to proceed in accordance with it. Thereafter, it could not be done.
Respondent number 1 has issued a letter.
Yes,
Not the petitioner.
Not
Where is that letter?
It's at page number 168.
168.
On 13/6/2024, the respondent regarding the appointment of the administrator, 27(1)(a) of the Society Registration Act.
For what reason? Why do they want to appoint?
There are 2 groups are between the.
There'll be always groups and multiple groups. So that doesn't mean that an administrator has to be appointed. If that becomes the reason, all societies, especially educational institutions.
But earlier occasion, the petition society was run by the Sri Anna. He had died in the year 2025.
You file a suit, Mr. Badrinath. It's a society. If you have a dispute amongst 2 groups, you have to file a suit. It's only a contractual matter. You can't involve the DR to appoint an administrator in a private society because one of the group doesn't like the other group.
Society is run by the third respondent.
Yeah,
Now he
file a
has
suit.
taken the position and he is running.
File a suit if you are aggrieved by it. Don't involve the government authorities in your private fight.
Where the government itself has stated that to appoint an administrator and to.
That cannot be done. Because the only reason which is stated is 2 groups are there.
Where the respondent number 3 is running without any.
File a suit if you are aggrieved by it. It's a society. A civil suit is maintainable.
This finding has given by the earlier occasion before the Honorable Court itself. Due to I had filed a writ appeal could not be prosecuted where it has been dismissed for non-passage.
Already you have come second
Sir,
time.
again, that is done by
There is a
which-
reference to that writ petition. No reference also.
Page number 160.
In your pleadings, there is no reference to that writ petition.
Yeah, it is there. Page number 8, it is there. Para number 10.
Petitioner is before this court seeking for the following reliefs. And you are representing the society as an authorized signatory. Yenappa. Petitioner is before this court seeking for the following reliefs. The petitioner in the present matter is a society represented by a member, and the relief which has been sought for is for implementation of the order Annexure M. Order dated 13/6/24 at Annexure L, and for quashing of the order dated 11/11/24 by which the documentation submitted by respondent number 3 was accepted. The contention of Sri Badrinath, Learned Counsel for the petitioner, is that from last 8 years there has been no elections which have been held to the society, and it is for that reason that a representation had been submitted for appointment of an administrator, which has been considered favorably via Annexure L dated 13/6/24, despite which the documents of appointment submitted by respondent number 3 has been accepted on 11/11/24. The petitioner had earlier approached this court in WP number 39380 of 2022, and a coordinate bench of this court, while its order dated 4th July 22 in ad, observed that as regards any dispute inter se between the members, it would always be available for the members to approach the appropriate authority or civil court with regard to the grievance relating to the constitution and management of the society, etc. The said order still holds force, despite which the present petition has been filed more or less for similar reliefs. This petition is also not maintainable for the very same reason, inasmuch as a society and the membership thereof being a creature of contract between the members, any dispute by the members can only be agitated before a court of competent jurisdiction. The official respondents cannot be involved in the personal disputes of the members, which have no bearing on the operation of the Society's Registration Act 1960. In that view of the matter, the above petition is dismissed, reserving liberty to the petitioner to approach the appropriate civil court. Though costs could be imposed, this court refrains from doing so.
Serial number 32. Manu Kulkarni.
Proceedings under the Senior Citizen Act. I am the daughter. My respectful submission is.
So Mutarna, you are appearing for respondent number 1 now. Yes, ma'am. TP Mutarna has entered appearance for respondent number 1. Delete Neo Shri KG Sadashiva has entered appearing for respondent number 1. Yes.
I am the daughter. My case is leaving aside the gift deed. That from 2011, when the gift deed was executed, up to 2022, my mother was staying with me. I was taking care of her. I was with her through surgeries. Thereafter, my lord's family partition issues cropped up. She took the side of the son. Thereafter, this petition comes to be filed.
Can we refer it to mediation?
Please, my lords.
My mediation is over, my lord. Mediation exercise is over now.
Over,
my lord.
I went. Mother did.
In this case, my lord, your lordship may kindly see the order passed.
Did you go for attend the mediation or you did not attend the
No, I
mediation?
did not attend because that mother, she is as it is, she was not well and she is 78 years old. And she requested that mediation that I am not unable to come. And she said that whatever this has filed, that has to be taken into consideration. Now, what happened, my lord, in this case, mother, she is the owner of a.
He is a petitioner, he will address arguments. But if the matter gets referred to mediation and you don't even go for mediation,
ಅವ್ರಿಗೆ ಬರ್ಲಿಕ್ಕೆ ಆಗಲಿಲ್ಲ ಅಂತ ಹೇಳಿ
ಬರೋದು ಬೇಡ, VCL ಮಾಡ್ಬೋದು.
ಅಲ್ಲಿ
We are
VCL
enabling
ಮಾಡ್ಬೇಕಲ್ಲ ಅವ್ರು.
mediation through video conferencing.
79, 80 ಎಲ್ಲಿ ಮೇಡಮ್
ಮಾತಾಡಕ್ ಬರಲ್ವಾ?
ಅಲ್ಲ ಮಾತಾಡ್ತಾರೆ.
ನಿಮ್ಗೆ instructions ಯಾರು ಕೊಟ್ಟಿದ್ದು?
ಅದ್ರಲ್ಲಿ ಫೆಸಿಲಿಟೀಸ್ ಇರ್ಬೇಕಲ್ಲ.
If somebody else is firing from our shoulders, it's not good. The Senior Citizen Act, today probably the largest number of litigation which are coming up before this court is under this act. Some of them right, some of them wrong, some of them abuse of the process. But if you don't even want to talk with your daughter or mediation, then it doesn't indicate.
They are not talking terms only. That is the problem now. See, because this has become very see. Now what happened, my lord, this case, I just.
He doesn't want to go, you argue.
Yes, ma'am.
Please. Therefore, my case, my lords, is really that it was once the partition angle came up, that this comes to be filed. Lords, on the same day, in respect of the same property, there are 3 floors. 1 floor each is assigned to one daughter.
Just take us through the gift deed.
Please, my lords. The gift deed,
Then
your
to the
lordship will.
complaint and then to the order.
Please, my lords. The gift deed, your lordship will kindly find at page 36.
36.
Please, my lords.
Yes.
It is dated 26/6/2012. Lords, the gift deed does not contain any explicit condition. Although, my lords, your lordship has held that.
Yes.
As a
What is the qualification of the mother? Is she
Lords,
a literate person?
she is literate, my lords.
Yes, signature appears to be so.
She is also a director in one company. She is a shareholder.
So she is worldly wise.
Please, and she is worldly wise, my lords, and also well-to-do.
Yes.
My lords, the second fact which may also be relevant, my lords, is that your lordship may kindly see, my lords, who are the witnesses. They are my 2 other sisters, because 2 other floors in the same building are given to 2 of my other sisters.
2 other gift deeds.
2 other gift deeds of the same day.
Contemporary. Same day.
Contemporary, my lords, and there is really no dispute
Page
about
number?
it. My lords, that if your lordship permits, I will file along with a memo. It's in the pleadings.
If
Even-
you file something, Mr.
Lords, they have not really disputed. It's in their pleadings.
It's in their field, then fine. You should not say I want time for that.
Lords, the
18
2 other gift deeds, my lords, are
Not same day, this is 1812, this is 6 months later.
lords. It's there at serial number 6 and 7, my lords. At page 19 and at page 30.
19.
19 to 29, my lords.
How many floors in the building?
3 floors, 1 floor to 1 daughter each. 3 daughters.
So you executed that as a consenting witness.
Please.
The other 2,
Please.
whoever got it, the other 2 executed.
Other
as
2
consenting.
were consenting witnesses.
Yes.
Then, my lords, as to
The son did not sign it?
lords,
You missed out your brother.
please. That's because, my lords, your lordship may kindly see document number 1. ವಿಶ್ವೇಶ್ವರಪುರದಲ್ಲಿ ಪ್ರಾಪರ್ಟಿ is gifted to the son.
ಅವ್ರದ್ದು ವಿಟ್ನೆಸ್ ಅಂತ ಮಾಡ್ಬಿಟ್ಟಿದ್ರೆ ಆಗಿರೋದಲ್ಲ.
Please, because bulk of the property is given to the son. 18/12/2023, the proceedings are filed before the assistant commissioner on 12/12. On 18/12, that is 6 days thereafter, a gift deed is executed. Here, my lords, both my sisters have once again signed as witnesses. Page 6. Because I asked for partition, if this property comes to be gifted in the favor of my brother. Because the thing is, as a daughter, that's all you will get. This property don't lay claim to.
This is self-acquired property of your mother.
Please note, my case is that it is.
And where is partition that you?
I filed a suit for partition subsequently.
In a self-acquired property.
Notes, my case is, this is not self-acquired property. Be that as it may, I am only submitting, my lords, that 5 days after filing the petition, this gift deed is executed. Both my sisters have signed. Gift is to my brother
Yes.
by the mother. This therefore, my lords, in my respectful submission, demonstrates prima facie that this was not a genuine bona fide proceeding instituted, but it was instituted because I asked for partition. Said, you're a girl, you want to ask for partition over and beyond what has been given to you, and then these proceedings come to be instituted. Now, my lords, your lordship may kindly see the petition. The petition, my lords, is at page 53.
Yes.
The averment, the relevant averment, my lords, perhaps from para 3. Petitioner brought up respondent in a luxurious manner and provided her good education. Respondent is married. Due to her wedlock, one daughter is born. She is abroad. Respondent leading a luxurious life and throwing the petitioner to the streets. This is the first allegation. Then para 4. Submitted that petitioner is the sole and absolute owner of the residential property bearing number so and so, situated at second floor.
Now, this building is a residential building or a commercial building?
Residential building, my lords. This is the same building, one floor each to each of the parties. Undivided share in the scheduled property that equivalent to 1900 square feet along with car parking area in the basement together with undivided share. Then, my lords, the rest of the 2 paragraphs are history of how it was acquired. Para 7 is the gift deed. It is submitted that the petitioner has executed the gift deed dated so and so, YD document number dated so and so, registered in the office of the entire second floor of residential house constructed on residential property bearing number so and so, measuring so and so, civic amenities with 1/3 right, basement together with 1/3 undivided right, 1900 square feet, share title, interest in terrace area of the
Who is
scheduled.
residing there?
Right now I have given it out on rent.
You're residing somewhere else.
I am residing, my lords, in para 8, what is mentioned in para 8. It is submitted that respondent is residing in the premises bearing number so and so, Ramayangar Road, BB-Puram. Idhar melene gift madi. Measuring east to west so and so, north to south so and so, where the respondent is running a school in the ground floor of the building, name and style Euro Kids on the first floor, she is residing. Respondent has deserted her husband. Therefore, the petitioner herein has provided to reside in the aforesaid premises and also to run the school since her daughter is
Who
also.
owns that premises, number 50?
Not my case is this is joint family property. Their case is it is their property. They have executed that gift deed. Since her daughter is also abroad and petitioner accompanied and residing with the respondent in the aforesaid premises. Admission, my lords, that initially she used to stay with me here, mother and daughter, for about 11 years. It is submitted that the said property is standing in the name of petitioner and her son Ashok are both joint owners in respect of the aforesaid property. Therefore, my lords, clearly it is either inspired by the son or mother is saying, I am taking the son's side. Submitted that petitioner's son was also residing in the said premises after his marriage. Relationship with daughter-in-law and petitioner are strained, separated, far away place from the aforesaid place. It's further submitted that petitioner another daughter got gifted property bearing number so and so, first floor. She is residing in the said premises, ground floor of the said premises. These are the 2 other gifts. Further submitted that the residential premises are not sufficient for the petitioner to accommodate to reside there. However, without there being any alternative, the petitioner residing with another daughter, B.S. Jayanti. Submitted that the respondent is very arrogant. She is ill-treated the petitioner after the death of the husband of the petitioner. He died on 2/5/2021. Thereafter, petitioner unable to sustain to lead peaceful life at the age of 72 years. Respondent always gives pics and scolding the petitioner, also ill-treated the petitioner. Respondent has been leading a luxurious life, whereas the respondent is totally neglected to maintain her and driven her to streets. Petitioner submits that she is very aged, suffering from severe knee
Yes,
pain.
how much are you willing to give as maintenance?
Lords, whatever your lordships direct, my lords,
Not for us to direct. If you say something and if there is a mismatch, then we'll get involved. It's for you to plan your finances.
20,000 per month I'll give, my lords. I'm getting some rent from the property. I have a daughter to take care of.
My lord,
A single mother.
before telling my lord that the petitioner is having a 14 residential apartments in Bangalore, all given it for rent. That is one. Number 2, my lord, this respondent, my lord.
ನಿಮ್ಗೆ ಎಷ್ಟು ಬೇಕು ಅವ್ರಿಗೆ ಹೇಳಿದ್ದಾಯ್ತು. How much do you want as maintenance?
How much, my lord?
How much money do you want as maintenance to maintain it?
Maintenance, no.
You can't, your only ground is that so also is not maintaining, therefore cancel the gift deed.
maintaining means not looking after her, because my lord, maintaining my lord, see, my lord, just my lord. 1995, that Vivipuram residence was purchased by respondent along with his son by taking loan from the Central Bank of India and other income. And they are staying together, a family, from 1995 onwards in Vivipuram.
Mr. Muthana, no court or nobody can direct love and affection by anybody. We can only direct them to make payment of some amounts to take care of your maintenance if you need it. Whether you need it or not, you are also wealthy and well off. If there is a particular amount that you are looking at, we can direct them to give that.
Under 23, I want that place, my lord, the very purpose of this is she wants to stay alone, separately. That is why, my lord, that is maintenance is not an issue, my lord, because now she is staying with.
You are not residing there. It's rented premises.
That is, they have given it for rented.
And both of you are not residing there. You are residing in a place where you claim that it belongs to you and your son jointly.
No, my lord. Now she is residing with another daughter in the same building.
In which building?
That's now 3 apartments. This, my lord, this Bhanashankari, she construct this. This is her own property. She constructed 3 flats, 1 for each. First floor, that second floor is the prisoner's place. First floor and third floor, other 2 daughters. Now she is staying in second floor, well, first floor with another daughter, and she is asking for that this petitioner's that place to stay there alone. That's all, because she is not staying that the second floor. That another daughter is that this is she wants to stay in this prisoner's place, because now, my lord, this house where she is staying, my lord, now she is staying there. Now this is also belongs to prisoner.
During your lifetime, you want to stay there. That's only your issue. You don't have a place to stay.
No place to stay.
So during your lifetime, you want to stay there.
Stay there.
Oh, yes. I'll take instructions. I don't think that should be a difficulty.
If that is the thing, it's a very simple solution.
Please.
My lord, even now that gift deed, it has been cancelled, my lord. It is nullified now. Now, my lord,
there is no clause for maintenance. What we have held in the other matter is when the person was not worldly wise, did not know what it is, drafted by the donee in those circumstances. Here you are a director of a company, you know everything.
No, it is not director, my. That is why this is owned by company. My lord, my application may kindly see, my lord.
They have produced here.
No, that is no only that company. That petitioner is also having share.
Maybe.
Respondent is having
Maria
175 shares.
Vijayalakshmi, director in what is the name of this company?
Serial number 17 and 18.
Venkatgiri Mansions
yes,
Private
my lord.
Limited.
Yes,
They have produced it. You are a director in a company, worldly wise. Your signature is also good. You know everything. You have executed 3 gifts and gift deeds on the same day to 3 of your daughters, separating the properties. All those things you have done. You can't be said to be a person who has been cheated. You want your dwelling house to be there during your lifetime. That could probably, they can look into it. If you want maintenance, they can look at it. At the most, the violation is not maintaining under 23. If they come forward to maintain, nothing is left. When they refuse to maintain, yes.
No, that is not that.
ಕಷ್ಟ ಆಗತ್ತೆ ನಿಮ್ಮ ಕ್ಲೈಂಟ್ಗೆ. You get proper instructions. We are not recording anything because if we record it, it will be a problem for both of you, especially for you. We'll have it on
16th.
16th. Released on 16th at 2:30 p.m.
Interim order may.
Some other XYZ.
ಯಾವ ಮ್ಯಾಟರ್ ತಗೊಂಡ್ಬೇಕು ಫಸ್ಟ್ 14123 or 251?
14,123.
14,120.
Yes, ma'am.
In which I am for the impleading applicant.
Impleading.
Impleading up.
Please plead. It was allowed.
Remove
And
the
is-
unauthorized shed.
Allotment is challenged in WP number 20375 of
33.1 ಕೊಡಿ.
My contention is that they have no locus standi to challenge my lord. because they are squatting on the property of the KDB, which is allotted to me marginal land.
So this is for mandamus. And 33, Chandrakant Patil, what have you filed for? 33.2,
33.2, my lord, I have seeking for allotment of the property, my lord, which is allotted to him. Prior to that, I have made application without
So
considering.
challenging his allotment.
Please. That is in WP number 20375, 33.3, my lord.
So we'll have to take 20375 first. If
Along
you,
with
if
14,
you succeed, then other things come about for them. If you fail, the other things come out for them. 20375. And 1166 is for?
1166 is for mandamus to allot the property.
That is if you succeed.
Please.
But in both your fight, Mr. Manoharan is enjoying the property. Yes.
Your lordship is taking first 1166 million.
20375.
20375. Please.
Adral
Please.
That is where you challenge the allotment.
Yes, I have challenged his allotment.
Yes.
And more number of documents are produced in 1166. 11, because Nandala, non-allotment.
With 6-7 petitions, if you have to go back and forth, kashta aagate. File a convenience set, we will consider it together. File a convenience set. But only if you succeed in 20375, the question of 1166 being taken up would be there. If you fail there, they get a right to agitate their right. If you succeed in these two, their rights are gone. So file a compilation of convenience set of all the documents.
Please.
Shri Chandrakant Patil submit that the documents that he wishes to rely upon are being filed in all the different petitions. Hence, he is directed to file a convenience set of all the documents and all the petitions that all the councils wish to rely on. Relist on 16 July.
Please.
Interim order, wherever granted, is extended till next date.
34, Deepak Kesar.
Freezing matter. Freezing matter.
So Deepak.
But in this case, my lord, we will place the order, my lord, if the
None appears for the petitioner, learned counsel.
Lordship, I am appearing for petitioner in 34.
34.
Yes, Lordship.
Yes, please. You have furnished the documents only now. Learned counsel for respond number 3 seeks for and is granted a week's time to place on record the communication received from the jurisdictional police authorities as regards the debit freezing of the account of the petitioner. Relist on 10th July.
Yes, much of.
10 July 2:30 idiyavalla?
10 July 2:30.
2:30.
35.
Lord, I appeal for the petitioner, my lord.
Yes. Yes.
The matter pertains to collection of the stamp duty twice, my lord. My lord, the petitioner, she purchases a flat for rupees 10 lakhs. The receipt and the possession certificate is produced at annexure A and B. Then the second respondent issues a notice saying that under the possession certificate, you are given possession of the property. Therefore, it requires registration. You have to get it registered and you have to pay the stamp duty as per 2 lakhs. That was the demand made by the annexure C. That was challenged by the petitioner in writ petition number at annexure D. Several petitions challenged. She was also one of the party there. It was challenged in annexure D. In annexure D, there were 2 prayers. One, only possession certificate is issued. Sale deed is not executed and registered. Therefore, at this stage, I need not go for registration. That was one of the contention which was negative. Second contention is even the demand made by the respondent by the annexure C is very excessive. The writ petitions were allowed partly, and the trial and this court in annexure D orders at page number, my lord, page number 79 and 80. It said that so far as the registration is concerned, you have to go and get it registered because possession is given to you via annexure B. Then so far as the stamp payment, payment of the stamp duty is concerned, it is not calculated properly. It is excessive. Therefore, rework out and recalculate it and issue a notice to the petitioner according to which he will let her pay the money. Then it was reworked out and an order was issued via annexure E. The order is at page number 80. 80 ನಲ್ಲಿ ನನಗೆ 64,000 plus this was heard, my lord, when your lordship.
Stamp duty was to be set off against the.
That is denoted. Denoting has been given.
Where's the calculation for this?
My lord, in fact, relying upon the judgment of your lordship, my lord, I think I have given it file ಇದ್ರೆ ಸರಿ ಇಲ್ಲ ನಾನು ಕೊಟ್ಟು. Lordship, may kindly see.
ನವೆಂಬರ್ ಆದ್ಮೇಲೆ ಇವತ್ತೇ ಲಿಸ್ಟ್ ಆಗ್ತಾ ಇದೆ.
ಅದು your lordship, I had heard this matter once. ಅಲ್ಲ ಜ್ಞಾಪಕ ಇಲ್ಲ ಸರಿ. October, the order was also dictated. Same case, similar case. ಅಲ್ಲಿ ಏನಾಗಿರುತ್ತೆ ಅಗ್ರಿಮೆಂಟ್ ಆಫ್ ಸೇಲ್ ಆಗಿರುತ್ತೆ. ಎಲ್ಲ ಅಮೌಂಟ್ ಕೊಟ್ಟು ಬಿಟ್ಟಿರ್ತಾರೆ. Then specific performance ಇದೆ ಅಲ್ಲ.
This is specific performance is different.
ಹೌದು ಅಲ್ಲ ಬಂದೆ ಅದ್ರಲ್ಲಿ ಏನ್ ಸಿಮಿಲಾರಿಟಿ ಇದೆ ಅಂತಂದ್ರೆ on the date of the agreement everything was paid, then it goes to the court. Court ಅಲ್ಲಿ 4-5 years the trial court original suit goes on, then it comes in appeal. Appeal ನಲ್ಲಿ ಕೂಡ ಒಂದು 4-5 ವರ್ಷ ಆಗುತ್ತೆ. Then he files an in the execution the vendor agrees for executing the sale deed. Then sale deed was presented for registration. Then the registering authority said he pay the stamp duty as on today. That was negatived by this court. Illa, when on the date of the agreement, whatever was the agreement amount that was paid on that day itself, therefore, in view of the litigation, some time has lapsed. Therefore, you need not pay the petitioner cannot be called upon to pay the stamp duty.
Current market value. It's on the current market value.
Current market value will insist ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂತ. That was the judgment. Now, here also what has happened was, after this I paid the duty, and that was also endorsed by them. Then I filed a case before the Joint Register of Cooperative Societies for execution of a sale deed. ನನಗೆ ಸೇಲ್ ಡೀಡ್ ಬೇಕು, ಬರೀ ಪೊಸಿಷನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇಟ್ಕೊಂಡ್ರೆ ಐ ಡೋಂಟ್ ಗೆಟ್ ಎ ಮಾರ್ಕೆಟಬಲ್ ಟೈಟಲ್. ನಾಳೆ ನಾನು ಸಾಲ ತಗೋಬೇಕಾ ಮಾರ್ಬೇಕಾದ್ರೆ ಆಗೋದಿಲ್ಲ. Therefore, I file a dispute before the Joint Register. Dispute ಆದಮೇಲೆ he allows my petition after hearing the other side also. They don't do it. Then I go to the civil court for execution of the decree passed by the Joint Register of Cooperative Societies. Then there also they contest, they don't execute the sale deed. Court officials, they come and register on behalf of the judge. The registrar of the court comes and executes. Then I present the document, the court sale deed for registration. They accept the document for registration. Then they impound it suddenly. Then they don't give back the sale deed to me. They impound it and say you have to pay 1 lakh in addition. Only then we will release the document.
As per the current market.
Under protest, I have paid that amount. Then I went and appeal before the second respondent. He negatives my contention. I have already paid as per your own order 74,100 rupees as per your demand pursuant to the orders of the writ petition. Therefore, I need not pay when this court sale deed has been executed by the court. That was negative. Then I carry that and appeal before the third respondent. He also doesn't accept my. Therefore, I am before the court saying that I have already, in pursuant to the orders of the respondent themselves.
The case is very simple.
Very simple.
They entered into an agreement.
Two things. The difference, my lord, we'll have to distinct between a possession certificate and an agreement. Now, my lord, the society was not a developer. The society formulates a scheme. It's a housing scheme, which was not approved and it was not there as in the Stamp Act in Karnataka at that point in time. This relates to the Datta Prasad House Building Cooperative Society. Too much of water has flown in this matter. What had happened was, my lord, they would make several members. Then they develop a building, and every member is allotted certain amount of shares. In lieu of those shares, he is given a possession certificate. According to them, that scheme was not formulated in Bangalore much of time. It is prevalent in other.
As regards a constructed area.
It's a constructed
share
area.
Certificate.
Constructed building.
Share certificate. Towards that share certificate, they give them a possession certificate. Now, what had happened is the issue, what my learned friend is not telling is, they found it difficult to get the revenue entries mutated based on a possession certificate, for which there should be a conveyance deed. Now, my lord, what had happened is they went and applied for the regularization of the possession certificate. Now, my lord, at that point in time, certain amount of stamp duty was collected. Now, my lord, they did not have a sale transaction in their favor. A conveyance does not be executed under Article 20. Now, what they do is they go to the before the
Only the sale, share certificate
Yes.
with possession.
Yes.
That matter.
Possession
File your
certificate was-
objections. We'll have to consider it. indeed.
Yes, sir. Now, only two things, my lord, before I conclude. One thing is, my lord, if your lordship would kindly see in the definition of the Stamp Act.
File
2B.
your objections, we'll hear
I
you.
will-
Because this issue is not covered by our other, because
yes,
it is
yes.
different. Learned AGA 6 point is granted 2 weeks time, file a statement of objections if any, by 10th June, failing which will be taken as not filed, matter proceeded with, relist on 17th June.
Serial number 36. Nagabhushan IS.
Yes,
For
Vinay.
the petitioner file writ of mandamus, my lord, given a representation. Request for NOC from the respondent 2 and 3, my lord. They are not issued, my lord. Therefore, I filed.
What is your representation for?
Annexure
Page
page number
18.
30, my lord.
Annexure E, page 30.
Please, my lord.
What do you want in this?
NOC from the R for conversion, my lord.
My lord, NOC cannot be given, my lord. Let them consider the representation, my lord. Please. Because if it is a forest land, my lord, then.
Laurene
Pass an
joint
order.
survey report
It is
is
3/125, 1.5 years. You could have passed the order by now.
joint survey
Directions,
report is
Petitioner is
not
before
a
this court
forest
seeking for the following reliefs. The grievance of the petitioner is that the representation dated 3/125 as per Annexure E for issuance of a no objection certificate for alienation of the subject property has not been issued by respondent number
2 and 3.
2 and 3. Though learned AGA submits that no such NOC can be issued, and since the land is a forest land, the fact remains that a representation has been submitted on 3/125, no orders have been passed thereon. If at all, the submission, if at all it's forest land, necessary orders would have had to have been passed by respondents indicating that to be so as to provide a recourse to the petitioner to challenge the same if deemed fit and advised.
Please.
Since no order has been passed on the representation date 3/125, the avenues available to the petitioner have been blocked. As such, this court passes the following order. Writ petitions allowed, a mandamus is issued directing respondents to consider the representation dated 3/125 at Annexure E and pass necessary orders within 4 weeks from the date of receipt of a copy of this order.
One
It's clear
submission.
that this court has not expressed any opinion on the entitlement of the petitioner. The same would have to be decided on in terms of the applicable law.
3/125 representation is not given by the petitioner, my lord.
Who has given it?
It is
Lakshmi is a petitioner.
by one Mahesh, my lord.
My lord, page number 30, Annexure E, my lord.
He
Given by
is given by
Lakshmi, my
the
lord.
petitioner, my lord. That may be considered.
Next
30.
annexure ನೋಡ್ತಾ ಇದ್ದೀನಿ.
30 Lakshmi,
30
31 Mahesh.
31 is a Mahesh is a ankle, my lord.
ಇದೆ ಲಕ್ಷ್ಮಿ ಇದೆ.
Obliged.
Serial number 37. Yes, Mr. Bhatti.
Withdrawal
ಲಿಬರ್ಟಿ ಮೇ ಬಿ ರಿಸರ್ವ್ ಮಾಡೋದು
ಏನ್ ಲಿಬರ್ಟಿ ಬೇಕು?
ಇವನ್ ಸ್ಟೇ ಇದ್ರು ಸಹ ಅವರು ಟೆಂಡರ್ ಪ್ರೊಸೀಡ್ ಆಗಿದ್ದಾರೆ ಮಲೋಡ್ ಅದಕ್ಕೋಸ್ಕರ ಲೀಗಲ್ ಆಕ್ಷನ್
Different cause of
ತಗೊಳಕ್ಕೋಸ್ಕರ
action. That's a different cause of action.
ದ ಲಿಬರ್ಟಿ ಮೇ ಬಿ ರಿಸರ್ವ್ ಮಾಡೋದು ಕೊಡ್ತೀನಿ ಸರ್.
Petitioner is before this court seeking for the following reliefs. A memo for withdrawal dated 24/6/24 signed by the petitioner, director of the petitioner and the counsel for the petitioner has been filed, which reads as under. Accepting said memo and submission of the counsel for the petitioner, petitioner is dismissed as withdrawn, reserving liberty to the petitioner to challenge the subsequent actions taken by the respondent.
38.
My lords, 38, I beg to appear for the petitioner, my lords.
Yes.
My lords, writ of mandamus, it's a covered matter, my lords.
My lord, for respondent bank, my lord, copy is also not served upon us.
Copy not served.
Copy has been served, my lords. I filed a memo of compliance, my lords.
To the bank.
To the bank counsel, my lords. Mr. Vignesh Shetty was directed to accept notice, my lords. Copy was served on 27th of February, my lords. I filed a memo, my lords.
Not received, my lord.
He served, you are saying, copy service, why should there be a problem? Okay, send her one soft copy.
I will do that, my lords. My lords, if they are, my lords, appearing for the RBI, notice was dispensed last time because the contesting respondent is only respondent number one, which is Canara Bank.
RBI is not required.
RBI is not a please, my lords. In fact, I've also filed a memo.
Counsel for the petitioner is directed to furnish one more set of the petition along with annexes on the counsel for respondent, who is directed to place the orders received by the respondent from the concerned police authorities as regards what, debit freezing? No, this is not debit
No,
freezing.
this is not debit freezing, my lords. Not police.
Erroneous debit.
This is the debit where, my lords, their bank is debited charges for non-utilization of certain account, my lords. It is a covered matter. On 27th October, the matter was before your lordship. The proprietary concern of the very same petitioner, my lords, the bank came and told that they will consider the
In
representation.
which matter is it covered? What is the order? The
My lords,
writ
I have
petition.
filed a memo. I have filed a memo on 27th of January, my lords.
27 January. Memo idea? Yes, 27 January.
My lords, it's your lordship's order, my lords, of 20th October 2025. The bank, my lords, Mr. Vignesh Shetty appeared and undertook that they will consider the representation, and on that basis, my lords, the report came to be disposed of.
So you want the same order?
Similar order may be passed, my lords. Your lordships may kindly see para 2 and 3 at page 4, my lords.
My lord,
Why waste paper? Same petition. One reached, one did not reach.
we don't have any
Any
instructions.
soft
from-
copy you send it.
I will send it across, my lords.
Petitioner is before this court seeking for the following leaves. Submission of learned counsel for the petitioner is that the above matter is covered by the decision dated 28th October 2025 in WP number 25945 of 2025.
942, my lords. My apologies. 942.
25942 of 2025.
Please, my lords.
And that though there are several reliefs which have been sought for in the present petition, the respondent, the petitioner would be, petitioner's interest would be safeguarded if the representation dated, what is the date in this matter?
My lords, 11/7/2025.
Same
At annexure M, 11/7/2025.
11/7/20. Where is 11/7?
Annexure M, my lords, page 90. In the petition, my lords.
90.
Yes, my lords.
Petitioner's representation to the respondent bank dated 11/7/25 at annexure M is considered by respondent number 1. His submission is that the said representation has been submitted. No orders have been passed. In that view of the matter, being of the opinion that whenever any representation is submitted to a bank, it is required for the bank to consider the same and pass necessary orders, either accepting the representation or rejecting the same within a reasonable period of time. Needless to say, if an order of rejection were to be passed, such order would have to be accompanied by reasons. This court passes the following order. Writ petitions allowed. The relief sought for are molded. The respondent number 1 is directed to consider the representation dated 11/7/2025 at annexure M and pass necessary orders within 4 weeks from the date of receipt of a copy of this order.
My lords, I may be given the liberty to challenge that decision, my lords, if I'm agreed, my
That
lords.
is a different cause of action. Once they pass the order, you can always challenge.
Please, my lords, I bow down, my lords. Please, my lords, grateful, my lords.
It is more likely that you will have to challenge. You can challenge it at that time.
Please, my lords. Please.
Yes.
Serial number 39, Arvind Patil.
Lords, appearing for the petition in this matter. Lords, just a brief background of this matter, if I can give it.
Ready, madam?
Your lordships, one submission. The prayer against R5 is to affect the Kata, your lordships. R5 is the executive officer. It is the PD of certain Gram Panchayats who has the power to affect Kata.
PDO is not made a party.
PDO is not made a party in both the petitions, your lordships. Chunchankappe village, PDOs, is supposed to be made a party.
Janpura Gram Panchayat, it comes, my lords, if I have seen that. Submit that these two endorsements are quashed, my lords. Rest will follow.
Issued by first respondent, third
Lords,
respondent.
A, B, C, D is important. If the registration takes place, my lord, then automatically, because the Kusutakinta Munche Kulavi also, registration agilla Kata Piella Madak.
So Your submission is only as regards prayer E.
Prayer E,
Yes,
Your
prayer
Lordships.
E, my lords. If
Prayer E.
ABCD is
Prayer
not considered, it will
ABCD.
not remain.
Please, please.
Only if he passes the test for
Test for
ABCD,
ABCD, then I will succeed.
then he'll go to E. Yes.
Lords, various properties.
So, one nimsha, A, B, C, C
D.
is being passed by respondent number 1
Yes.
state, 2, D is by respondent state, 3 is also respondent state. Yes. Jafar, ready?
Yes. Lord, I'll file my statement of objections in this matter, my lord.
You
For
filed
one
or you
submission-
want to file?
No, we'll file, my lord. We have secured the instructions, 2 weeks time will be granted. I will file.
Yes,
Either
you
way,
have
my
to
lord,
defend
against the
this.
refusal, my lord, as per the new amendment, my lord, it's an appealable order.
That's, there is no order at all, my lords. I'll just demonstrate there is no order at all.
Refusal, any
My
refusal
lord, this
under
is something which has been dealt with by the coordinate benches in at least 3 judgments. I'll point out, my lords, what's the problem in this matter?
Already
Why
dealt
the
with, why
government?
do you want to file
My lords,
objection?
100-year-old, lords, the lands in particular villages were all declared as Inam lands because it was in Barabalati registers, quit rent registers. After the Inams were abolished, applications filed under the Inams Abolition Act. Re-grant orders were made right from 1952, 53 and onwards. Re-grant orders are made. Then multiple transaction takes place. In some cases, there are up to 20 sale deeds. In some cases, there are about 6 to 7 sale deeds in respect of various survey numbers of these villages. That's when these lands now comes within the urban agglomeration. Properties are purchased by the societies. There's the cooperative societies. Then they form the layout. They form the layout of the properties which is re-granted, and then there are multiple transactions. Conversion takes place. We go to the local planning authority. Local planning authority also sanctions the plan. Sites are released. Then, after some portions of the sites were already released, this religious and endowment commissioner says that now I have found out that in 1939, these properties were belonging to one so and so Radhabai Dwarka Vedantam. They executed a registered gift deed in favor of these temples for certain purposes. Therefore, the property belongs to Mujrai. He directs the IGR saying that direct all the sub-registrars not to register any properties coming within the purview of these 5 villages. This is the letter. IGR acts on the letter. Says, no, don't register any of the sites which are formed in this.
5 villages.
Yes, five villages. Then we come before this honorable court at the first instance. That is at Annexure G, page 42. That's what I now said, my lords, 2 letters is also subject matter of challenge. Page 42.
Yes.
Para 10, my lords, at page 48.
This is one other site owner.
Yes. Lord, this was for the releasing order, my lords. They, because of these letters being circulated like pamphlets to all the authorities, they said that no, we will not release the further sites. So that was the first round of litigation. In pursuance of the occupancy rights granted, the name of the vendor was entered in the revenue records and the land was converted for residential purposes, section 95 of the Karnataka Land Revenue Act. Petitioners purchased the land from the grantee by virtue of the registered sale deeds. Respondent is claiming over the subject land by virtue of a gift deed of 1939. However, the occupancy rights of the subject land were granted in favor of the vendor under the provisions of the Mysore Personal and Miscellaneous Inams Abolition Act. Rights which were alleged to have existed in favor of the respondent prior to commencement of 54 Act automatically stood extinguished after the land vested in the government free from encumbrances, and also other occupancy rights granted in favor of the Inam Darsa tenants. The order granting occupancy rights is attained finality and binding on the respondent number 1. Hence, the impugned endorsement issued by respondent number refusing to issue NOC for release of 40% of the sites to respondent number 3 is one without authority of law, and therefore, though there is no requirement of obtaining NOC by petition number 1, impugned endorsement is set aside, directed to release the sites.
NOC from respondent number 1.
Respondent number 1 is this, yes, religious and charitable endowments commissioners.
So that was the first stage.
First case.
Get NOC.
Yes, go and
Now
get
it is
NOC.
don't register.
Yes. Then they started, NOC is given, then the sites are released, then starts this IGR's problem. IGR says don't register any property. Then page number 50, 50. Lordships may kindly see after extracting the orders, some
57. Yes.
Lords, the quashing certain endorsements are against the petition submits a representation, the representation seeks implementation of the order dated so and so, which reads as final. To say the least, the reasons rendered by the officer is preposterous. The order that is passed on so and so, unless state or set aside the writ that is granted would run till such time as observed here and above. An officer cannot declare that it has not become final merely because the government is preparing a writ appeal against the order. Therefore, the act of the respondent not complying the order fringes on the border of contempt. Then a mandamus is issued saying that you register the documents. Then next round, page number 61. Can I just now, Lords may kindly have a look at page number 67.
This was delay in issuing the NOC.
Yes. Now, Lords, the second writ petition is relating to the registrations because IGR says don't register. Then page 67, para 3. So and so submitted that on the last date, the state is preparing a writ appeal right from the date of the order 25/8/22 submits that state is still in the preparation of such appeal to be filed despite 18 months having passed. Court has also observed that the state fringes on the borders of contempt. State government wanting to prepare the writ appeal would not mean the directions is to be eclipsed or extinguished. Therefore, they are neither eclipsed nor extinguished as of today. Therefore, I deem it proper to grant the relief.
So
Then
each,
impugned order is endorsed.
Each site owner has been coming before
But
this.
now we are forced to do this because what is covered is 1,300 acres. 39 gift deed is what they are referring to, Milords. Milords, more than the value of the site owners will have to spend on the value of the on the litigations now. Milords, it is not one single litigation.
That's a compliment for you.
No, that's compliment, Milords. I accept
That
it.
if they have to engage my learned friend, then probably yes.
No, that's a compliment for
No,
yourself.
that
We have
is
no problem.
definitely a compliment. Milords, now,
No, my lord,
3 rounds.
39, it's already, there's an order passed by so many coordinate benches.
Well, one of the
Still, you are judge, you're the executioner.
one of the coordinate benches, my lord, I have the order. There's a similar batch matters where the site owners had come. There, my lord, the bench, the honorable court has held and laid down certain rules that we have to approach the site owners have to approach the deputy commissioner to get the clarification, and then they can.
Give us that order.
Well, just before that, can I just, what happened, even before this happened, I'll just read that endorsement for your lordship's consideration. On the basis of this letter, they initiated proceedings under the Land Grabbing Act. Then we challenged those proceedings before the division bench. It's particular to our cases, that is these villages.
What happened? Writ appeal was finally filed or not filed?
No, even
Till-
today, as I
till
stand
down,
before lordships,
no
no,
writ
it is not.
No, my lord, there are other two petitions that are pending before the coordinate benches, my lord. And where we have a similar question is.
We are not saying
Can I-
every judgment passed is correct, Judge.
There is a division
You-
bench judgment,
You have to
my
file an
lords.
appeal. 23 judgment, 22 judgment, you are still not filed the appeal. You are going on telling before all the benches that we are in the process of drafting the appeal. It's been in no uncertain terms, the coordinate benches have observed that you can't be saying that. Today also you are saying you still not filed an appeal. So
Lords,
that
can I-
order, after 4 years, do you have a different law for the state?
My lord, I will secure instructions as
Lords,
to
can
what
I
is the
just-
federal-
Instructions are there. There is an order which you have not filed an appeal. You're still in the process of filing an appeal.
Lords, can I just say this, Milords? This very issue came up for consideration before the division bench, which considered the validity of this Land Grabbing Act and also the proceedings initiated in the first stage. Para 170 and onwards is pertaining to this village.
This village.
May I just pass it on, Milords? Para 170 onwards.
Yes.
Writ petition ಅಲ್ಲ?
So without jurisdiction.
Yes.
That is why you have not filed the appeal. Division bench has held this.
That is with regard
You
to
can't
the land
overcome
grabbing.
this
Manoj.
also.
That is for the land grabbing one,
Then-
because I don't have a copy.
Please.
We had challenged the provisions of the land grabbing.
Now, can I request, Milords, there is a report which was generated by the Tehsildar, which is at page number 33 in this papers, Milords, 25. Because the Deputy Commissioner said, you please give a report, what is the status of these properties as per the revenue records.
Yes.
Then Lords may kindly see at page number 34. ಪೆದ್ದನಪಾಳ್ಯ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 7ರಿಂದ 11ವರೆಗಿನ ಜಮೀನುಗಳು ಕೈಬರಹ ಪಾಣಿ 60-70ರ ಸಾಲಿನಿಂದ 2000-2001ನೇ ಸಾಲಿನವರೆಗೂ ಕಲಮ 9ರಲ್ಲಿ ರಂಗನಾಥ ಸ್ವಾಮಿ ದೇವರ ಇನಾಮತಿ ಎಂಬುದಾಗಿ ನಮೂದಾಗಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಸದರಿ ಜಮೀನುಗಳು ರಂಗನಾಥ ಸ್ವಾಮಿ ದೇವರ ಇನಾಮತಿ ಹೆಸರಿನಲ್ಲಿ ಮುಂದುವರಿದಿರುತ್ತದೆ. ಈ ಕೆಳಕಂಡ ಮಂಜೂರಿದಾರರು ಖಾತೆದಾರರ ಹೆಸರುಗಳಲ್ಲಿ ಸ್ಪೆಷಲ್ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಫಾರ್ ಇನಾಮ್ ಅಬಾಲಿಷನ್ ಅವರು ಹಾಗೂ ಭೂ ನ್ಯಾಯ ಮಂಡಳಿ ಇನಾಮ್ ಅಬಾಲಿಷನ್ ಕಾಯ್ದೆ, ಕರ್ನಾಟಕ ಭೂ ಸುಧಾರಣೆ ಕಾಯ್ದೆ ಅಡಿಯಲ್ಲಿ ಆಯಾ ಅಧಿಭೋಗದಾರರು ಗೇಣಿದಾರರ ರೈತರ ಹೆಸರುಗಳಿಗೆ ಪ್ರಶ್ನಿತ ಜಮೀನುಗಳು ಅಧಿಭೋಗದಾರಿಕೆ ಹಾಗೂ ಗೇಣಿ ಹಕ್ಕನ್ನು ಕಿಮ್ಮತ್ತು ಪ್ರೀಮಿಯಂ ಹಣ ಸರ್ಕಾರಕ್ಕೆ ಕಟ್ಟಿಸಿಕೊಂಡು ಈ ಕಾಯ್ದೆ ಅಡಿಯಲ್ಲಿ ಯಾವುದೇ ನಿಗದಿತ ನಮೂನೆ ನಿಗದಿಪಡಿಸದೇ ಇರುವುದರಿಂದ ಈ ಕೆಳಕಂಡ ಆದೇಶಗಳನ್ವಯ ಸರ್ವೆ ನಂಬರ್ಗಳ ಜಮೀನು ಮಂಜೂರು ಮಾಡಲಾಗಿದೆ. ಹಾಲಿ ಸದರಿ ಸರ್ವೆ ನಂಬರ್ ಜಮೀನುಗಳು ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ 95-2ರಲ್ಲಿ ವ್ಯವಸಾಯೇತರ ವಾಸದ ಉದ್ದೇಶಕ್ಕೆ ಭೂ ಪರಿವರ್ತನೆ ಆಗಿರುತ್ತದೆ. Then your lords may kindly turn to page number 40. After the tabulated ಈ ಮೇಲ್ಕಂಡ ಪ್ರಸ್ತಾವಿತ ಜಮೀನುಗಳ ವಿಚಾರವಾಗಿ ಹೇಮಂತ್ ರಾಜ್ ಎಂಬುವರು ಮೇಲ್ಕಂಡ ವಿಧಿಬದ್ಧ ನಿಯಮಬದ್ಧ ಕ್ರಮಗಳನ್ನು ವಿಚಾರಣೆ ಲ್ಯಾಂಡ್ ಗ್ರಾಬಿಂಗ್ ಆಕ್ಟ್ ಅಡಿ ರಚಿಸಿರುವ ವಿಶೇಷ ನ್ಯಾಯಾಲಯದ ಪೆದ್ದನಪಾಳ್ಯ ಗ್ರಾಮದ ಜಮೀನುಗಳು 114 ಗೇಣಿದಾರರು ಹಾಗೂ ಎಂಡೋಮೆಂಟ್ ಕಮಿಷನರ್ ಪ್ರತಿವಾದಿಗಳನ್ನಾಗಿ ಮಾಡಿ ಅರ್ಜಿ ದಾಖಲಿಸಿರುತ್ತಾರೆ. ಈ ಅರ್ಜಿಯ ಬಗ್ಗೆ ವಿಶೇಷ ನ್ಯಾಯಾಲಯ ಎಂಡೋಮೆಂಟ್ ಕಮಿಷನರ್ ಅವರಿಗೆ ವಿವರವಾದ ವರದಿಯನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಲು ಸೂಚಿಸಿರುತ್ತಾರೆ. ಹೇಮಂತ್ ರಾಜ್ ಅವರ ಅರ್ಜಿಯಂತೆ ಬಾಧಿತರಾದ ಪೆದ್ದನಪಾಳ್ಯ ಗ್ರಾಮದ ಫಲಾನುಭವಿಗಳು ವಿಶೇಷ ನ್ಯಾಯಾಲಯದ ನಡವಳಿಕೆಗಳನ್ನು ಔಚಿತ್ಯ ನ್ಯಾಯಬದ್ಧತೆ ಹಾಗೂ ಸಿಂಧುತ್ವವನ್ನು ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ ಅವರನ್ನು ಪ್ರತಿವಾದಿಯಾಗಿ ಪ್ರಶ್ನಿಸಿದ್ದು ವಿಚಾರಣೆ ನಡೆದು ಘನ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಒಂದು ತೀರ್ಪು ನೀಡಿ ಹೇಮಂತ್ ರಾಜ್ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಿದ ಅರ್ಜಿ ರದ್ದುಗೊಳಿಸಿ ಕರ್ನಾಟಕ ಸುಧಾರಣೆ ಕಾಯ್ದೆ ಭೂ ನ್ಯಾಯ ಮಂಡಳಿ ಗೇಣಿದಾರ ಅಧಿಭೋಗದಾರಿಕೆ ಪತ್ರವನ್ನು ವಿತರಿಸಿದ್ದು ಜಮೀನುಗಳು ಕ್ರಯ ವಿಕ್ರಯ ನಡೆದು ಭೂ ಪರಿವರ್ತನೆಯಾಗಿ ನಿವೇಶನ ರಚನೆ ಅನುಮೋದಿತ ಬಡಾವಣೆಗಳಾಗಿರುವುದರಿಂದಲೂ ಹಾಗೂ ಮೈಸೂರು ಪರ್ಸನಲ್ ಅಂಡ್ ಮಿಸ್ಲೇನಿಯಸ್ ಇನಾಮ್ಸ್ ಎಂಡೋಮೆಂಟ್ ಕಮಿಷನರ್ ಅವರು ಮಾಡಿಕೊಟ್ಟಿರುವ ಗಿಫ್ಟ್ ಡೀಡ್ ನ ಎಲ್ಲಾ ಅಂಶಗಳು ಸ್ವಯಂ ಚಾಲಿತ ಮೆಕ್ಯಾನಿಕಲಿ ನಶಿಸಿ ಹೋಗಿರುವುದಾಗಿ ಎಕ್ಸ್ಟಿಂಗ್ವಿಶ್ ತೀರ್ಮಾನ ತೆಗೆದುಕೊಂಡಿದ್ದು ಹೈಕೋರ್ಟ್ ಆದೇಶ ಮಾಡಿರುವುದರಿಂದ ಈ ಗಿಫ್ಟ್ ಡೀಡ್ಗೆ ಯಾವುದೇ ಕಾನೂನು ಮೌಲ್ಯ ಇರುವುದಿಲ್ಲ. ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಪ್ರಕರಣ ದಿನಾಂಕ 16ರಂದು ಅಂತಿಮ ಆದೇಶಕ್ಕೆ ಮಾಡಿರುತ್ತದೆ. ಪ್ರಕರಣದ ಆಯುಕ್ತರು ಧರ್ಮದತ್ತಿ ಇಲಾಖೆಯವರು ಪೆದ್ದನಪಾಳ್ಯ ಗ್ರಾಮದ ಜಮೀನುಗಳಲ್ಲಿ ಸರ್ವೆ ಕಾರ್ಯ ನಡೆಸಲು ಹಾಗೂ ಅನುಭವದಾರರ ಒಕ್ಕಲೆಬ್ಬಿಸಲು ನೀಡಿರುವ ನೋಟಿಸ್ಗಳಿಗೆ ಯಾವುದೇ ಬೆಂಬಲಿತ ದಾಖಲಾತಿಗಳು ಇರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ everything they are aware. That writ appeal is not challenged by the state government. I'm sorry, that writ petition, there is no challenge by the state government to the Supreme Court. Just letter communications.
No, this was the internal
What is
communication
will
which
say-
is not given to him. This is an internal communication. What the deputy commissioner got the report. It says even in 2021, the name of the temple was there. Now, my lord, now this matter is seized before the coordinate bench. There are three different benches which are hearing this matter. My lord. The same issue.
Parted matters?
The parted matter, one is before code number 6, my lord. That is WP number 2162.
This issue is seized by another bench, it will have to go before that.
The other bench.
Lords, I can say
Parted
so
matter-
without any fear of contradiction, the matter pertaining to this, because we are in the 4th round of litigation, in the manner in which I have now submitted.
What is the matter seized up by coordinate?
I have
Coordinate bench is
absolutely no
seized.
idea, my lords. They will have to give me the,
we should-
at least if they give the numbers, I will ascertain what is
WP
that
number
matter about.
2162, my lord.
Lords, so far as this, so far as WP 26744 is concerned, not the land with which we are concerned is Chunchankuppe village.
Not just the land.
No, Chunchankuppe is not in these 5 villages.
But Chunchankuppe, well, but the entire claim of the endowment commissioner is that
Lords,
this land belongs to the Telangana.
You don't
Page
know what
26 villages are
other
there.
court
Pyalalu,
was seized of.
Cholnaik,
We'll have to go by what
Whatever the
you
Veda-
make your
Veda-
submissions on that.
Vedantam.
But if the coordinate bench is seized of the matter and it's considering it, then we'll
Yes, my
stay
lord.
our
It
hand.
is
It has
WP
to be
number
considered by.
2162 of 2025. my lord.
Lords, let him give the number, I'll ascertain if it is something
Ascertain, eh?
similar.
Very well, my lord.
But from what Mr. Ravi Shankar says and what is there in the division bench's order,
Yes, sir.
this you are creating a lot of litigation. If 1,300 acres, 1 acre ಅಲ್ಲಿ 30 site 20-30 site ಅಂದ್ರೆ, you are creating litigation of.
No, it is not only sites, my lord, but there are other thing. My learned friend has mentioned that is the entire area of the village. Maybe
They're
that
creating
that-
10,000 litigation minimum.
Maybe,
Minimum. Why do you want to create 10,000 litigation? To lose in all 10,000, you have lost so many already.
And also my learned friend is a winner. He has complimented himself.
And the division bench has clearly observed for entire 279 acres.
Yes.
This
Please,
order
my
is
lord, I'll give the
final
list
and
of the other
binding.
matters. my lord. I'll give the list of the matters that are pending pertaining to the same.
I'll
thing,
just
my lord.
take that list. Lords may have this
And
matter next
AG
week.
One more submission, my lord. The
Indian.
PDO is, I'm appearing for the fifth
Ado prayer
respondent.
E, your colleague has made the submission. We are on prayer A, B, C, D, then E.
Otherwise also,
We will reject prayer E at the most. A, B, C, D, he can
Is
continue.
yet to take place.
he's ready. Sorry.
In release one sati ಆಯ್ತು.
ರಿಲೀಸ್ ಒಂದು ಆರ್ಡರ್ ಅಲ್ಲ NOC ಫಸ್ಟ್ ಆಮೇಲೆ ರಿಲೀಸ್ ರಿಲೀಸ್ ಮಾಡಿಲ್ಲ ಅಂತ ಒಂದ್ ಮ್ಯಾಂಡಮಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿ ಅಂತ ಒಂದ್ ಮ್ಯಾಂಡಮಸ್ ಇವಾಗ ನಮ್ಗೆ
Only after registration J slip ಒಂದು ಇನ್ನ ಬಹಳ ಇದೆ.
Even my lord, it's not fair on my part. Otherwise, ಅವತ್ತೇ ಹೇಳಿಲ್ಲ ಅಂತ ಮತ್ತೆ ಶುರು ಮಾಡಬಾರ್ದಲ್ಲ ಸುಮ್ಮನೆ ಅದಕ್ಕೋಸ್ಕರ.
Learned AG, learned counsel for respond number 5 submit that insofar as prayer number E is concerned, it is the PDO who is the necessary party. Since he has not been made a party to these proceedings, the above petition would not be maintainable insofar as prayer E is concerned. His submission is placed on record. Learned AG has submitted that the coordinate benches are seized of other similar matters. A list thereof has been provided to the counsel for the petitioner, who seeks for and is granted 10 days time to verify and make his submission. Since if coordinate benches are seized of similar matters, this matter would also have to be heard by the coordinate bench.
Grateful.
Relist on
Monday,
16th. Monday ಒಳಗೆ ಮಾಡ್ತೀರಾ?
ಅಲ್ಲ ಮಂಡೇ ಮಿಲಾಟ್ಸ್ matters milots it appears are parted by Justice M.I. Arun.
So it will have to go there. If
Certain milots, your lords may have this matter on Monday so that I'll make a mention as to whether these are all.
if those matters are listed on Monday.
Monday before the.
Then if that is there, then you can make a mention there on that day. That
Make a mention there.
connect these
Connect
matters.
this matter.
That's all. We'll give a date in this matter for 7th July.
Thoughts, sir.
If it's connected, it will go there.
Please.
Grateful.
Serial number 40.
Yes.
Short accommodation in this matter, my lord.
Petitioner, my lord.
To file an affidavit of the SP. Next week it may be posted, my lord.
Serious allegations.
Yes, ma'am. Next week.
That the AGA seeks for and is granted 10 days time to file his affidavit, relist on 2nd July.
Serial
It's
number
made
40.
clear that no further adjournment would be granted.
My lord, I appear for the petitioner.
I appear for the, these objections are ready, my lords. I just need a day's time to get the signatures. A day's accommodation. my lords.
List is put up, so when getting it listed is a problem for them. So
No,
you
no,
should
it can be
not
listed on Monday.
take
I'll have it
adjournment.
filed by then.
But we'll give a date of 16 July, unfortunately for them also.
I'll file it by Monday.
So that counsel for respond number 2 seeks for a day's time to file a statement of objection.
My lord, may I request?
Directed, he is permitted to file the same by 29th June after serving a copy thereof on the counsel for the petitioner. Relist on 16th July.
May I make one request, my lord? Let them not take any precipitative action to procure that product from anybody else. It's a product that we have been tendered.
Tender matters are time sensitive.
Monday accommodation.
I relist on 1st July.
Grateful, my lords.
Obliged.
42. Anusha Ganeshan.
Lord, appearing for the petitioners, my lord.
Yes.
There was a subvention scheme, my lords.
Subvention scheme.
Yes, my lords. Lords, the possession was supposed to be done in 2018, my lords. I've been paying EMIs.
There's no stay order?
No, my lords.
My lord, in this case, the coordinate bench refused to grant stay in this matter.
Refused to grant.
The proceedings against respondent number 3 has been admitted by the NCLT, my lord, in this matter.
NCLT.
NCLT nal admit agide. The home buyers have filed petition under section 7 of the IBC. That has been admitted.
That is why it's been refused.
We file our statement of objection in this
My
matter.
lord, sir, my lord, in that case, my lord, a stay may be granted to us, my lords, and interim relief.
If it has been admitted to NCLT, finally you are bringing, there's so many petitions of this company coming
Yes,
up.
my
before
lord.
this court. So all these matters would have to be transferred to the NCLT.
Yes. Has to be adjudicated before the NCLT.
They cannot be before us. They'll be formulating, it's under moratorium now. It's better that you go there as soon as possible than delaying this.
My lord, we will go there, my
In
lords.
fact,
But
the advocate for the respondent number 3 made a submission, my lord, before the coordinate bench that the claim against the respondent number 3 has been admitted before the NCLT. He is also aware of it. The home buyers have filed a petition.
It's in your interest that you go there fast.
my
No
lords,
point
we will approach the NCLT, my lords. But until then, my lords, I've been paying 33 lakhs as
Go
interest, my
next
lords.
week, what is it? ಇದು ಒಂದು ಕೆಲಸ
My lords.
ಮಾಡಿ ಇದು ಓಝೋನ್
Ozone matter.
ಯಾವ್ದು ಬಂದ್ರೇನು we are passing orders, nobody has brought it to our notice. For the first time you are bringing
Senior
notice.
counsel Sam Prasad has submitted before the coordinate bench.
There are so many matters of this
Replace-
company.
I have also
My lords,
instructed
until
the
then, my
bank-
lords.
I have also instructed
13 ಪಾಪ ಅವ್ರಿಗೆ ಮತ್ತೆ ಲೇಟ್ ಆಗುತ್ತೆ ಲಿಸ್ಟ್ ಮಾಡ್ಬಿಡಿ because these orders will not be enforceable once the moratorium is there. They will not have any benefit of these orders.
Yes, ma'am.
My lords, until then, I may be given some.
You won't have any benefit of the orders because the moratorium would be there. You will have to go there and get your orders. It's in your interest. If we pass this order, it's of no use for you. And anyway, in your matter, it's already been rejected.
Yes.
So we can't pass an order now until the service there. You may as well go before the NCLT. Learned counsel for respond number 1 and 2 submits that respond number 3 has been admitted to insolvency proceedings in what number?
Number
Number ಕೊಡ್ಬೇಕು.
next time. my lord.
Next time ಅಲ್ಲ ಇವತ್ತೇ ಕೊಡಿ in so and so. In that view of the matter, the NCLT being seized of all issues pertaining to the respondent number 3 company, the petitioner being a home buyer, also being a creditor, the issues raised by the home buyer would also have to be considered by the NCLT. Hence, reserving liberty to the petitioner to agitate all the issues raised in the present petition before the NCLT, the petition stands disposed.
He's also aware of the
Tipping number 100.
If you are aware, you should go there. Why are you wasting time here?
Madam, he's aware of. ನಾನು ಕೇಳ್ತೀನಿ. ಮೇಡಮ್ ಇಲ್ಲ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಇದೆ. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಮುಗಿದ್ಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ 6 ಮ್ಯಾಟರ್ ಇದೆ.
ಫೈಲ್ ಬಂದಿಲ್ಲ ಅಂತ
ಸೆಲ್ ನಂಬರ್ 49 ಏನಾದರೂ ಎಡ್ಜನ್ ಆಗಿದೆ.
ಇಲ್ಲ ಅವರು
ನೀವೇ
amendment
ಇದ್ದೀರಾ?
ಕೇಳಿದ್ರು.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಏನಾಗುತ್ತೆ ಗೊತ್ತಾ, ವೇಟ್ ಮಾಡ್ಬೇಕು, ಅದು ಎಡ್ಜನ್ ಆಗಿರ್ತಾರೆ ಬೆಳಗ್ಗೆ.
ಹೌದು, ಅದು ಪ್ರಾವಿಷನ್ ಇದೆ. CJ ಆರ್ಡರ್ ಇದೆಯಲ್ಲ ಸರ್, ಅವ್ರಿಗೆ ಸರ್ಕ್ಯುಲರ್ಸ್ ಇದಾವೆ, ಯಾರ ಮುಂದೆ ಯಾವ್ದು ಹಾಕ್ಬೇಕು ಅಂತ, ಅದನ್ನ ಫಾಲೋ ಮಾಡ್ತಾರೆ. ಯಾರು ಮಾಡ್ತಾರೆ? ಓವರ್ ರೂಲ್ ಜಡ್ಜ್ ತಾನೇ ಮಾಡ್ತಾರೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಸಬ್ಮಿಷನ್ ಬರ್ಕೊಟ್ರೆ ಓವರ್ ರೂಲಿಂಗ್ ಸರ್. ಒಂದೇ ಒಂದ್ ನಿಮಿಷ ಸರ್. ಸರ್ಕ್ಯುಲರ್ ಇದ್ರೆ ಅವ್ರು ಅವ್ರ ಮುಂದೆ ಹಾಕ್ತಾರೆ. ಈಗ ಸಬ್ಮಿಷನ್ ಇತ್ತು ಅಂತಂದ್ರೆ ಅವ್ರ ಮುಂದೆನೆ ಹಾಕ್ಬೇಕು ಅಂತಿದೆ. ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದ್ರಲ್ವಾ ನೀವು ಸಬ್ಮಿಷನ್ ಮಾಡೋದು? ಅದೇ ನೀವು ಮೂವ್ ಮಾಡಿದ್ರೆ ಲಿಸ್ಟ್ ಆಗ್ಲೇ, ನಿಮ್ಗೆ ಲಿಸ್ಟ್ ಆಗ್ಬೇಕಷ್ಟೇ, ಆಗುತ್ತೆ. ನಾನ್ ಯಾಕೆ ಹೇಳಿ, ಮೆಮೊ ಕೊಟ್ಟಿದೀವಿ, ಹಾಕ್ಬೇಕಲ್ವಾ, ಅವ್ರ ಕೆಲ್ಸ ಅಲ್ವಾ? ಎಲ್ಲ ನಾನು ಹೇಳ್ಕೊಂತ ಕೂತ್ಕೊಂಡ್ರೆ ಒಂದಿನಕ್ಕೆ 200 ಡೆಮೋಸ್ ಬರುತ್ತೆ. ಒಂದೊಂದ್ ಕೇಸ್ಗೂ ನಾನು ಅದಾಕಿ ಇದಾಕಿ ಅಂತ ಹೇಳಕ್
ಮೇಡಮ್ ಪಾಸ್ ಓವರ್
ಹೇಳಲ್ಲ
ಮ್ಯಾಟ್ರಿಕ್ಸ್
ಸರ್,
ಯಾವಾಗ
ಅವ್ರು ಹಾಕ್ಲಿ,
ತಗೊಂತಾರೆ?
ಅವ್ರ ಕೆಲಸ.
ಮೇಡಮ್ ಪಾಸ್ ಓವರ್ ಮ್ಯಾಟ್ರಿಕ್ಸ್ ಯಾವಾಗ ತಗೊಂತಾರೆ?
ಫಸ್ಟ್ ಧಾರವಾಡ, ಆಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಪಾಸ್ಟ್ ಓವರ್ಸ್ ಕಂಟಿನ್ಯೂ.
ಧಾರವಾಡದ್ದು ಎಷ್ಟಿದೆ ಮೇಡಮ್ ಮ್ಯಾಟ್ರಿಕ್ಸ್?
ಧಾರವಾಡದ್ದು 2,
ಆಮೇಲೆ
ಪಾಸ್ಟ್
ಸೆಕೆಂಡ್
ಓವರ್ಸ್ ಒಂದು 5 ಇದೆ.
ನಮ್ದು ಪಾಸ್ ಓವರ್ ಇದೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 50 ಅಜ್ಜನ್ ಆಗಿಲ್ಲ ಅಲ್ಲ?
ಯಾವುದು ಸರ್?
ಸೀರಿಯಲ್ ನಂಬರ್ 50 ಮೇಡಮ್, 50.
50 ಇದೆ ಸರ್.
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಸರ್ ನಾನು ಹೇಳಲ್ಲ ಸರ್, ಅದು ಅವ್ರ ಕೆಲಸ ಅವ್ರು ಮಾಡ್ಬೇಕು. ಅವ್ರಿಗೆ ಸರ್ಕ್ಯುಲರ್ ಇರ್ತವೆ, ಯಾರ ಮುಂದೆ ಹಾಕ್ಬೇಕು, ಏನ್ ಹಾಕ್ಬೇಕು ಅಂತ. ನಮ್ ಮೆಮೋನು ಇದೆ, ಅದನ್ನ ಸೇರಿ ಅವ್ರು ಏನಾದ್ರು ಡಿಸಿಷನ್ ತಗೊಂಡ್ ಹಾಕ್ಲಿ. ನನ್ ಕೆಲಸ ಬರೀ ಮೆಮೋ ಕೊಡೋದು, ಇಷ್ಟ ಆದ್ರೆ ಕೇಸ್ ಕರೆಯೋದು. ಎಲ್ಲದಕ್ಕೂ ನಾನು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಕೊಂಡು ಕೂತ್ಕೊಳಕ್ ಆಗಲ್ಲ. ನಾವೇನ್ ಮಾಡೋಣ ಹೇಳಿ, ಮಾಡಿ ಅದನ್ನೇ ಸಾಹೇಬ್ರ ಮುಂದೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿ. ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಮಾಡಲ್ವಂತೆ ಸರ್, ಲಿಸ್ಟ್ ಮಾಡಲ್ವಂತೆ ಅಂತ ಮಾಡಿ.
ನಿನ್ನೆ ಮ್ಯಾಟ್ರ್ ಇತ್ತು, ಸಾಹೇಬ್ರು ನಾಳೆಗೆ ಹಾಕಿದ್ದಾರೆ. ಫೈಲು ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಅಲ್ಲಿ ನಮಗ್ ಬಂದಿಲ್ಲ ಇವತ್ತು.
ನಿನ್ನೆ ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳಿ ಸರ್.
ನಿನ್ನೆ ಸೀರಿಯಲ್ ನಂಬರ್ 35 ಫಸ್ಟ್ ಲಿಸ್ಟ್.
ಒಂದು ಫೈಲ್ ಅಲ್ಲಿದೆ 11041/26 ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಆಗಿದ್ರೆ ಫೈಲ್ ಬಂದಿರುತ್ತೆ, ಅದಕ್ಕೆ ನೋಡೋದು ಕೇಸ್ ನಂಬರ್ ಬೇಕು. 11041/26
ಹೌದು ಮೇಡಮ್.
ಆರ್ಡರ್ ಇಲ್ಲಿ ಅಪ್ಲೋಡ್ ಆಗಿದ್ರೆ ಇಲ್ಲಿ ಗೊತ್ತಾಗುತ್ತೆ. ಅಪ್ಲೋಡ್ ಆಗಿಲ್ಲ ಸರ್, ಫೈಲ್ ಬಂದಿಲ್ಲ. ಸ್ಟೆನೋಗ್ರಾಫರ್ ಇಂದ ನನಗೆ ಫೈಲ್ ಬಂದಿಲ್ಲ.
ಎಲ್ಲಿ ಹೋಗುತ್ತೆ
ಬ್ರಾಂಚ್ ಹೋಗಿ, ಪೆಂಡಿಂಗ್ ಬ್ರಾಂಚ್ಗೆ.
ಅಲ್ಲಿ ಅದು ತಗೊಂಡೋಗಿದ್ರೆ ಬುಕ್ ಇರುತ್ತಲ್ಲ ಮೇಡಮ್?
ಅಲ್ಲ, ಡಿಕ್ಟೇಷನ್ ಅವ್ರು ತಗೊಂಡೋಗಿದ್ದಾರೆ, ಸ್ಟೆನೋಗ್ರಾಫರ್ ಬರ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ. ಫೈಲ್ ಅವ್ರ ಕಡೆ ಕೊಟ್ಟಿದೀವಿ, ಅವ್ರ ಆರ್ಡರ್ ಟೈಪ್ ಆಗಿ ಜಡ್ಜ್ ಕಡೆಯಿಂದ ಸೈನ್ ಆದ್ಮೇಲೆ ನನಗೆ ಬರುತ್ತೆ.
ಅಯ್ಯೋ, ಮತ್ತೆ ಇವಾಗ ನಾನು ಎಲ್ಲಿ
ಬರ್ಬೇಕು, ಫೈಲ್ ಬಂದ್ರೆ ಕಳಿಸ್ತೀವಿ.
ಅಲ್ಲ, ಅವ್ರನ್ನ ಎಲ್ಲಿ ಹುಡ್ಕೋದು?
ಆ BNV ಅಂತ ಇರ್ತಾರೆ, ಈ ಅವರು ಜಸ್ಟಿಸ್ ಮನ್ವತ್ ರಾವ್ ಇದಾರಲ್ಲ, ಆ ಚೇಂಬರ್ ಅಲ್ಲಿ ಇರ್ತಾರೆ. BNV ಕೋರ್ಟಲ್ ಅಲ್ಲ, ಅದು ಚೇಂಬರ್, ಜಡ್ಜ್ ಚೇಂಬರ್. ಸರ್ ಈಗ BNV ಅಂತ ಅವ್ರ ಹೆಸರು, ಇನ್ಶಿಯಲ್ ಅದು. ಅಲ್ಲ, ಈಗ ಏನ್ ಗೊತ್ತಾ, ಯಾರು ಹೇಳಿದ್ ನಿಮ್ಗೆ ನನ್ನ ಹೆಸರು? ಎಲ್ಲಿ ಹೇಳಿದ್ರು ಹೇಳಿ? ಕೋರ್ಟ್ ಆಫೀಸರ್ನ ಕೇಳಿ ಅಂತ ಹೇಳಿದವ್ರು ಯಾರು? ಬೋರ್ಡ್ ಅಲ್ಲ. ನೈನ್ ಅಲ್ಲ ಸರ್, 10. ಫಸ್ಟ್ ಧಾರವಾಡ ಸರ್, ಆಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್, ಆಮೇಲೆ ಪಾಸ್ಟ್ ಓವರ್ಸ್. ಅಲ್ಲ ನಮ್ಮದು ತೊಂದ್ರೆ ಅದು. ಬಿಂದುಮ್ಮ, ಹಾ ಹೌದಾ, ಗುಡ್, ಥ್ಯಾಂಕ್ ಯು. ಹಾ ಸರಿ, ಆಯ್ತು ಆಯ್ತು. ಸರಿ ಸರಿ, ಆಯ್ತು ಕಣ. 10 ಸರಿ. ಸರ್, ಕೋಮಲ ಎಲ್ಲಪ್ಪ ಇದೆಯಾ? ಹಿಂಗೆ ಆಗ್ತಿಲ್ಲ ನಂಬರ್. ಯಾಕೆ ತಗೊಳ್ಳಿಲ್ಲ? 200 ಮೆಮೋ ಇದಾವೆ.
ಆಯ್ತು. ಆ ಕಡೆಯಿಂದ ಕಾರ್ನರ್, ಫುಲ್ ಕಾರ್ನರ್.
ಯಾವಾಗ ಬರಕ್ಕಾಗುತ್ತೆ ನಿಮಗೆ? ಮೆಮೋ ನಿಮ್ ಕಡೆನೆ ಕೊಡ್ತೀನಿ, ನೀವೇ ತಗೊಂಡೋಗಿ ಬ್ರಾಂಚಿಗೆ ಕೊಡ್ಬೇಕು. ಇದು ಏನ್ ಮೆಮೋ ಇದು? ಪೋಸ್ಟಿಂಗ್ಸ್ ಕೇಸ್ ಬರ್ಲಿ ಅಂತನಾ? ತಗೊಳಮ್ಮ. ಅಲ್ಲ ಈಗ ಪೋಸ್ಟಿಂಗ್ಸ್ ಅಲ್ಲ ಮೆಮೋ ಫಾರ್ ಪೋಸ್ಟಿಂಗ್ಸ್ ಇದ್ರೆ ಕೊಡಿ. ನೀವು ಯಾವತ್ ಬರಕ್ಕಾಗುತ್ತೆ ಹೇಳಿ, ಅದು ನೀವೇ ತಗೊಂಡೋಗಿ ಬ್ರಾಂಚಲ್ಲಿ ಕೊಡ್ಬೇಕು. ಅಲ್ಲ ಮೆಮೋ ಫಾರ್ ಅವ್ರು ತಾನೆ ಫೈಲ್ ಅವ್ರು ಇಟ್ಕೊಂಡಿರ್ತಾರಲ್ಲ, ಅದಕ್ಕೆ ಪೆಂಡಿಂಗ್ ಬ್ರಾಂಚ್ ಕೊಡಿ. ಕೋಮಲ, ಹಲೋ, ನನ್ನ ಹತ್ರ ಯಾಕಮ್ಮ ಕಳಿಸ್ತೀರಾ? ಯಾವ್ದೋ ಮೆಮೋ ಇದೆಯಂತೆ. ನನ್ನ ಹೆಸರು ಹೇಳ್ಬೇಡಿ ದಯವಿಟ್ಟು ನೀವು. ನಿಮ್ಗೆ ನಿಮ್ ಫೈಲ್ ಬಂದ್ರೆ ಲಿಸ್ಟ್ ಮಾಡಿ, ನನ್ನ ಹೆಸರು ಯಾಕೆ ಹೇಳ್ತೀರಾ ಇಲ್ಲಿ? ಈಗ ಅವ್ರಿಗೇನೋ ಸರ್ಕ್ಯುಲರ್ ಇದೆ, ಇಂಥವ್ರ ಮುಂದೆ ಹಾಕ್ಬೇಕು, ರಿಜಿಸ್ಟರ್ ಮುಂದೆ ಹಾಕ್ಬೇಕು, ಅವ್ರಿಗೇನೋ ಇದೆ, ಅದನ್ನ ಮಾಡ್ಕೊಂತಾರೆ ಅಲ್ವಾ? ಅವ್ರು ಏನ್ ನಿಮಗ್ ಕಳಿಸ್ತಾರೆ ಅದನ್ನ ತಾನೇ ಮಾಡ್ಬೇಕು. ನನ್ನ ಹೆಸರು ಯಾಕೆ ಹೇಳ್ತೀರಾ ಇಲ್ಲಿ ನೀವು? ಬೇಡ, ನೀವು ನನ್ನ ಹತ್ರ ಕಳಿಸ್ಬೇಡಿ. ಎಲ್ರಿಗೂ ಉತ್ತರ ಮಾಡೋದು ನಾನು ಊಟನೇ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಎಷ್ಟೋ ದಿನ ಊಟನೇ ಮಾಡಲ್ಲ, ಬರೀ ಪ್ರಶ್ನೆಗಳು ಉತ್ತರ ಕೊಡೋ ಅಷ್ಟ್ರಲ್ಲಿ 2:10 ಆಗೋಗುತ್ತೆ, ವಾಶ್ರೂಮ್ಗೆ ಹೋಗೋ ಅಷ್ಟ್ರಲ್ಲಿ 1:15 ಗಂಟೆ ಆಗೋಗುತ್ತೆ, 2:30 ಆಗೋಗುತ್ತೆ, ಬಂದ್ಬಿಡ್ತೀನಿ. ಊಟನೇ ಮಾಡಲ್ಲ ಕಡೆಗೆ. ಬರೀ ಕೊಯ್ರಿ ಅಟೆಂಡ್ ಮಾಡೋದೇ ಆಗೋಗಿದೆ ಕೆಲಸ ಮಾಡೋದಕ್ಕಿಂತ. ನಾನು ದಯವಿಟ್ಟು ಯಾರು ನನ್ನ ಹತ್ರ ಕಳಿಸ್ಬೇಡಿ. ನಿಮ್ ಫೈಲ್ ಬಂದ್ರೆ ನೀವ್ ಹಾಕಿ, ಬರ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ಏನಾದ್ರು ಮಾಡ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ. ಏನ್ ಮಾಡೋದು ಹೇಳಿ? ಇಲ್ಲಿ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾರೆ, ನಾಳೆಗೆ ಹಾಕಿ ಅಂತಂತಾರೆ, ನಾವು ನಾಳೆಗೆ ಅಂತ ಬರ್ದ್ ಕಳಿಸ್ತೀವಿ. ಅವ್ರ ಪ್ರೊಸೀಜರ್ ಏನೋ ಇರುತ್ತಲ್ವಾ, ಅದನ್ನು ಫಾಲೋ ಮಾಡ್ತಾರೆ. ನೀವು ನನ್ನ ಹತ್ರ ಕಳಿಸ್ಬೇಡಿ ಯಾರನ್ನೂ. ಅಷ್ಟೇ, ಅವ್ರ ಫೈಲ್ ಬಂದ್ರೆ ಹಾಕ್ತಾರೆ. ಅಲ್ಲ, ಈಗ ನಿಮ್ಗೆ ಯಾವತ್ ಬರುತ್ತೆ? 29ಕ್ಕೆ ಬರ್ತೀರಾ ನೀವು? ರೀಚ್ ಆಗೋ ಅಷ್ಟ್ರಲ್ಲಿ ಅಷ್ಟೊತ್ತಾಗುತ್ತೆ. ಯಾವ ವರ್ಷದ್ದು ಅದೆಲ್ಲ? ಯಾವ ವರ್ಷದ್ದು? 24 ಫಸ್ಟೇ ಬಂದ್ಬಿಡುತ್ತೆ. ಬೇಡ, ಇಲ್ಲ, ಅದ್ ಯಾವತ್ ಬರುತ್ತೋ ಅವತ್ತು ಆರ್ಗಿ ಮಾಡಿ ಅಷ್ಟೇ. ರೀಚ್ ಆಗಷ್ಟಕ್ಕೆ ಮಧ್ಯಾಹ್ನನೇ ಆಗುತ್ತೆ. ಯಾವ್ದು ಕೊಟ್ಟು ಮತ್ತೆ ಓದು. ಪೆಂಡಿಂಗ್ ಬ್ರಾಂಚಲ್ಲಿ ಕೊಡು. ಎಲ್ಲಪ್ಪ ಇದೆ ಪೆಂಡಿಂಗ್ ಬ್ರಾಂಚು? GM RES RES
ಈ ಕಡೆ ಇಲ್ಲಿ ಕೆಳಗಡೆ ಇಳಿದು ಗ್ರೌಂಡ್ ಹೋಗಿ ಅಲ್ಲಿ ಸಂದಿಲ್ ಹೋಗ್ಬಿಟ್ಟು GM ಬ್ರಾಂಚ್ ಅಂತ
ಫಸ್ಟ್ ಧಾರವಾಡ, ಆಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಪಾಸ್ಟ್ ಅವರ್ಸ್ ಕಂಟಿನ್ಯೂ. ಇದ್ಯಾವ್ದು ನಾಗರಾಜ್? 43ನಾ? 43 ಹೇಳಿ. ನೀವೇ ತಗೊಂಡ ನೀವ್ ಯಾವ ಬ್ರಾಂಚ್ಗೆ ಹೋಗ್ತೀರಪ್ಪ? ಪೆಂಡಿಂಗ್ ಬ್ರಾಂಚ್ ಅಂತ ಯಾವ್ದಾ? ಡಿಸ್ಪೋಸಬಲ್. ಕೊಟ್ಬಿಡಿ ಬ್ರಾಂಚಲ್ಲಿ ಅಷ್ಟೇ. ಪೆಂಡಿಂಗ್ ಬ್ರಾಂಚ್ ಅವ್ರಿಗೆ. ಬಿಂದು ಬಂದಿದ್ರಾ? ಇಲ್ಲಿ ಬರ್ತೀನಿ, ಆಮೇಲೆ ಊಟಕ್ಕೆ ಹೋಗೋಣ ಅಂದ್ರು, ಅದಕ್ಕೆ ಫೋನ್ ಅವರೇ ಮಾಡಿದ್ರು. ಇಲ್ಲಿ ಎಲ್ಲಿ ನಾನು ಅಟೆಂಡ್ ಮಾಡಕ್ಕೂ ಆಗ್ಲಿಲ್ಲ.
Okay, sir. Okay, along.
ಮೇಡಮ್ ಊಟಕ್ಕೆ
ಮಧ್ಯಾಹ್ನ 1:30 ಯಾವ್ದು ಮೂವ್ ಆಗಿದೆ 2:30 2:30 ಯಾವ್ದು ಮೂವ್ ಆಗಿದೆ ಇದೆಯಾ ಗೌರ್ಮೆಂಟ್ ಯಾರು ಸರ್ ಕಾಲ್ ಸರ್ ಸರ್
ಯಾವುದು ಸೀರಿಯಲ್ ನಂಬರಾ? ಅಲ್ಲ ಎಷ್ಟ್ ಸತಿ ಲಿಸ್ಟ್ ತೆಗಿಬೇಕು ಗೊತ್ತಾ? ನನ್ ಗೊತ್ತ, ಅದಕ್ಕೆ ಆಚೆಗೆ ಇಟ್ಬಿಟ್ಟಿದೀನಿ ಆ ಕಡೆಗೆ. ಇಲ್ಲಿ ಬಗ್ಗೆ ತೆಗಿಬೇಕಲ್ಲ ಅಂತ. ಒಂದ್ ಸ್ಟೆನೋಗ್ರಾಫರ್ ಬಂದು ಹಿಂಗ್ ಹೋಗಾಗಿದ ತಕ್ಷಣ ನಾನು ಅವ್ರಿಗೆ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಯಾವ್ದು, ಡೇಟ್ ಯಾವ್ದು ಎಲ್ಲ ಆಯ್ಕೊಡಕ್ ಆ ಕಡೆ ಹೋಗ್ತೀನಿ. ನೀವು ಈ ಕಡೆ ನೋಡ್ಕೊಳ್ಳಿ. ಅವ್ರಿಗೆ ಡೇಟ್ ಇರೋದು ಯಾವ್ದು, ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಯಾವ್ದು ಎಲ್ಲ ಆಯ್ತು ಕೊಡ್ಬೇಕಂತೆ. ಅವಾಗ ನೀವು ಈ ಕಡೆ ನೋಡ್ಕೊಳ್ಳಿ, ನಾನು ಆಯ್ತು ಕೊಡ್ತೀನಿ. ಅದೇ ಮೆಸೇಜ್. ಹಾ ಹೌದು, ಹಾ ಹೌದು. ನೀನ್ ಮಾಡು ಅಂತ ನನಗೆ ಹೇಳಿದ್ಮೇಲೆ ನಾನು ಅದನ್ನ ಮಾಡ್ತೀನಿ. ಇದು ನನಗೆ ಸಿಒ ಅಲ್ವಾ ನೀವು, ನನಗೆ ಅಸಿಸ್ಟ್ ಮಾಡ್ಬೇಕು ನೀವು, ನನ್ನ ಕೆಲಸ ನೀವು ಮಾಡ್ಬೇಕು. ಓಕೆ, ಅದೇ ಅದೇ. ಇಲ್ಲ, ನಾನು ಬಂದು ಆಯ್ಕೊಡ್ತೀನಿ.
July print ಇಲ್ಲ.
Forward bench matters. Serial number 1.
Please, Madam. Madam, some general directions have issued in this case, Madam. However, similar directions have issued in the principal bench also, Madam. In WP 11506/2022, and in those matters, Madam, the state is regularly filing the compliance report, Madam.
So we'll close this matters then.
Please, Madam.
Lord Additional Advocate General submits that compliance reports are being filed in WP number
11506/2022.
22. Hence, there would be no requirement to file compliance report in these matters. The petition stands closed.
Please.
Additionally, there's a report already filed. We have made some observations.
Yes, Madam. Yes, Madam. Principal Secretary were present before this honorable court on the last date of hearing, Madam, in those cases, Madam.
Nodi, because there are around 10,500 land acquisition matters in Kalburgi.
Yes, Madam. Yes, Madam.
Around 6,000 and odd in Dharwad.
Dharwad bench, Madam. Yes, Madam.
Main beneficiaries would be Kalburgi and Dharwad.
Yes, Madam. And last date also, my lord also given some interim directions in those matters, Madam. What are to be included in the software and all those things, Madam. Please, Madam. All those things have been in the pipeline, Madam. It is in the process, Madam.
Okay. Yes.
Madam, the next matter, Madam. That software is ready, Madam. It is launching on Monday, Madam. So another 7 days, Madam, I will give the details, models of the software, Madam.
Additional Advocate General submits that the software is being launched on Monday. Given 10 days time, a compliance report with the details of working of the software will be placed on record. Released on 16th July.
Please, great.
230 matters. List number 2. Serial number 1. Srikara PK and connected matters.
Calculation ನಾನು ಕೊಟ್ಟಿದ್ದೆ. They have filed objection.
They filed objection.
Their objection on the first face of it appears to be correct. ಯಾಕೆಂದ್ರೆ ನಾವು 2017, 2018 GST ಬಂದಿರೋದು. ನಾವು earlier ಟೈಮ್ಗೂ GST ಹಾಕಿದ್ದಾರೆ. ನಮ್ಮ
ಮತ್ತೆ ಕರೆಕ್ಷನ್ ಮಾಡಬೇಡಿ.
ಅದೇ ಕರೆಕ್ಷನ್ ಮಾಡಿ ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ. ನನ್ನ ಅಂದಾಜು ಬೇರೆ ಯಾವ್ದಾರ ಟ್ಯಾಕ್ಸ್ ಬದಲು ತಲೆಗೆ ಹೋಳಿದ GST ಅಂತ ಹಾಕ್ಬಿಟ್ರ ಅಂತ. Earlier ಇದಕ್ಕೆ
ವೆರಿಫೈ ಮಾಡಿ.
ವೆರಿಫೈ ಮಾಡಿ.
I felt calculation issue.
Genuineness in
ನಿಮ್ ಸಬ್ಮಿಷನ್ ರೆಕಾರ್ಡ್ ಮಾಡದ?
ಬೇಡ.
ಅದಕ್ಕೆ
I just wanted to be.
That is why we are asking you before.
ಮತ್ತೆ ಅದೇ ತಪ್ಪು ಮಾಡಿ.
Learned counsel for the. You don't need to worry. Don't worry. Don't be looking at the door. It's a very simple. ಶ್ರೀಕರ ನೋಡಿ ಹೇಳ್ತಾರಂತೆ, as regards the GST calculation that you've given, they'll verify and redo the calculation if required. 2009 in the GST.
ಅದೇ ತಪ್ಪಾಯ್ತಲ್ಲ. ಅದೇ I'm admitting.
Service tax was there.
ಬದಲು nomenclature change ಮಾಡಿ.
Service tax was there. So this is for rental alva. Rental service tax was there.
ಅದನ್ನ ಹೇಳೋ ಬದಲು ಈ ತರ ಬರೆದ್ಬಿಟ್ಟಿದ್ದಾರೆ.
2009 service tax was there. Percentage was the same as far as we remember, but let them check it. Learned counsel for the petitioner has filed his objections to the calculation submitted by respondent number 1 and 2. Counsel for respondent number 1 and 2 seeks for and is granted
9th or 10th.
2 weeks time to go through the same, obtain his instruction, make his submission. Released on 16th July. Interim order earlier granted is extended.
ನಮ್ಮದು ಗ್ಯಾಪ್ ನಮ್ದು GST ಇದ್ರೂ ಸಹ more than about 50,000 60,000 ಏನಾರು ಎಲ್ಲ 900 ರೂಪಾಯಿ 1000 ರೂಪಾಯಿ ರೆಂಟ್ ಎಷ್ಟು ಕೊಡ್ತಾರೋ ಕೊಟ್ರೆ ಕೊಟ್ರೆ ಅದನ್ನ ಬಿಟ್ಬಿಟ್ರೆ ಕೊಟ್ರು ಆಯ್ತು.
ಅವರು ಕ್ಯಾಲ್ಕುಲೇಷನ್ 24 ರೂಪಾಯಿ 22 ರೂಪಾಯಿ per square feet 24 ರೂಪಾಯಿ per square feet ಬರ್ತದೆ 10 ಅಲ್ಲಿ ಲಿಂಕ್ ಹಾಕಿ. ಈಗ ತಂದೆ ಪಕ್ಕ ಕಟ್ಟಿಗೆ ಮಾರ್ಕೆಟ್ ಅಂತ ಈಗ ಕಲೆಕ್ಟ್ ಮಾಡ್ತಿದ್ರು 22 ರೂಪಾಯಿ 23 ರೂಪಾಯಿ per square feet ಕಲೆಕ್ಟ್ ಮಾಡ್ತಾರೆ. ಅವರು 2010 ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿ 3 years ಹೈಕ್ ಮಾಡ್ಕೊಂಡು ಕೇಳಿದ್ದಾರೆ.
ಇದನ್ನ ನಾವು ಅಗ್ರಿಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಇನ್ನೊಂದು ರಿಜಿಸ್ಟರ್ಡ್ ಆಗಿರೋದು ಅದನ್ನು ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದೆ ಮತ್ತೆ ಗವರ್ನಮೆಂಟ್ ಫಾರ್ಮುಲಾ ಇದೆ ಇದಕ್ಕೆ.
Both of you said you will reconcile. We are facilitating that. If final last stage, if it is not reconciled, you argue, we'll deal with it. If there's any of those things, this at least you will be arguing only on 1 or 2 points instead of 10 points that you'll be arguing. No day.
Serial number 2. Hello, Bakash.
My name was wrongly shown in the cost list. Your Lordship kindly see the, I filed a memo along with the cost list on 20th.
You are for respondent number 4.
4.
Soumya. Jayaprakash Shetty had appeared for respondent number 4.
A is missing. After K, A is missing.
A is missing.
Please.
Where the cause list?
Along with the memo. Page 5.
Serial number?
5. In page 5.
Serial number?
32.
KASH.
Please.
That's right.
So for second portion of the order.
You are not registered in the portal with your enrollment number.
No, already registered.
If you are registered, the full name will come with proper, it is linked to the KSBC.
So for order is second portion of order concerned, I will not dispute it. Both the parties should go to a civil court. But only the first portion.
Entry of the name.
Entry of the kata. Let it be.
The first stage will recall it, restore the writ petition to file, then you address your argument. We cannot change that order.
The dispute between the brother and sisters.
You have a reason for
Please.
recall. IA 1 of 26 has been filed for recalling the order dated 9 February 26. The submission of IA Akivera. What is the prayer that you are seeking? The submission learned counsel for respondent number 4 is that in the cause list which had been published for 9th February 26, his name was wrongly printed in the cause list. The name printed in the cause list is inverted commas JAYAPRAKSH space Shetty SHETTY inverted commas close. Whereas his name is JAYAPRAKASH Shetty. Since the A was missing, he was not aware of the listing of the matter and as such could not be present when the matter was taken up for disposal. The appraisal of the cause list indicates the, supports the submission made by the counsel for the respondent number 4. Hence, order dated 9 February 26 is recalled. The petition is restored to file. Relist on 16th July.
Please.
16th, 17th or after that? 16th.
Please.
There is a delay of 13 days.
A delay of IA 1 of 26 is, IA 2 of 26 is allowed, delay of so and so days is condoned. Then the submission made by the counsel for the respondent is that he came to know about the order much later when the petitioner sought to get his entry, name entered in the revenue records. IA 1 of 26 are restored.
Please.
Since the petition is restored to file, the interim order which had earlier been granted would continue to be in operation.
Please.
Serial number 3, Kevin Narasimhan.
My lords, I appear for respondent 125, my lords. I am bringing the officials. Kindly request, I request for a short pass over, my lords.
Yes, pass over.
Grateful, my lords.
Serial number 4, Vinay M.
For respondent number 4, my
Not been, report is not made.
not filed.
Okay.
Ready, Mara.
Report is there, it is being furnished now. Third.
Madam.
The reports, you should ask them to give typed copies.
Next time.
Page
I
3
apologize,
and
my lord.
Reading would be very difficult.
May I explain, my lord?
Is not.
Yes.
It's quite clear. Now, my lord.
Yes, Mr. Chinnappa.
Chinnappa is not here.
My lord is not there. We'll have to look into the report, my lord. I can have it tomorrow, my lord. Yes, now we have.
Tomorrow is always a problem.
Tomorrow I.
Or 2:30, my lord.
Tomorrow, my lord, I'll not be in station.
You are not in state.
Monday.
Something other, 1 week.
No, Monday, my lords, may have it. There's not one more fact, not I'll want to give me the plan sanction. But there's one more, not copy put over. Sign. He's not shown that access routes. What does he say?
This is all due to haphazard development. This 18-meter road doesn't lead anywhere. It all of a sudden comes.
I will.
But I'll just point out one
I will.
material fact, Lord. In
No,
fact,
if
Lord,
at all I can
this is
explain
very, very
regarding-
interesting. But before the Pollution Control Board, they file a map. I'll show my lords that map. There, my lord.
You show everything when he
Very well,
is
very well.
Chinnappa is not in his
Only,
absence.
only
well,
with
very
regard to whatever the survey is, Lord. I'll explain the survey.
You
Without
can
missed
explain the
anybody.
survey
I will explain the survey.
in the presence of both of
Presence of
them,
both the parties.
not.
Also,
but,
my lord,
Because we are the independent authority to conduct the survey, and whatever we have found there, we have clearly mentioned.
That is fine, but our observation is that this 18-meter road of 100, what probably 150 meters is what that extent of that road is.
If I-
Suddenly it's appearing there. After that, every road is 9.14, half of it. We can't have
It
an
is
orderly
act-
development of the.
Actually, if your lordship could see that 7/1 survey number, there it is not even 9.1, it is 6.15.
That is my property.
That is his property. There, my lord, the 6.14 is at Bandidari. That is the property owned by the state. If your lordship can see.
No, that we
have-
understand,
Yeah,
but if
20
you look
feet
at
road.
if you look at the purpose for FAR calculation,
But then, my lord, the RMP shows that the other portion also between A and B, that is the road.
that is not the road.
That's also
The road that is being claimed is near that raste antidella, Kannadalli, in between both the two rastes.
ಅದು ಬಂಡಿದಾರಿ ಅಂತ
13.73, 21.98 is the depth of it, 13.73 is the width of it. That is what they are claiming.
whatever we have shown that raste antide, everything is a sanctioned government road. Now what has happened is they have produced some document to show that they have acquired certain easementary rights to enter their property.
You can argue
When they are there,
together.
we can.
But suddenly one 18 meters road coming and all the exits are to 9 meters. So imagine
It actually narrows down to the petitioner's property. But there, my lord, I am told that the land has been acquired to the RMP. That road is to be formed as 18-feet road, and already there exists 20-feet road belonging to the
meters.
20 feet, 6.1 meter, which is the Bandidari, which is owned by the state. Now they have
many apartments are being constructed here.
I will, as
What will you do in a 20
without
feet
prejudice to
road?
anybody's rights, whatever, my lord, only with regard to the survey and the survey and the.
Elevated expressway plus everything, that is not able to cater.
Correct.
Today, we took 1 hour 15 minutes.
And let the petitioner and respondent fight it out on that issue. As regards to the.
Can I make
A
one indulgence?
memo with a memo with the report of the ADLI has been filed, copies have been
Along with
furnished.
the affidavit of the fire department, the LC of the fire.
Idenidu?
Both directions were there.
A memo with the survey report
Also measured those.
and the affidavit of the chief fire officer
Please also notice that.
have been filed. Both of them are taken on record. Copies thereof have been furnished to the council for the petitioner and respond number 5.
4, my lord.
For everybody.
My lords, I'm yet to, no, my lords, I have not received a copy. My colleague informs me that we've not received the copy as yet. I'm appearing for respondent number 5.
Where is your colleague? Collect it.
No,
Yes. Kodi.
Total.
Mr. Jaffer.
Total environment. You are total environment.
Which survey number is here?
The total environment.
Total environment now or owner again.
Who is respond number 4?
Total environment. The developer is respond number 4.
Respond number 5?
Is the owner.
I'm the landowner, my lords.
Both of you are together, share the copy.
Just one shot.
Yes. Release turn. 30th at 2:30 p.m.
Like, the interim order may be.
Interim order earlier granted is extended till next year.
Can I seek one more indulgence, my lord? When the survey was conducted, my lord, he has also noticed, my lord, what happened was, my lord, I had placed on record the fire map which they had given before the fire department. What was shown to my lords on the last occasion was, my lord,
all those arguments do it in the
I'm only
presence of
requesting,
everybody.
Lord, during the survey, the ADLR has noticed, Lord, the existence or otherwise of those roads. Let him at least mention that.
Unless you want the court to give some directions for the hearing, otherwise not required.
Very well.
Both of you can address on that day.
Very well. I shall. Grateful.
We can take up other matters.
Right. Grateful.
Serial number 5. CH Dwarkanath.
Yes, Mr. B.B. Patil.
Memo is there yesterday.
AG also appearing.
AG is
We
appearing.
already filed affidavit on 22nd. And the resolution board also passed the resolution. I enclosed it and we already implemented.
It'll take 10 days.
Affidavit is filed, my lord. It's on record, my lord.
22nd.
So if you upload everything, all the pictures as it is, status will be known.
That is very true, my lord. In fact, in future, my lord, we'll see that.
ULMS.
Today, we had one more KDB allotment where the contention was the other side, the neighbors are not allowing me to get inside the property.
In fact, my lord, possession certificate, everything is done. For the industry to actually go and implement and go and take it is a different proceedings itself.
So whatever KIDB, there are allegations, counter allegations being made.
My lord, once the
This won't take it away.
ULMS.
The 10 allegations here, 10 counter allegations will be there.
That is what the
Instead of that 10, it will be reduced to probably 2 is what we are thinking.
So we'll, in future, definitely, my lord, we'll see that it is effective.
You are appearing in this matter for what reason?
My lord,
Because
since
the-
I am appearing on behalf of the Patel and also AG, since the government is involved, my lord, AG also.
AG is busy otherwise. Why?
Because they want
yes,
to- because your lordship has passed certain directions.
no.
As long as you are complying with what is learned counsel for respond number 1 and 2. So now you will be appearing.
Yes.
The so and so has entered appearance and register his name, print his name, and delete name of Shri BB Patil as that appearing for respond number 1 and 2.
Yes, already uploaded.
So and so and the Advocate General submit that the software has been implemented. The uploading of all the documents would take place, and a status report submitted by.
Well, the instruction is been already uploaded on the 10th, my lord.
GIS is already uploaded, my lord. All the
and
data is
it
available. And ULMS is concerned, my lord, government also taken decision, board has also passed the resolution. It will take minimum, complete update, my lord, minimum 100 days. By that time, my lord, everything will be completed. Required, my lord, I have got a paper cutting of the.
CIS is done.
Yes,
You
DRS
are
is done, my lord.
going to
There
be on
also we have
ULMS.
to update software is required.
Hmm.
And ULMS, my lord, board has already taken decision on 11/6 in way of the government direction. And step by step we are implementing. It will completing for that one, my lord, it will take minimum 100 days. That is the reason for minister also made a statement.
Okay.
Alala, statement, my lord, it is required. That I have. But everything will be in transparency, my lord. That is the reason.
What your lordship are saying, case should not come before the court.
Yes.
You may do.
You're not saying case should not.
No, not case in this, because of the.
My lord, regarding that.
See what happens in this, the state and KIDB will have to consider, because when the petitioner comes and makes certain statements, we are not aware of what is the actual fact.
Absolutely.
So sometimes big projects which could be there, we could stay those matters, which could result in problem. If the information is available to the
Most
council,
important, transparency also, Manoj, and
Okay.
clarity also.
and insofar as the officers are concerned, if CIS is implemented, if they have to comply with anything, they don't need to
My lord, regarding
come
that,
under section 3 and 4 of Contempt Act.
my lordship observation regarding, my lord, before executing lease come salary, we have to mention all this infrastructure. My lord, what has happened, my lord? We are acquiring nearly 2,000 acres of land. We are developing step by steps. But the initial amount is required, my lord, taking a deposit. Now we are thinking to insert a clause in the lease come sale agreement, my lord. If suppose the infrastructure is not done as on within 2 years, my lord, we will extending that time for this one. That can be done.
That's your policy
Yes,
decision.
that is the only thing.
See that CIS, CCMS.
GIS.
Partly implemented.
Has been implemented as regard to all the projects of KIDB, and all the land parcels and the plots have been
KLMS is under.
geotagged and uploaded onto the website of the KIDB. His further submission is that KIDB will also be part of the Uniform Land Management System, and all the documentation, approvals, etc. of KIDB would be uploaded onto ULMS to have a cross integration with the other departments. His submission is that the process having started, it would take around 3 months' time.
100 days, my lord.
100 days project.
That was the statement made by our minister. That we have to buy.
So a part of that 100 days will be implemented in 100 days' time. Relist on 1st September for the Learned Council to place on record the progress made till then.
We'll place it on.
Please, ma'am.
Next stage.
Yes, sir. What is the further progress? Only we can make submission.
Question. Grateful to you.
Serial number 6.
Now, if AG has taken interest, it will happen.
Yes.
AG has appeared. So,
we'll see that.
or rather, it is like better happen. Yes.
Serial number 6.
Yes, Mohan.
Mohan Kumar D.
My lord, the two writ petitions, my lord, challenging the notice issued by the respondent police My lord, after stay granted by this court, my lord, recently I obtained the copy. Charge sheet is filed. In A8 and 9, there is no evidence and drop the charge sheet this present two petitioner name. I produce the charge sheet number.
Yes, silly. Who is appearing this? You are appearing?
Patil will appear.
Patil will appear.
482 ಇದೆ.
$480 GM.
Red with 482 ಇದೆ.
Red with 480. ಯಾವತ್ತಮ್ಮ 482 ಆಗ್ತಾ ಇರೋದು? ನೆನ್ನೆ ಒಂದು ಡೇಟ್ ಕೊಟ್ಟವಲ್ಲ?
ನಿನ್ನೆ 13 ಜುಲೈ.
Released on 13 July.
ಇದ್ರ ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಇದ್ರಲ್ಲಿ.
ಏನು?
ಇವ್ರು ಏನ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿರೋ ತನಿಖೆಗೆ ಬಾ ಅಂತ ಹೇಳಿ ಇವ್ರ ಆರೋಪಿಗಳು ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಇವ್ರ ಮೇಲೆ.
You don't want to. It's over ಅಲ್ಲ ಮತ್ತೆ.
Oh.
And counsel for the petitioner has filed a memo. He submits that the notice which had been issued against the petitioner have been recalled. In that view of the matter, nothing survives in the petition.
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಇವ್ರ ಆರೋಪಿನೇ ಅಲ್ಲ ಅಂತ ಬಿಟ್ಬಿಟ್ಟು.
It stands disposed.
Great.
ಎರಡು petition. 4 matters. List number 1. Serial number 2 is Anand.
54.
Serial number 15. Vinayan.
Apologies, but
yes, said.
But this issue relates to not fishing rights. But the issue was as to whether not in respect of lift irrigation tanks, not the tanks have to be given not by way of auction or not was the issue in the earlier
lift irrigation.
Lift irrigation. Not there was the bifurcation made by the state government.
Yes.
In respect of tanks not which are falling within the jurisdiction of not lift irrigation and tanks not which are rain-fed tanks. But their societies not had filed a writ petition not, including this petitioner's not his society. He is the president of a particular society. They filed a writ petition before the Honorable Court. But they can take my lords not to the interim order at page 37 in that writ petition.
Yes.
But we pointed out that insofar as not the fishing policy is concerned, wherever it's not these rain-fed tanks are concerned, first priority should be given to society. And whereas they had issued an auction notification. But this interim order dated 25/3/26, please turn to note.
That petition is still pending.
That petition is still pending.
And why are you filing this?
This petition, not what happened was, that petition not we had the society had also challenged the auction notification. But in the auction notification, Lord, the petitioner herein had participated. And in this Honorable Court not passed an interim order saying that insofar as tanks which are rain fed, they should be excluded.
Yes.
Lift irrigation tanks not they can not there is no interim order granted. No, please turn to bottom of the order dated
So
25/3.
the interim order was only to lift irrigation and rain fed tanks should go ahead.
No, vice versa, Lord.
Sorry, rain fed tanks cannot go ahead.
Yes.
Lift irrigation can go ahead.
How?
Because it
Now,
comes under this
correct. Now what happened was not annexure A at page 27 was the tender notification that was issued.
This is for what tanks?
No, this is for not about several tanks were there, but I am concerned with
lift tank or the.
But it included both.
Both.
That is why not it was challenged. At serial number 1, not few of the lakes are mentioned. Auction for fishing rights in Jodi, Timblapura tank, Shettigar, etc., etc. Now, Lord, if my Lord then turns to page 30, this petitioner had participated. Lord, he was declared as H1, Lord, the highest bidder. After this, Lord, they did not take it forward. The interim order that was granted by the Honorable Court said, insofar lift irrigation, the court is not interfering because there's another writ petition also. Court declined to interfere with so far as lift irrigation is concerned. So that virtually, Lord, has not been troubled. Now, Lord, what they are saying is, despite I being successful bidder, they are now saying there's a writ petition that is filed. In the writ petition, the court said insofar as lift irrigation, you can go ahead. In respect of the rest to rain fed, it cannot be gone ahead. But I bow down, of course, insofar as other tanks, we're not going to ask. But even in respect of 5 tanks which come under lift irrigation, they are saying we are not going to give it to you. We'll call for fresh tender. Fresh tender is called for.
Where is that? They've issued an endorsement?
Yes, Lord. Annexure K, page 42.
42.
Please. Can I request Lords, please turn to page 43, Lord.
Yes.
ಅಲ್ಲಿ ಉಲ್ಲೇಖ ಪತ್ರ 3 ಅಂತಿದೆ. ಉಲ್ಲೇಖ ಪತ್ರ
3 ಏನು?
ಹೌದು.
ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ 7194. That is the other proceedings.
ಹೌದು, that 7194 is that writ petition.
Yes.
ಕೆರೆ ತುಂಬಿಸುವ ಯೋಜನೆಗಳಲ್ಲಿ ಮುಖಾಂತರ ತುಂಬಿಸುತ್ತಿರುವ ಸಣ್ಣ ನೀರಾವರಿ ಇಲಾಖೆ ಕೆರೆಗಳ ಮೀನು ಪಶುವಾರ ಹಕ್ಕನ್ನು ವಿಲೆ ಮಾಡುವ ಕುರಿತಂತೆ ಈ ಟೆಂಡರ್ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಮುಂದುವರಿಸಲು ಅನುಮತಿಯನ್ನು ನೀಡಲಾಗಿದ್ದು, ಪ್ರಸ್ತುತ ಮೀನುಗಾರಿಕೆ ಇಲಾಖೆಯಿಂದ ಮೀನು ಪಶುವಾರ ಹಕ್ಕನ್ನು ವಿಲೆ ಮಾಡಿ ಗುತ್ತಿಗೆ ಅವಧಿಯ ಚಾಲ್ತಿಯಲ್ಲಿರುವ ಕೆರೆಗಳು ಹಾಗೂ ಮಳೆಯಾಶ್ರಿತ ಕೆರೆಗಳು ಟೆಂಡರ್ ಪ್ರಕ್ರಿಯೆಯಿಂದ ಕೈಬಿಡುವಂತೆ ನಿರ್ದೇಶಿಸಲಾಗಿರುತ್ತೆ. ಅದರನ್ವಯ ಉಲ್ಲೇಖ ಪತ್ರ 4ರಲ್ಲಿ ಸರ್ಕಾರದಿಂದ ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಿದ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಸೂಚಿಸಲಾಗಿರುತ್ತದೆ. ತಾವು ಸಲ್ಲಿಸಿರುವ ಬಿಡ್ಡಿನಲ್ಲಿ ಒಟ್ಟು 7 ಸಂಖ್ಯೆ ಕೆರೆಗಳು ಪೈಕಿ 2 ಸಂಖ್ಯೆ ಕೆರೆಗಳು ಮಳೆಯಾಶ್ರಿತ ಕೆರೆಗಳಾಗಿದ್ದು, 5 ಸಂಖ್ಯೆ ಕೆರೆಗಳು ಏತ ನೀರಾವರಿ ಕೆರೆ ತುಂಬಿಸುವ ಯೋಜನೆಗಳ ಮುಖಾಂತರ ನೀರನ್ನು ತುಂಬಿಸುತ್ತದೆ. ಈ 5 ಕೆರೆಗಳ ಮೀನು ಪಶುವಾರ ಹಕ್ಕನ್ನು ಈಗಾಗಲೇ ಮೀನುಗಾರಿಕೆ ಇಲಾಖೆಯಿಂದ ವಿಲೆ ಮಾಡಿ ಗುತ್ತಿಗೆ ಅವಧಿ ಚಾಲ್ತಿಯಲ್ಲಿರುತ್ತದೆ. ಗುತ್ತಿಗೆ ಅವಧಿಯ ಬಗ್ಗೆ ಮಾಹಿತಿ ಲಗತ್ತಿಸಿದೆ. ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಮತ್ತು ಸರ್ಕಾರದ ಸೂಚನೆ ನಿರ್ದೇಶದನ್ವಯ ತಾವು ಸಲ್ಲಿಸುವ ಟೆಂಡರ್ ಅನ್ನು ರದ್ದುಗೊಳಿಸಲಾಗುವುದು ಹಾಗೂ ಏತ ನೀರಾವರಿ ಕೆರೆ ತುಂಬಿಸುವ ಯೋಜನೆಗಳ ಮುಖಾಂತರ ನೀರು ತುಂಬಿಸಲಾಗುತ್ತಿರುವ ಮತ್ತು ಮೀನುಗಾರಿಕೆ ಇಲಾಖೆಯಿಂದ ಮೀನು ಪಶುವಾರ ಹಕ್ಕನ್ನು ವಿಲೆ ಮಾಡುವ ಗುತ್ತಿಗೆ ಅವಧಿ ಮುಗಿದ ನಂತರ ಟೆಂಡರ್ ಕರೆಯಲಾಗುವುದು ಅಂತ ಈ ಮೂಲಕ ತಿಳಿಸಿದೆ.
ಈಗಾಗಲೇ 5 ಸಂಖ್ಯೆ ಕೆರೆಗಳು ಮೀನು ಪಶು ಈಗಾಗಲೇ ಮೀನುಗಾರಿಕೆ ಇಲಾಖೆ
ಅದು that was there, that term expires on 30th of this month. Now, Lord, when they issued the notification, they were aware that this expires on 30th. It's not that they did not know, but this has become a ruse for them to cancel the tender. But this honorable court note, if not again sees the interim order was respect of Lord rain-fed tanks. Page 37, Lord, is interim order. There, Lord, we had challenged the circular and Lord the
Fishing policy.
page 37, Lord, should get it, the interim order. Yes, Lord, we will not have much of say insofar as
your earlier notification was 21st February 26.
Please.
The interim order passed by the coordinate bench was on 25/3/26.
But what happened was, this tender was challenged, saying that society should be given priority. But this honorable court said, Lord, with the order dated 25/3/26, that the issue with regard to lift irrigation, Lord, I have to say that in other matter, Lord, the court said you cannot claim as a matter of right. But I'll place that also on record. This honorable court said when societies had challenged the policy of the government, saying that lift irrigation tanks is to be given by open auction.
Now, rain-fed is subject matter of 7194.
Yes, there the interim order is limited to
lift irrigation. There is another writ petition.
No, lift irrigation.
There is
Lord,
another
what
matter, Lord. That's coming up tomorrow. There is another matter, similar matter that is posted tomorrow.
On that, something is pending.
Yes, my lord. There was a fishing policy, my lord. Under the policy, they classified.
Subject matter of another writ petition. We'll take it along with that.
Yes, but tomorrow, my lord.
It's coming up tomorrow, my lord.
What is the number?
It is the writ
And
petition
AGA
number
accepts notice
7194, my lord.
for respond number 1 to 4. Connect to
7194.
no, 7194 is rain-fed.
Placed on record.
That orders they are placed on record. That's
That
rain-fed.
matter is coming up tomorrow. There is a direction to file an affidavit, my lord.
Correct. But what about lift irrigation? Is there any other litigation pending on that?
Litigation is not.
But this is
Because this is the lift irrigation tanks here.
No, my lord, the classification was in the policy, my lord. First thing is the primary thing is the policy. What my learned friend says. Initially, under the policy, the lakes are classified into different things. Lake under a taluk panchayat, lake under a zilla panchayat, depending upon the water spread area and also the lift irrigation. The lift irrigated lands, lakes come under the minor irrigation department. Initially, everything was controlled by the fisheries department. Then the policy was placed before the government, saying that because there is some cost involved in the lift irrigated, because they have to, the electricity cost to fill the tank. Now, my lord, what they thought was there was some reservation depending upon the lake size, my lord. It has to be reserved for a certain section of the people and also to the first society registered in the taluka. That's how the policy is classified. All that
that
was
is fine,
involved.
Mr.
Now, my lord,
Jafar.
what my learned friend says,
But
in
issue
the,
is
in the lift irrigation thing, we have to hold an open auction.
You
Subject.
already held the auction
Already
value as
held.
H1. You issued the tender on
Yes,
in
Manoj.
January.
Yes, my lord.
He was declared the H1
Yes,
in
Yes, my lord.
what is the date? On 23/3.
Yes, my lord.
He was declared H1. Then somebody challenged the rain-fed tanks, which are in the custody of the forest
The
fisheries
fishing
department.
department.
There's an interim order passed on 25/3, 2 days after being declared. Thereafter, now you issued a new notification saying that since this continued to be under the custody of the fisheries department, after that we'll issue a fresh tender.
It is regulated and it is, the auctions are held by the fishing department only. Fisheries department, the one which calls for the tender. Open
Even for
auction.
the lift irrigated.
Yes, yes, my lord. Because
We'll have it tomorrow.
I think these.
Yeah, we'll have it tomorrow.
I think let
There
my
may be
learned
some
friend verify
late
because
instructions.
No,
it is to the contrary to my, because Lord, this petitioner's society itself challenged that Lord, which have produced interim order. He is the president of the society.
And AG accepts notice for respond number 1 to 4.
Not a problem.
Connect with WP 7194 of 26. Relist
Tomorrow.
Tomorrow it is there.
Tomorrow.
Relist tomorrow.
Can I request for Monday? Not tomorrow. I have some difficulty. Gulbarga.
Then that matter will also fit.
Monday we already have 140 matters.
Tuesday. Then. My only difficulty is not here. The tender, Lord, they will go ahead with the process.
List on 30th. Yes. Monday 130 already dated plus 40 new matters.
But let them not.
IA 1 of 26 and 2 of 26 are allowed.
With regard to opening of the tender, Lord.
Anyway, when the writ petition there, it's subject to it.
Serial number
But
17.
for preliminary hearing itself, not can I request.
Preliminary hearing.
Great.
Ajay yaar.
One minute, sorry.
Yes. Yes, madam.
Lordships kindly appreciate annexure A, my lord.
Hmm.
This is tender called by minor irrigation, my lord.
Hmm.
My lord, now they say that, my lord, they have paid the money.
Hmm.
And there was a, lords may kindly see, 7/2/26, my lord, there was a circular issued by the government, my lord, for the minor irrigation to call for the tender, my lord. Lord, the fisheries, they don't have any provision to.
Then how did they do this? See, a citizen will go by what a department does. The department called upon him, my fisheries department called upon him to make
They have
payment. He has
confirmed
paid the
also.
money. Now, if
They
one
have
department says the other department doesn't have power, what will they do?
Because
That
yesterday
is
it has
the
been
issue, my lord.
confirmed, Manoj. Fisheries departments have
And
confirmed
this-
my payment and confirmed my tender also, Manoj.
This circular is
Yesterday.
much,
Extension.
Yesterday, I got the document
Give a
today.
copy to
circular
madam.
is much prior to the,
Hey, you sort it out. You appear for both. You appear for the state.
yes,
Because you will appear for both the fisheries and the irrigation, minor irrigation.
please, my lord.
What is your stand? Because we'll stay the notification because
Please, my lord.
can't have this diametrically opposite stand.
Please, my lord. I'll accept notice, my lord.
The learned AG accepts notice for respondents 1 to 8. I 1 of 26 is allowed. The submission of learned counsel for the petitioner is that a demand being made by the fisheries department on 15/6/26 for payment of a sum of rupees 1,35,519 for extension of the fisheries lease, fishing rights lease by 2 years. The same was paid by the petitioner on 18/6/26. The last date for payment as prescribed in the letter dated 15/6/26 being 36/26. A memo has also been filed today. Enclosing the extension letter dated 23/6/26 issued by the Fisheries Department.
Order
Wide
sheet, the last
government order bearing number so and so, page 3, dated 23/6/26. Learned AG
One
on
more
instruction
submission, my lord.
submits that a circular had been issued way back on 7/2/26, by virtue of which the above lake, the administration of the above lake was vested with the minor irrigation department.
And these
And on-
tanks come under the minor irrigation only.
And on that basis, she submits that the lands and the lake coming under the minor irrigation department, the fisheries department did not have any power
Please, ma'am.
to either extend, to call for payment of money for extension or extend the lease. Especially, it appears to be a dispute between two departments of the government, namely the minor irrigation department and the fisheries department, as to who has jurisdiction on the matter. Should we refer it to the committee, or you will
It
make
may be referred, ma'am.
in that way of the matter, in terms of the Karnataka litigation policy?
Please, ma'am.
The chief secretary
Please, ma'am.
is directed to refer the matter to the committee constituted
Please, ma'am.
to decide the dispute, interdepartmental disputes.
Interdepartment dispute.
Interdepartmental disputes. And the AGA is directed to place the
Please, ma'am.
orders passed by the committee before this court. Until then, until the next date of hearing, the notification bearing number so and so, e-tender notification number 6 of 26/27, relating to grant of fishery lease rights in respect of Nangli Dodkare, situated in Nangli village, Kasba Obli, Mulbagal Taluk, Kolar district, at annexure A, is stayed till the next date of hearing. Released on 28th July.
Please, ma'am.
By that time. If you get the order before that, you can mention.
Please, ma'am.
First, can I get a hand delivery of the order?
Why do you need hand delivery?
Today is the last day of the.
Nothing left.
Yes.
Obliged.
19. Ashok B. Patil.
Yes, madam.
Seek for short Passover.
No
madam.
Passover, madam.
Kind-
Morning it was opposed the Passover.
Kindly, he is on his feet in another court hall.
We'll dismiss it, file a recall application.
Kindly, my lord.
This has happened thrice. There was opposition in the morning. We gave you
He will,
Passover.
5 minutes, my lord, kindly.
Despite a Passover having been granted, none appear, the further request has been made by the counsel for the petitioner. In the morning session, as also in the earlier hearings, an adjournment had been opposed by the
My lords,
respondent.
kindly. I will,
Hence,
5 minutes, ma'am, kindly.
he was put on notice in the morning to be here. Hence, dismissed for non-prosecution.
Please, please.
Next.
Serial number 23. Srinivas PS.
Yes, Srinivas.
Challenging the order of the Deputy Commissioner and the Tahsildar, my lord. The Deputy Commissioner order is at annexure F64. Lord, I am holding a puja rights. This is the Hindu Endowment Commission, my lord. As
The commissioner is not sitting.
he's
is
not
what-
sitting, my lord,
That is
and
why it was
before my lord.
Not sitting. CL ಇಲ್ಲ sir. By next week he will.
In alternate arrangement ilva?
ಯಾವುದು ಇಲ್ಲ. He's on CL.
We are not, he is entitled to take a CL, EL, everything. But when he is not sitting for 2 weeks, is there not an alternate arrangement?
No, alternative ಏನು arrangement ಇಲ್ಲ ಅಂತ.
Then they'll have to come to this court for all this.
Next week ಅಲ್ಲಿ ಬರ್ತದೆ.
ಅದುವರೆಗೂ their puja rights will go.
Lord,
These are all emergency matters. There should be some alternate arrangements.
Yes, my lord.
Lord,
Yes.
one submission, please.
Hmm.
Okay, for the caveat of this.
Hmm.
So I am none other than the brother of the petitioner. And my
In
another
all
brother-
these matters, the brother only.
No, my lord. Another brother has already taken charge on Saturday.
Hmm.
And he is performing his puja. His turn will come to an end tomorrow, please. Ma'am. My turn will commence from 26th to 29th. Ma'am. 4 days I'm having the turn to perform.
4
puja.
days only.
4 days.
That is why I am before.
That's,
No, what has happened
my
is
lord,
this.
he has been performing as per the that impugned order what he has agreed before the Honorable Court has already been implemented, and another brother has taken a charge, my lord. When because the order of the DC was passed in the month of March, my lord. 26/3/2026 was the date of passing of this order by DC, my lord. They kept quiet for all these days, and now they have approached the commissioner after lapse of 2 months, my lord.
Kindly see
Now
the DC
they
order.
are depriving my right to perform puja for 4 days.
Kindly see the DC order, my lord. May I request my lords to pursue the DC order at page 76, my lord.
76.
76 is the Adesha, my lord, where the DC, my lord, directs the Tahsildar to look into the matter and allot puja, my lord. The Tahsildar, my lord, what he does is this, my lord. on 24/12, my lord, 24/12, he allots pujas for all the archakas of the temple, my lord, on 24/12.
Where is that order?
24/12 is at page 78, my lord, where the third respondent is not included in this, my lord. Tahsildar makes this order. Thereafter, my lord, again at annexure H, annexure H at 27/4/2012. Yes, my lord, I have been placed at second.
He is still September 31,
My lord, yes, I am
For
there.
which
my
year
lord.
is this?
This writes, my lord, this is for 2025, for the year 2026. My lord, I have derived my rights by way of annexure A at page 37. What my learned friend is saying, my lord, yes, I am his brother, my lord. The third respondent is my brother. But I have derived my right through a will from my uncle.
Now we are in June.
Yes. Kindly see, my lord, my brother.
April in the April 3 to
June
28th.
15th in the July 31st.
June 15th
Original
to
it was
31st is MD Rajshekhar.
Yes. Original, this was the understanding, my lord.
You are the MD Rajshekhar is the petitioner.
Yes. 37 is the will in which I am claiming my puja rights from my uncle, not from my father. Now the respondent number 3 claims, my lord, that he is claiming rights from his father, from my father.
What happened to this order?
This order is still existing. This order is not cancelled at all. This order is not, but annexure H, after the DC order, my lord, Tahsildar takes up the matter at annexure H, page 80.
Annexure G is by the Tahsildar.
Yes, that is kept in abeyance. That has not been touched, my lord. As on today also, it is still existing. Annexure H at page 80. Tahsildar makes one more order after the DC's order, stating that please give me documents in regard to my father's puja sardi at page 81, my lord. Then on 19/5 at annexure 82, page 82, my lord, annexure J.
ಯಾವ ಅವಧಿಯಲ್ಲಿ
ಪೂಜೆ ಸರದಿ
ಮಾಡುತ್ತಿದ್ದ ಬಗ್ಗೆ ಸಕ್ಷಮವಾದ ದಾಖಲೆಗಳು ಕಂಡು ಬರೋದಿಲ್ಲ
ಇಲ್ಲ
ಈ ಬಗ್ಗೆ ನಿಮ್ಮ ತಂದೆ ತಾತ ಸೋನ್ಸೋ ಕೊಡಿ
Lord, annexure J at page 82. When this is still existing, my lord, without even a report or without even submitting any documents, the Tahsildar makes an order to give puja rights to respondent number 3 at page 84. Kindly see, my lord. All the 3 brothers' names are there. Rajshekhar's puja sardi is changed. And then Kalsappa, who's the respondent number 3, that is my brother, my lord, is also given puja rights. From May 1st in the June 15th.
Kalsappa will start from 16 July.
My lord, I'm sorry. Kalsappa will start from May 1st, the last table.
May 1st to June 15th is over.
Yes, July 16th
Next
till
is
the
July
31st.
16th to 31st.
Yes, this is what this order was, my lord.
So who is there now?
Now, my lord, what happened, my lord? After this, my lord, when
you are there from 16 to 30th.
No, my original rights, my lord, was from April 3rd to April 20th.
Now till 30th, there's no problem for you.
No, but they've changed it again. Tahsildar, after this order, is again changed it.
Another order.
Yes, without even the Tahsildar, my lord.
All these orders, which is order you're challenging?
Sorry, 97.
97.
Annexure L. When this order is passed, my lord, on my back, my lord, they passes one more order, my lord, changing the puja sardi again. Kindly see now, my lord, Kalsappa.
June 15 to June 20th.
Yes. 10 days, 5 days.
21st to June 25th. Jeevan Kumar. June 26 to June 30 would be Kalsappa.
Yes, Jeevan Kumar has already finished his sardi. If my lord sees the 24/12 order of last year, where Tahsildar decides to in the year 2026.
Why was this altered now?
No reason, my lord. So moto, this is taken up and been altered.
So moto?
Yes, nothing has been stated why this was altered. And kindly see, my lord, there was also a direction given to the RI to investigate in this matter. And the third respondent himself claims that he does not know when his father was doing puja. Kindly see page 136, my lord.
Yes, why did you do so moto?
I'll take instruction, my lord.
I'll have it tomorrow because tomorrow is things come to an end.
Lord,
Even as per this, so that for next 1 week he can do it.
Yes, ma'am.
Why so many changes are happening without any application?
I'll take instruction, my lord.
Yes.
I may permitted to rely upon one document, my lord, wherein it's the contention of the petitioner that father has not been performing puja, my lord. And it is the admitted fact by the petitioner.
Even if it is, how did this happen so moto without notice to him?
Even my period has been diminished, my lord. I was given 15 days time earlier.
It's up to you to challenge or not. He is challenging it. He is challenging it for a simple reason that he was not issued any notice, he was not heard in the matter. And this has been taken up so moto. How could a change happen of a vested right once it was finally determined? If it has to be redetermined, notice has to be issued.
My lord, before the deputy commissioner, my lord, all the parties have been heard, my lord. Annexure F is the order of the deputy commissioner.
There is no problem. That has got changed. That's the problem.
My lord, after hearing all the parties, it has been directed to the Tahsildar to allot the turn of the puja. Accordingly, Tahsildar has implemented DC order.
Yes, sir. That would be like we pass an order now and ask the court officer to list it on some day. Interim order vacated and ಬರೀತಾರೆ. ಪರವಾಗಿಲ್ವಾ?
ಪರಿಷ್ಕೃತ ಮಾಡಿದ್ದು.
Can't be doing that without hearing.
Yes. And he has
AGA
admitted in
accepts
the
notice for respond number 1 and 2. Shri HR Manjunatha, who is filed caveat, accept notice for respond number 3. Learned AGA is direct secure instruction, make a submission as to on what basis the matter was taken up and the impugned order dated 25/5/26 at Annexure L was passed. Since the submission of the learned counsel for the petitioner is that it was passed so moto, if that be so, the alteration of the rights of the petitioner without hearing the petitioner could not have been done via Annexure L. Release tomorrow at 2:30 p.m.
Tomorrow is late.
25th.
Tomorrow, let them not.
Tomorrow we are dealing with.
Serial number 43.
40?
43. K. Ravishankar.
Period for respondent, my lord. Short accommodation, my lord. Senior is held up in court.
Avare memo
matter,
ಮಾಡಿ.
my lord.
Who moved the matter?
I only moved matter, my lord. I apologize.
He is held up or he is not here?
He is held up in court on 26.
Then we will pass over. He can come. Pass
Sorry, my
over.
lord. He is held up in court on 26, my lord. So, part and matter, my lord.
We can finish that and come. We'll be sitting here till 5:15 at least.
Thank you.
Yes, next.
44. Sushal Tiwari.
Actually, in this, my lord.
Yes, Mr. Order.
Yes, please. Jan Chinnappa was appearing. For my lord, the petitioner. He's gone, my lord, to England because it's for admission of his son. ಅವರು ನನ್ನ ಹತ್ರ ಬಂದ್ರೆ ಅವರೇ ಇರ್ಪಾರಿಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಂಡ್ರೆ ಅವರೇ ಬಂದ್ ಮಾಡ್ತಾರೆ ಇಲ್ಲಾಂದ್ರೆ ನಾನು ಮಾಡ್ತೀನಿ
ನಿಮ್ಮ ಇಷ್ಟ. ಇಫ್ ಯು ಆರ್ ಇನ್ ಹರಿ,
ನನಗೇನು
ಡಿಪೆಂಡ್ಸ್ ಆನ್ ಯುವರ್ ಇನ್ಸ್ಟ್ರಕ್ಟಿಂಗ್ ಕೌನ್ಸಿಲ್.
ಒಂದು ವಾರ ತಗೊಂಡ್ರೆ ಅವರೇ ಬರ್ತಾರೆ ಪಾಪ.
ಡಿಪೆಂಡಿಂಗ್ ಆನ್ ಯುವರ್
ಫೈನಲಿ ಅಂತ ಆಗ್ಬಿಡಿ. ಟೆಂಡರ್ ಮ್ಯಾಟರ್ ಸ್ವಲ್ಪ ಅರ್ಜೆಂಟ್ ಇದೆ ಅದು.
ರಿಲಿಸ್ಟ್ ಆನ್ ವೆನ್ ಇಸ್ ಹಿ ಬ್ಯಾಕ್?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಯಾವಾಗಲಾರು ಹಾಕೊಳ್ಳಿ.
Then we adjourn one matter. Now he is not.
Please, my lord.
He is not going to be there for a week.
He's not there for this week. This week he is not here. Monday, Tuesday.
Monday. Because another matter we have posted on 30th for him.
Oh.
Relist on 2nd July. Interim order earlier granted is extended till next.
Wait for it. ಪಾಪ ಅವರದ್ದನ್ನು ನಾನು ತಗೋಬಾರ್ದು ಹಾಗೆ ಅವ್ರು ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಬಂದ್ರು.
It doesn't matter.
Lord, he has appeared. ನಾನು ಅದನ್ನ ಆರ್ಡರ್ ಶೀಟ್ ನೋಡ್ಬಿಟ್ಟು ನಾನು ಇವ್ರಿಗೆ ಹೇಳಿದ್ದು.
ಅವ್ರಿಗೂ ಟೆನ್ಷನ್ ಏನು? Interim order is 10.
Public advocate.
I appear for respondent number 20 minutes.
Lord, sorry, on the previous application, your lordship,
for respondent number 19, ordered notice. I'll take notice.
They already served it to the direction.
Yes, served us with a copy of the.
You've been
petition.
asked to take notice.
Yes, sir. Malat, the wakalat malat may file it within
can
2
file
days.
it. Yes. Yes, Mr. Ron.
Look, if they file their objections, this very
No,
short
sir,
point,
ready-
Milord.
we're ready to make submission.
You filed your objections.
Lords, I have not filed objections, but this is a writ against a statutory appellate order. The record of the appeal is, in my respectful submissions, adequate. There are no new facts.
It's your,
I placed very well. I'll argue on that basis. I've quite seen.
as long as you are ready to argue,
I'm
we have
ready.
no problem. Yes.
May I request on Wednesday, next Wednesday? Lords, I have some objection to an adjournment. Lords, on the last date also I'd mentioned to your lordships. I have a mining lease which is confirmed and extended till 2035 by the government. Now saying that, my lords, this issue is pending. They don't execute lease deed in my favor.
You have it till 2035.
Lords, every day, my lords, since 2011, I have not been permitted to work the lease, my lords. I've been waiting one reason after the other. my lords.
Before us, it came on 10th.
I quite see. I'm not, of course, I'm not saying this on. Lords, throughout delayed, my lords, appeal is.
Well, there is one issue with me also. My application for deemed extension is already pending. Using this very thing there, it should not be
Yes.
a.
When
bonus
will
to
you
delay
get
that.
ready?
Next Wednesday.
Most of the time, he is insisting on us to take matters. He is asking adjournment, we'll give it. Otherwise, he'll argue for 1 hour, we'll have. At the request of the Additional Advocate General, relist on 1st July.
Great. My lord, 30th.
30th.
Or second.
Request.
First there is.
Second is, yeah, both of you are going somewhere.
No,
on
no.
30th. Both of you are okay for second, not okay for.
He said, first is fine.
2:30.
First is fine?
No, no. First I have some difficulty. May I request for second?
Okay, whatever. Second.
Second.
Second at 2:30.
2:30, my lord.
2:30.
Great.
46, Archana Murthy, on connected matter.
Take the petition, your lordships.
Who is appearing for the respondents? Monish, Pavan, Mallikarjun. Chief Commissioner was direct to file an affidavit. Pass over.
47, Siddharth Tiwari.
Lords, may I request this to be taken up next week, my lords? My colleague was handling this work, my lords, and he has a personal difficulty today. We are told.
Request of counsel for the petition 16th July. 17th July.
Yes, my lords. The arbitration proceedings have been stayed 30th July, 30th.
This is the arbitration matter.
Yes, yes, my lords.
Why is the arbitration
Because
matter?
what has happened is, my lords, that this is a tenancy dispute between the parties, my lords. The arbitrator in the course of the proceedings, my lords, has directed the lessee to deposit a disputed sum. My lords, that is in contrary to the Supreme Court judgment, my lords. And failing which, my lords, the arbitrator has also passed strictures saying that your defense will be struck off. Now, I have no remedy, my lords. That's the reason I'm before you. Now, what has happened is, my lords, today, my lords, a disputed sum, my lords, during the proceedings cannot be deposited in the court or to be paid to them. They say pay the disputed sum also to them, my lords. That's the issue that we're facing with. Undisputed sum, my lords, we have paid.
When is it before the arbitrator?
3rd of July, my lords. 30th of June, my lords. I have no problem.
Hmm.
Because an appeal against section
How
16, my
many
lords.
in arbitration matter will not? Now, if the order is defense will be struck off, then what is left in the arbitration? See, if we don't intervene at this stage, 34 becomes a formality.
Settlement is also going on between the parties. It has been going on. They have kept on 30th.
No, my issue is, my lords, who do I pay? There are so many landlords, my lords. Landlords are having fight.
30th of June. 30th of June is. He list on 30th of June.
May I request interim order, my lords?
Interim order earlier is granted.
Is granted, my lords. The stay of
Interim order
proceedings.
earlier granted is extended. Then what is the? Yes.
48,
Yes, madam. Mr. Deshak.
counsel for the petitioner is informed that he
Paso, you are ready? Paso.
49.
Appearing for the respond number 4, my lord.
Hmm.
Last letter hearing also petitioners before this honorable court that till the interim measurement has been taken, that is the administrator has to be appointed to the petitioner. Fourth one may be permitted to distribute the salaries to the employees. my lord. It's very difficult that on 2nd March 2026, all the president and vice president secretary have given the resignation. From that day, we are not able to give the salary to the employee. That's the only prayer I'm seeking.
What is the interim order granted you?
The third respondent, my lord, he has no, without authority, he convened the meeting, my lord. So at that time, I approached this court. So this court said any decision taken shall be subject to, the decision shall not be given effect to. There's a complete, all the office bearers have resigned, my lord, vice president, secretary, treasurer, president, everybody.
The year 1918, state Sabha has been registered under the Mysore Society Registration Act.
Who are you appearing for?
I represent the manager.
Manager, he represents manager.
It's my duty, my lord, to take care of the society. No one is there.
Very nice. You are the manager
Please, my lord.
who is appointed on a salary.
Please, my lord.
You are not even a, you may be a member, but you are a member also of the society.
Yes, my lord. Everyone has to be a member of the society.
Any office bearer, any appointee also has to be.
No, I'm not, I'm the manager, but I'm not the elected member of the society.
So who are you?
Then I need to give the salary to the staff, my lord. It is my duty, my lord. That's the only prayer I'm doing, I'm making before this honorable. I'm nothing to do with the elected members.
No, now that everybody has resigned, they'll appoint an administrator.
That's no, my lord. Till then, the appointment.
Till then, naale appointment ಮಾಡ್ತಾರೆ administrator. How long does it take to appoint the administrator?
Till the time of taking charge of the administrator.
We don't want you to use any monies for anything. You act as per the instruction of the administrator. Whatever the administrator tells you, you do. Because you are not even a member.
Proposal is sent, my lord, to the
By when will you pass orders?
15/6, my lord, DRCS has sent a proposal, my lord,
By when will
pending
you, by when will you pass orders?
lordship.
Salaries have to be given until.
Directions may be issued, my lord.
Because salaries will be in the first week of July.
Please, my lord.
So you have only another 3-4 days for any action to be taken.
Yeah, I have
Otherwise, the
also-
manager's office will be
Please, my lord, I have
under pressure. Petitioner is before this court seeking for the following reliefs. The President, Secretary, Treasurer
court officer.
of the society having tendered their resignation. The meeting was conducted on 23/20/26, where certain resolutions had been passed. Since those resolutions were sought to be given effect to, the petitioner who are the other committee members are before this court seeking for the aforesaid reliefs. This court, the coordinate bench of this court, wide order date 23/3/26, stayed the operation of the resolutions passed pending consideration of the writ petition. The above writ petition has been filed seeking for a mandamus to the respondent to consider the representation dated 29/12/25, whereunder the appointment of an administrator has been sought for in terms of section 27 of the Karnataka Societies Registration Act, pending an inquiry under section 25 of the KSR Act.
And also I sought for inquiry into affairs of the society for
20 inquiry under 25, pending the inquiry.
Start ಮಾಡಬೇಕು.
Appoint the administrator pending the inquiry.
Yes. Sorry.
Respondent number 4 is represented by its manager who submits. Respondent number 4 society is represented by its manager who submit that how many employees are there?
8. 8 staff.
You are building artificially that there are 8 staff who need to be paid their salary. In that view of the matter, there being no other, his submission is that there being no other office bearers, it is the manager who has to take care of the disbursement of the salaries, etc. The manager, not being a member of the society, let alone an elected member, cannot be allowed to operate the said bank accounts when there is allegations made by intersay between the members as also elected members. In that view of the matter, what has been sought for being a mandamus, a time frame needs to be fixed for the respondents to consider the same so that the interests of the other are not adversely affected. As such, this court passes the following order. Writ petition allowed, a mandamus is issued. Respondent number 2 is directed to consider the representation of petition dated 29/12/25 at Annexure A and pass necessary orders by 30th of June 2026.
The interim order is not to give
Made
effect to
clear
the.
that this court has not expressed, it's made clear that the interim order earlier granted by this court shall continue in force till 30th June.
Proposal is sent, my lord. Your lordships may direct the ARCS to this.
Whatever.
Yes.
Whoever-
Because
because
I also got instructed them. my
if
lord,
we
to-
restrict it to one officer, the other officer says no.
Please,
The representation is for appointment.
please.
Serial number 50, N. Kumar.
Well, the appeal for petitioner, my lord.
Yes, Mr. Kumar.
It's under Senior Citizen Act, my lord. Wherein, my lord, a petitioner, my lord, being a mother, executed a gift deed, madam, as per Annexure B, my lord, during the 2018.
Naeem Pasha, where is the counsel for respondent?
There was a order lodged of hearing, my lord. The matter will be heard in his absence, my lord. Because, my lord, the assistant commissioner.
Say that, but in senior citizen matter, we'll have to hear.
No, my lord, this. Or what? Last time, ಬಂದಿರಲಿಲ್ಲ, my lord. Both Assistant Commissioner and Deputy Commissioner, my lord, have dismissed the application filed by the petitioner, my lord, saying that there is no recital to the maintenance, my lord.
Yes.
And also the allegation is, well, the allegation against the respondent number 3 is, my lord, she taken the petitioner for its medical treatment and by taking the thumb impression, my lord, at that point of time, by bringing her to sub-registrar office, my lord, she got executed that gift deed, my lord. That was the allegation, my lord.
Where is your complaint? Where is your complaint before the AC?
Can you see, my lord, annexure, my lord? Annexure E, my lord.
Page?
Page number 29, my lord. Page number 30, relevant para, my lord. Page number 2nd para, my lord. ಅರ್ಜಿದಾರರು ಮುಂದುವರೆದು ವಿನಮ್ರವಾಗಿ ಪ್ರಾತಿನಿಧ್ಯದ ಅರ್ಜಿದ ವಯಸ್ಸಾಗಿದ್ದು ಅರ್ಜಿದ ಕಾಣ್ತಲ್ಲ ನಂತರ ಅರ್ಜಿದಾರರೇ ಹೆಣ್ಣು ಮಕ್ಕಳು ಮತ್ತು ಗಂಡು ಮಕ್ಕಳ ಪೋಷಣೆ ಸಂರಕ್ಷಣೆ ಮಾಡಿ ಆರೈಕೆ ಮಾಡಿರುತ್ತಾರೆ ಹಾಗೂ ಅವರುಗಳ ಮದುವೆ ಮತ್ತು ಬಾಣಂತನವನ್ನು ಸುಭದ್ರವಾಗಿಸಲು ಸರ್ವ ಕಷ್ಟಗಳನ್ನು ಪಟ್ಟಿರುತ್ತಾರೆ. ಅರ್ಜಿದಾರರಿಗೆ ಅವರ ಪತಿ ಇಲ್ಲದ ಕಾರಣ ಸದರಿ ಸ್ವತ್ತಿನಿಂದ ಬರುವ ಆದಾಯದಿಂದ ಜೀವನ ನಿರ್ವಹಿಸಿದ್ದು ತನ್ನ ವಯೋವೃದ್ಧಿ ಕಾಯಿಲೆಗಳಿಂದ ಬಳಲುತ್ತಿದ್ದು ಮತ್ತು ಅರ್ಜಿದಾರ ಅವರ ನೆನಪಿನ ಸ್ಥಿತಿ ಕಳೆದುಕೊಂಡಿರುತ್ತಾರೆ. ಹೀಗಿರುವಾಗಿ ಎದುರುದಾರರು ಮತ್ತು ಅವರ ಗಂಡ ದಿನಾಂಕ 11/11/2009 ಚಿಕಿತ್ಸೆಗೆಂದು ಆಸ್ಪತ್ರೆಗೆ ಕರೆತರುವುದಾಗಿ ಕೊರಟಗೆರೆ ಕರೆದುಕೊಂಡು ಬಂದು ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗುವ ಬದಲು ಅರ್ಜಿದಾರರನ್ನು ಉಪನೋಂದಣಾಧಿಕಾರಿಗಳ ಕಚೇರಿಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಅಲ್ಲಿ ಅರ್ಜಿದಾರರಿಗೆ ಮಾಹಿತಿಯನ್ನು ಮರೆಮಾಚಿ ಕಾನೂನು ಬಾಹಿರವಾಗಿ ವಸ್ತು ವಿಷಯವನ್ನು ಮರೆಮಾಚಿ ದಾನಪತ್ರವನ್ನು ಮಾಡಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. And gift deed is for Annexure B, my lord.
In 2009.
Yes, my lord.
You have filed a petition in 23.
Yes, my lord.
After
Before
14
that,
years.
my lord, I filed a civil suit, my lord, seeking cancellation of the gift deed, my lord. It is also pending consideration, my lord.
Then you proceed in that proceedings, not
No, my
here.
lord, anyhow, my lord, it's a speedy remedy, my lord. I have no other means except that suit shall property, my lord.
Mr. Kumar, that may be true, but there is a document executed in the year 2009,
Yes, my lord.
and we are challenging it in 23 after 14 years on the ground that you are wrongly taken to this. How can we believe
No,
it
my
at
lord,
this?
before that they are taking care, my lord. Before that they are taking care of my lord.
You establish all these things in the suit which you have filed, which you
My lord,
filed in 2018.
my lord, till then let there be direction to pay some maintenance, my lord. The thing is, my lord, I don't have property, my lord. I don't have any other means for maintenance.
Where is the order of the Assistant Commissioner?
Kindly annexure F, my lord.
36.
Page?
36.
At page number 11, page number 34, my lord. Kone para, my lord.
34.
34 ಕೊನೆ ಪ್ಯಾರಾ my lord. 4 ಲೈನ್ ಕೆಳಗಡೆ my lord.
Yes.
ಹಿರಿಯ ನಾಗರಿಕರ ಪೋಷಣೆ ಸೋಂಟು ಅಧಿನಿಯಮದ ಪ್ರಾರಂಭದ ತರುವಾಯ ಯಾರೇ ಹಿರಿಯ ನಾಗರಿಕರು ತನ್ನ ಆಸ್ತಿಯನ್ನು ತನ್ನಿಂದ ವರ್ಗಾವಣೆ ಪಡೆದ ವ್ಯಕ್ತಿಯು ವರ್ಗಾವಣೆಕಾರನಾದ ತನಗೆ ಮೂಲಭೂತ ಸೌಕರ್ಯಗಳನ್ನು ಮತ್ತು ಮೂಲಭೂತ ವಾಸ್ತವಿಕ ಅಗತ್ಯತೆಗಳನ್ನು ಒದಗಿಸತಕ್ಕದ್ದೆಂದು ಷರತ್ತಿಗೊಳಪಟ್ಟು ದಾನದ ರೂಪದಲ್ಲಿ ಅಥವಾ ಬೇರೆ ರೀತಿಯಲ್ಲಿ ವರ್ಗಾವಣೆ ಮಾಡಿದಲ್ಲಿ ಹಾಗೂ ಹಾಗೆ ವರ್ಗಾವಣೆ ಪಡೆದವನು ಅಂತಹ ಸೌಕರ್ಯಗಳನ್ನು ಮತ್ತು ವಾಸ್ತವಿಕ ಅಗತ್ಯತೆಗಳನ್ನು ಒದಗಿಸಲು ನಿರಾಕರಿಸಿದಲ್ಲಿ ಅಥವಾ ವಿಫಲನಾದಲ್ಲಿ ನ್ಯಾಯಾಧಿಕರಣವು ಸದರಿ ಆಸ್ತಿಯ ವರ್ಗಾವಣೆಯನ್ನು ಮೋಸದಿಂದ ಅಥವಾ ಒತ್ತಾಯದಿಂದ ಅಥವಾ ಅನುಚಿತ ಪ್ರಭಾವ ಬೀರುವುದರ ಮೂಲಕ ಮಾಡಲಾದುದೆಂದು ಭಾವಿಸತಕ್ಕದ್ದು ಮತ್ತು ವರ್ಗಾವಣೆಕಾರನ ಇಚ್ಛೆಗನುಗುಣವಾಗಿ ಶೂನ್ಯವೆಂದು ಪರಿಗಣಿಸತಕ್ಕದ್ದು ಎಂಬುದಾಗಿ ನಮೂದಿಸುತ್ತದೆ. ಇದರ ಅನ್ವಯ ಸದರಿ ಪ್ರಕರಣ ಸಂಬಂಧ ಅರ್ಜಿದಾರರು ತನ್ನ ಮಗಳಿಗೆ ದಾನಪತ್ರ ಬರೆದುಕೊಡುವಲ್ಲಿ ಮೇಲೆ ವಿವರಿಸಿರುವ ಸ್ವತ್ತನ್ನು ಉಲ್ಲೇಖಿಸದೇ ಇರುವುದು ಕಂಡುಬರುತ್ತದೆ.
ಮೇಲ್ಕಂಡಾಂಶ ಪರಿಶೀಲಿಸಿ ಅದು ಸ್ವಾಂಶ. Yes.
And further, my lord, DC, my lord, Annexure G, my lord, confirm the order passed by the Assistant Commissioner. At 11 pages, my lord, page number 37, my lord, second para. Wherein also, on the same ground, my lord, my appeal was dismissed by the Deputy Commissioner.
Yes, but 2009, that question still remains. From 2009, you are not challenged. You have filed a suit in 2018.
Yes, my lord.
When you filed a suit in 2018, that time also you did not come under 23. Now we are trying to do a shortcut, which cannot be permissible. You prosecute your suit.
Anyhow, I am entitled for maintenance, my lord.
This is not a proceeding under section 6. This is a proceeding under 23.
Otherwise, my lord, kindly have next week, my lord, let the other side appear, my lord.
Learned counsel for respondent petitioner submits that he would not press for the main prayer, but would seek for certain maintenance amounts to be awarded. None appears for the respondent to enable the counsel for respondent to appear, released on 16th July.
Serial number 51, CS Madhu.
Lord, I'm appearing on behalf of the petitioner. Lord, being aggrieved by the inaction of the respondents in not discharging their duties and non-consideration of the representations and requests made by the petitioner and the other villagers, I am before this court, my lord.
You want the respondent to implead in OS number 670?
Yes, my lord.
You are a party in that suit.
No, my lord. My lord.
Why do you want them to implead?
My lord, the petitioner is a resident and devotee of Sri Ranganatha Swami, Toreyalli, Herur Gram Panchayat, my lord. The said Ranganatha Swami temple is 400 years old, and the temple is under the control of Mujra Ilake.
You want to implead, you can implead yourself in that suit. You cannot ask for a mandamus directing the respondent to implead in some other suit which is pending where you are not even a party.
My lord, the Archaka of the temple died leaving behind his wife and children. That wife has instituted OS before the junior division civil Judge Gubbi, my lord. So in that she has sought permanent injunction restraining the PDO and other, the president of the Gram Panchayat to not interfering in the suit scheduled property, which is located within the premises of the temple, my lord.
Correct. So at the most, your petition can be public interest, which we cannot consider. We have no jurisdiction.
And
the relief that you are seeking for, we can't grant.
my lord, this court in writ petition 27 of 2018 has given judgment that it is the duty of the Tahsildar and other endowment officer to protect the public property.
Correct.
So, my lord, when she is claiming it as her own property, which is belonging to the temple, which is a Muzarai temple, which is a public property, the respondents are not taking any action in spite of representation.
His complaint and take action. We can't allow you, direct you to implead. He has brought some facts to your notice. Now you have put on notice, you have to take some, you have to pass some order on this. Yes, madam. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the legal notice submitted issued by the petitioner on 7/2/25 at Annexure L has not been replied to or acted upon by the respondent. His further contention is that respondents are not complying with the orders passed in WP number 27 of 2018 by this court at Annexure M. Apart therefrom, a relief has been sought for issuing a mandamus directing the respondent to implead themselves as defendants in a pending suit in verse number 670 of 23. Insofar as this last prayer is concerned, no such mandamus could be issued to the respondents to implead themselves in a particular matter which is pending. As regards the representation which has been submitted, whenever any representation is submitted, it would be required for the concerned governmental authorities or statutory authorities to consider the same and pass necessary orders, either accepting or rejecting the representation within a reasonable period of time. Needless to say, if it is rejected, it would have to accompany by reasons. Neither having been done, I pass the following order. Writ petition allowed. A mandamus is a relief sought for are molded. A mandamus is issued directing the respondents to consider the representation of the petitioner dated 7/2/25 at Annexure L and pass necessary orders within 30 days from the date of receipt or copy.
Grateful, man.
Serial number 52.
Yes.
Petitioners, your lordship.
What is this matter?
Your lordship, there is a surplus of amount which was deposited by the petitioner and respondent number 2 as an OTS.
OTS, then it will have to go before the other bench, not before this bench.
This is deposited before the civil court, your lordship.
Civil court, not
Yes,
sufficient.
No, your lordship.
That counsel for respondent seeks fund is granted.
Please, my lord.
How much time do you want?
1 week, my lord. Or maybe direct them to serve a copy to me.
Serve a copy.
Yes, your lordship. We will do that.
Counsel for the petitioner is direct furnish one more set of the petition along with annexures on the counsel for respondent who seeks for and is granted 10 days time to obtain instructions and make his submission. Relist on 16th July.
Grateful, your lordship.
Grateful.
Serial number 53 adjourned. 54 along with serial number 2.
For the
Petitioner and
respondent.
Yes.
The
Which one do you want us to
54.
take? 2 or 54?
54 first.
54.
In 54, we had served the respondent a copy. In serial number 2, it was a fresh matter, therefore. As in 54, the petitioner is a company who had, the respondent had
Ready, Kasif?
Yes.
Yes.
But note, currently the work order has been issued and the work is underway.
my lords had held the observation on the last date that we
Matter had
had,
come up for interim prayer, my lord, 2 months back. No interim
Order will be
prayer.
subject to
Please,
retribution.
that the petition was served prior to the issuance of the letter
Yes,
of
please.
acceptance.
52 ಏನಾಯ್ತು?
Yes, go ahead.
Yeah, the petitioner is an electrical company engaged in the business of electrical engineering, and the respondent had issued a issued a bid for the substation and other electric work. It was a two-bid system under which first the petitioner had to qualify under the technical process before the commercial process. On the required date, that is in the month of February, the petitioner submitted its application and the same was accepted. The petitioner was evaluated and declared 2 months of time has passed, and but on the date of commercial bid, which was on the 18th of April, the petitioner was disqualified. If I may just take my lots to Annexure M at page number 39. That was the day before the financial bid, on 17/4, the respondent issued a communication confirming that the petitioner has qualified and the commercial bid is opening on the next day, that is 18/4/26. Thereafter, at Annexure N, my lords, at page number 40, apologies, if page
40.
number 40, the petitioner received that the email that the opening of the commercial bid is at 9:15 a.m. Immediately after, at 9:48 a.m., the respondent issues a communication disqualifying me from the financial bid.
Is that communication?
That is Annexure A at page number 16, my lords. So I have qualified under the technical bid. I have qualified and they've taken 2 months time. The day before they have intimated me, and then on 18th of April, they say that I am disqualified. Just the bid was scheduled to open at 10:30. I have received an email at 9:15. The grounds that they have taken is that the solvency certificate given by me, produced by me at the time of the technical bid, did not meet the requirements. My lord, the solvency certificate, if I may take my laws to Annexure R at page number 48. Now, there are certain documents which come under the CVC guidelines that are shortfall documents. In the event the respondent feels that certain documents produced at the time of the technical bid are insufficient, the respondent can call upon the petitioner to make good the shortfall. My lords, Annexure R at page number 48 is another tender in which the petitioner has taken part in, where the respondent has called upon the petitioner to produce the shortfall document. If I may take my lords to page number 48, it says this has reference to your offer for the subject work. While scrutinizing the technical bid, certain observations were made and the same are brought out in Annexure 1. You are requested to submit the required document as mentioned in Annexure 1, failing which your tender is liable for rejection. No further communication will be made in the above. I may take my loss to page number 49, the next page. At point number B, they mention that the solvency certificate has to be submitted. So it is not that there are several tenders in which the petitioner has taken part in. The petitioner and respondent have been working together for almost close to 40 years. So there are several other bids where the petitioner has been successful, in certain which they have identified there are certain shortfall documents. The respondent has called upon the petitioner to produce the necessary documents, and thereafter, if it had to be, and if the requirements were met, they have gone ahead for the commercial opening. In this present case, they qualify me. They say I'm technically competent. The morning off also, they say at 9:15, they send a mail saying it is opening at 10:30. At 9:48 or so, they say I'm disqualified. And the CWC guidelines, which the respondents themselves have produced in their objection, it allows that in the event there are certain shortfalls, the respondent may call upon the petitioner to produce the necessary documents. I have produced that in several other tenders, and right now which I have produced at Annexure 8, this has happened. There have been documents that I have not, and I'm specifically going on the solvency.
This is the only ground, solvency certificate.
Notice has not been given. I have not received anything. I have qualified and then disqualified.
Yes, Mr. Kassim. But once you hold them to be technically qualified.
Lord, I never held them technically qualified. Now, Lord, there are two stages of tenders. And these are, Lord, tenders held through the GEM portal, Lord, government e-procurement site GEM portal. And Lord, at the time of submitting the bid, Lord, if the bidder submits all the document, Lord, on that day a notification will come saying that you have submitted all the document, therefore you are pre-qualified. Lord, that's a pre-qualification criteria
to be able to submit all your.
This submission is not pre-qualification.
No, my lord, to be able to submit your bid, you'll have to upload all the eligibility documents that are mentioned in the bid. My lord, once you submit that, my lord, on that day you will receive a notification saying you've been qualified. But my lord, the communication was issued, my lord, not on the same day. I have produced along with my statement of objections and extra, my lord, R3. My lord, on 17/4/26 itself, my lord, we have informed him that the certificate
R3
given
page
does not
number?
meet the eligibility criteria.
R3 page number?
My lord, page 34, my lord, of my statement of objections.
Against solvency on 17/4 you informed.
17. Now, my lord, may I just invite your lordship's attention to, my lord, annexure R2. Annexure R2, my lord, at page 25.
This is 17/4. Your rejection is
17/4. My lord, that is my rejection letter. My lord, he sent an email in the morning saying, why is it rejected, so on. We replied to that. That is what my learned friend has produced it now to show. Morning I have rejected.
14/1/26 is what when they got the message from you.
Yes, my lord.
This rejection, what you are relying on is 17/4/26 after 4 months.
Yes, my lord.
Where is the earlier order of rejection?
My lord, one day before the opening of financial bid, we have rejected it.
You waited for 3 months for that to happen.
My lord, what happens is, I'll my lord, take your lordship through that. My lord, what happens is, if my lord takes annexure R2, page 25, my lord, in the middle, your lordship will find essential pre-qualification criteria.
Yes.
Now, my lord, I'll invite your lordship's attention to page 26, clause 3. The solvency required will be 40% of the approximate estimated amount put to tender. The solvency certificate shall be procured from a nationalized or scheduled bank and issued within a period of 12 months from the final date of submission of tender. So your solvency certificate should not be older than 12 months.
Issued, scheduled bank and issued within a period of 12 months from the
Final date of submission of tender. Now, my lord, your solvency certificate should not be older than 12 months. Now, my lord, I will invite your lordship's attention to page 24, annexure R1. Lord, this is the document submitted along with the tender. Lord, this solvency certificate is dated 27/1/2025. Lord, date of submission of the bid, Lord, was 18/2/2026. Beyond the period of 12 months.
Yes.
Lord, now if, Lord, the manner in which this is conducted, I will invite your lordship's attention to, your lordship may have page 28, my lord. I will read clause 5, please. No, that point is clear that solvency certificate is not within the 12-month period prior to submission of the bid, my lord. That I've made it clear to your lordship. Now, my lord, clause 5, if I may read.
Which page number?
28, my lord. Clause 5. Contractors, agencies are subject to be disqualified.
Just 28 of the petition.
Of my statement of objections. Same.
Yes, 28.
Contractors, agencies are subject to be disqualified even though they meet the pre-qualifying criteria if they make misleading or false representation in the request. Statements and attachments submitted in proof of qualification, including holding of information, so and so. Now, my lord, we received the documents. It's not that, my lord, we have not received the document. If your lordship sees that document, my learned friend took your lordship through. We don't say, my lord, he is qualified. My lord, that is, my lord, auto-generated from the GEM portal, which indicates that, my lord, he submitted all the documents. My lords will get that at page 37, annexure L. If your lordship sees the date, my lord, it is the same date as the date of submission of the bid. My lord, date, your lordship, somewhere in the center, my lord. 18/2/2026. This is the date on which my learned friend submitted his bid. Therefore, it was shown as qualified. This does not indicate technical qualification. Prior to the opening of a commercial bid, I'm entitled to disqualify if document submitted in view of the eligibility criteria is not correct.
What is the other column? Qualify status? Status, qualify status. There are two columns.
Qualifying status, that is subject to, is earnest money deposit to be made, subject to fulfilling all those criteria.
That is next up.
That is next. If they, in fact, if they don't deposit EMD, they will not even show in this picture because they will not be entitled to build it. If your lordship see the next page, page 38, some people who have not submitted EMD, bids have been auto disqualified.
Hmm.
No, so that's the thing. Now, my lord, petitioner submitted all the documents, my lord, no doubt. But my lord, the document submitted for solvency certificate was not what the tender was called for.
That's, I'm not denying
And
that I
one
have.
second, I'll just finish.
Hmm.
Now, my lord, the commercial bid was due to be opened on, my lord, 18/4/2026. Now, my lord, on 17/4, before opening of the commercial bid, well, my lord, the certificate was seen. In fact, my lord, if your lordship sees page 46, annexure Q along with the writ petition. My learned friend says, my lord, this is the solvency certificate I submitted, 15/11/2025. Lord, what is actually uploaded is what I've produced along my statement of objections. That was 12 months prior, not within the criteria. And therefore, my lord, he is disqualified. My lord, he has understood the terms of the tender condition. His solvency certificate ought to have been 12 months prior to the date of submission, which was not. Therefore, my lord, we have disqualified him. That, my lord, my learned friend challenges before this honorable. We have strictly, my lord, adhered to the tender conditions. Nothing more, nothing less.
Yes, madam.
And I'm not
And
denying
my lord,
that the.
they don't deny that it is this certificate that they have produced. Lord, along with my statement of objection, the certificate I produced, they don't deny that I have not produced this. This is what they have produced. This is what I have downloaded from the GEM portal, my lord, as a tendering authority. And my lord, because it did not meet the criteria, my lord, we are disqualified.
Hmm.
I'm not denying that the solvency certificate was produced was the previous years. This was by an oversight. But we have worked with the respondents over several years. And in several tenders where certain documents have come within the shortfall, there's a period of 2 months, my lords, from the date of the technical bid opening, 2 months and then the financial bid. During that time, generally, we have received, which is why I brought on record certain other tenders where specifically a solvency certificate where there was an issue, the respondent has requested in a separate tender, I'm clarifying that once again, that there was an issue with the solvency certificate. It came within a shortfall document. They have requested us to submit it and then thereafter close that.
I will answer that point as well.
What provision do you ask for that?
Hello?
If somebody has not submitted a proper document,
But I can answer that also.
under law, ask for it.
But
Then
the
everybody else will come. This is not there. That is not there. They
In fact,
should
I
have
can
asked.
answer that as well.
That cannot be done. Yes, answer.
My lord, page 48 of the writ petition, annexure R, which my learned friend relied upon saying earlier I have done so. My lord, in that case, my lord, page 49, if your lordship says about solvency certificate, my lord, document uploaded was correct. My lord, if your lordship sees the note there, my lord, in column B, in the center, solvency details provided in pre-qualification sheet and the uploaded solvency certificate are not the same. Uploaded solvency do not meet the pre-qualification. Therefore, we replied to him. Lord, he had mentioned a different date in the tender and the document uploaded was different. Therefore, we, my lord, sought for clarification on that. Lord, in every case, we don't have to, my lord, if they have read and understood the tender conditions, my lord, we cannot go around, my lord, each and every bidder to tell, no, you upload this, you upload that. No, that cannot be the correct position.
Since it has been done and the CVC guidelines allow for shortfall documents to be cured, my lord. Yes. And this is not the first tender that the petitioners have taken. They have
Next
done
time,
multiple.
be a little more careful.
Understand, because they have taken so many tenders before, therefore the.
Serial number 2, my lord, I don't know. My lord.
Let's finish this.
Yes.
Petitioner is before this court seeking for the following leaves. Respondent number 1 had issued a tender notification dated 14/1/26 calling for tender with respect to revamping of pipe bending, shop and drop tank hanger LT panels, lightings including new wiring at Aircraft Division HALBC. The petitioner participated in tender and submitted his bid application on 11/2/2026. The last date for opening of which was accepted to have been received by the respondents. The technical bid evaluation was postponed from 11/2/26 to 18/2/26. On which date the petitioner resubmitted the documents required. The petitioner contends that out of the total bidders, 4 bidders were pre-qualified as accepted by the respondents. The commercial bid being scheduled for opening on 18/4/26, the petitioner received a communication on 17/4/26 that the petitioner is not qualified. It is charging saying the petitioner is before this court. The submission of, what's your name, madam?
Priyanka Rao.
Priyanka?
Rao.
The submission of Ms. Priyanka Rao is that the rejection, that on verification, it's been found that the rejection of the bid of the technical bid of the petitioner at the qualification stage was on account of the solvency report not being for the particular year. Our submission is that if there was any shortfall or any defect, it was always available for the respondents to have called upon the petitioner to submit a proper document. In this regard, she relies upon Annexure R to the writ petition to contend that in one other tender where the petitioner had participated, such shortfall documents were called for by the respondent and furnished by the petitioner. Her submission is that it's not that the documents were not submitted. If at all there was any infirmity in the said documents, the respondent could have always called upon the petitioner to rectify the same and consider the same. This she submits more so for the reason that the petitioner has been performing works for the respondent for more than
40 years.
40 years. 40 years, you should have become expert by now.
That's light.
Mistakes happen, what to do? On that ground, she submits that the above writ petition is required to be allowed. Shri Kasif Learned Counsel, appearing for respondent number 1 to 3, would submit that there is no clarification which was required to be sought for by the respondent, inasmuch as the tender condition was clear and categorical in that, as per clause 3 thereof, the solvency required is to be 40% of the approximate estimated amount put to tender, and the solvency certificate shall be procured from a nationalized or scheduled bank and issued within a period of 12 months from the final date of submission of the tender. By relying on clause 3, his submission is that the solvency certificate was to be within 12 months of the date of submission of the bid document, which was 18/2/2026. That is to say, the solvency certificate ought to have been issued post 19/2/2025 and not earlier. The solvency certificate submitted by the petitioner in the present matter was dated 27/1/25, which is 1.5 months prior to the said date of submission, and as such falls foul of clause 3 of the tender documentation. His submission, therefore, accordingly, his submission is that, according to him, the petitioner ought to have submitted a solvency certificate which was dated after 19/2/2025. The submission of solvency certificate prior to that date does not enjoin any responsibility on part of the respondents to call upon the petitioner to rectify the defect and or supply any missing document or corrected documents. Insofar as the demand made in one other tender at Annexure R pointed out by the counsel for the petitioner, he submit that that was sought for on account of a discrepancy in the date of the solvency certificate, since the pre-qualifications, the solvency certificate produced at the pre-qualification did not match with the uploaded solvency certificate. And in that background, a clarification was sought for as to what was the correct date of the solvency certificate for the purpose of evaluating the petitioner technically. In the present case, there being no infirmity in the solvency certificate uploaded, there being no doubt about the date on which it was issued, there was no need for the respondents to seek for any clarification from the petitioner. His submission also is that there being several hundreds of tenders floated by respondent, if in each of the tender the respondent were to call upon the bidders to rectify and or comply with the requirements, then the whole purpose of issuing a tender would be lost, in as much as it is for the bidder to have complied with the requirements of the tender document to submit the same. Heard so-and-so peruse papers. The short question that would arise from in this matter is whether there was a duty cast upon the employer stroke tender issuing authority to call upon the bidder to rectify any document which was found to be in shortfall once submitted. Clause 3 of the tender
Notice.
Clause 5 of the tender document, page 28, is reproduced hereunder for easy reference. A perusal of clause 5 would categorically indicate that if there was any misleading or false representation in the request statements and attachments submitted in proof of the qualification requirements, including in withholding information and or have record of poor performance, etc. How is this attractive?
Like this is
not attractive.
It would be subject to disqualification if you withhold some information or wrongly submit.
There is nothing wrongly submitted.
But shortfall is there.
Clause 5 would like. Clause 3 reads as under page 26 of objections of the respondent. A perusal of the above clause would indicate that the solvency required will be 40% of the approximated estimated amount put to tender, and that the solvency certificate has to be issued within a period of 12 months from the final date of submission. The petitioner claims that the petitioner has been carrying out work, has been bidding and carrying out work for the respondents for the last 40 years. And as such, the petitioner cannot be said to be a lay person who does not know the manner and methodology of uploading the documents. The clause being very clear that the solvency certificate has to be within 12 months, it was but required for the petitioner to have uploaded a solvency certificate complying with clause 3. Though a solvency certificate has been uploaded along with the bid documents dated 27/1/25, it is around a month earlier than the last date for submission of the bid. Therefore, the same does not qualify the requirements of clause 3 of the tender documents. Now, coming to the issue of whether there was a duty on part of the respondent to call upon the petitioner to comply with any shortfall and or to rectify any mistake, though a submission to that effect has been made by learned counsel for the petitioner, I am unable to accept the same. As rightly contended by Sri Kasif, if in each tender, the tendering authority were to request for clarification, rectification, etc., then the whole purpose of issuing the tender would be lost. Inasmuch as it is for the tenderer to comply with the requirements and not for the tender issuing authority to enforce compliance. The compliance being voluntary, both the issues cannot be conflated. Both the issues operate on different fields and different circumstances. It is only when there is any doubt that the tender issuing authority can seek for a clarification. If there is a violation or non-compliance with any particular clause of the tender notice, there would be no duty cast upon the tender issuing authority to seek for clarification. In that view of the matter, I answer the point, this court answers the point raised by holding that in every case, it's not the duty of the tender issuing authority to seek for clarification and or provide an opportunity to the bidder to rectify the documents submitted. The tender issuing authority, in its own wisdom, if required to seek for any clarification, could seek for such clarification. Applying the above to the present case, the solvency certificate ex facie did not satisfy clause 3 of the tender document. Hence, I do not find this court does not find any infirmity in the rejection made rejection made of the bid at the technical evaluation stage. There's one other issue that would be required to be answered here. The submission of learned counsel for the petitioner is that there is already a qualification accepted by the respondent. That submission cannot be accepted since the qualification indicated in the web portal is only as regards the uploading of the documents, not the evaluation of the documents. Evaluation is a different aspect. Again, uploading and evaluation cannot be conflated with each other. Hence, that submission also cannot be accepted. No grounds being made out, the petition stands dismissed. What is serial number 2?
Serial number 2 is a similar matter, my lords, if I may be permitted to serve them. And
Serve it, let him get instruction. See, Pradeep Savkar accepts notice for respondents 1 to 3. He seeks for and is granted a week's time to obtain instruction, make a submission. He list on 10th July.
Please.
Serial number.
Well tried is what we can tell.
Grateful.
55.
Lord, serial number 55, my lord, I undertake to file wakalat on behalf of R1 and R3, my lord, in this matter.
Name is not shown correctly. Registry direct correct the appearance of the counsel for respond number 1 and 3 as Mr. Pradeep S. Savkar. Mr. Sharath, in what is this matter?
My lord, it's a challenge to the banking ombudsman's order. One of the fraudulent transactions.
No particular. None appears for the petition released on 17 July.
Please.
Anila.
Yes, Anil.
Appearing for petitioners, my lord.
Yes, please. Therefore, you received instructions?
No, my lord, we don't have the instruction, my lord. This declaration of the probation, my lord. I'll secure the instructions, my lord. Notice was issued on last date of hearing. I've already sent a letter.
Notice.
Last time only they have
10 days time to obtain instruction, make a submission is what you say.
Again, it is delaying, my lord, because probation was withheld, my lord.
See, we can't give Monday because Monday next week is, unless some emergency is there, we'll take it up. Otherwise, it goes on regular. And AJ seeks for, submit that he has not received instruction. He seeks for 10 days time to obtain instruction, make a submission. Relist on 17 July.
Fix the date, my lord, short date, because probation was withheld from the petitioner side.
17 July. If instruction are not received by then, who has to give instructions?
The Department of Health.
Respond number 3, na? 4.
The respondent number 1, my lord, because it is declaration of the probation. So I
don't want to put commissioner on this one. And who is the person who is to give you instructions?
The instructions, my lord, District Health and Family Welfare Officer.
The respondent number 3 shall be personally present before this court, if instructions are not received.
57. SDN Prasad. Connected matter.
57.1. My learned friend is filing a memo to withdraw the writ petition.
You're withdrawing
This-
it.
I'm for the respondent also. There are 2 petitions.
57.1.
57.1 petitioner is before this court. Memo filed reads as under. Accepting memo and submission dismissed as withdrawn. 57.
This connected matter arising out of an order passed by the Assistant Commissioner, where he had directed that the maintenance should be paid. Thereafter, subsequently, the Deputy Commissioner has passed that matter was carried in appeal before the Deputy Commissioner. That is impugned in this writ petition. So therefore, that writ petition does not survive for consideration. It is now withdrawn.
But the AC order was not clear. AC order was not clear whether he has ordered for the cancellation of the gifted or it paid a maintenance. They came to the High Court stating that the AC ordered for the maintenance and AC held that the gifted is null and void. We filed an appeal to the DC for the clarification of the AC order.
So now what about 57? What is to be done?
There are certain additional documents which I am required to produce. Kindly have it.
57 learned counsel for the petitioner seeks for and is granted 2 weeks time to file certain additional documents. Released on 17 July.
Interim order
Earlier granted is extended.
58. HC Shivramu.
Mr. Shivramu. ಏನಿದು?
Civil dispute, NCR ಮಾಡಿ. Civil dispute, police protection.
Consider the representation. Consider the representation.
Please, ma'am.
The petitioner is before this court seeking for the following relief. The grievance of the petitioner is that the representation submitted by the petitioner on 23/26 at Annexure H has not been considered. Then the offences under
Civil nature.
your illa bidi. Pass over, let us see if they come.
59, B. Nagarajan.
Mr. Nagaraja? Yes.
Last occasion is a government advocate is filed the FIR in the next state of hearing is taking adjournment in the last.
Without
date of
having
hearing.
complaint
Yes,
been
yes.
filed. Any complaint is there?
No, madam.
And why are you calling him?
I spoke with him, they're not calling it.
Not calling.
Just now I spoke with him, sir.
ಬರೀ ಫೋನ್ ಬರ್ತಾ ಇದೆ.
Yes, madam. Phone ಮಾಡಿದ್ರೆ and also
just ಮಾತಾಡೋದು. Just ಈಗ ಮಾತಾಡ್ತಿದ್ದಾರೆ. Also, we will also complaint ಇಲ್ಲ ಅಂತ ಏನೇ ಕರಿತೀನಿ ನಾನು ಕೇಳಿದೆ. ನಾನು ಮಾಡ್ತಿಲ್ಲ.
Oral remand, this is
ಇಲ್ಲ ನಾನು ಈಗ ಕೇಳಿದಾಗ ನಾನು ಯಾರನ್ನು ಕರೀತಲ್ಲ. ಜಸ್ಟ್ ಈಗ ಒಂದು ಅರ್ಧ ಗಂಟೆ ಮುಂಚೆ ಮಾತಾಡ.
We'll record his submission.
I'll produce call recordings. I'll produce call details. I'll produce next state of
All
hearing.
details you produce.
Please.
And AG on instruction submit that the petitioner has not been called by the jurisdiction police to come to the police station. Counsel for the petitioner seeks for and is granted 10 days time to place on record the call detail records.
Please.
Released on 17 July.
Serial number 60, Mahesh M.
This is a writ petition filed challenging the police notice, my lords. Police notice to the petitioner for seizure of gold.
Seizure of gold.
Complaint is for 22 grams. Now, complaint was given for 22 grams of gold against one Manjunath and who was running Gajalakshmi Finance.
Yes.
Which is in Hassan. The police notice, my lords, is at page 27. Now the police is asking me to produce the gold pledged by Netravati, Shravan Kumar, Peter and Danny. The complaint is for 22 grams.
Yes.
Police is now sought to seize 976 grams
They're
of
not
gold.
asking you to seize, they're asking you to produce. To
We have
ascertain
produced
which are
it.
the
Now they're trying to produce. I mean, seize the same gold, my lords.
Annexure B is only for production.
Now we have produced. Now they're trying to seize the same, my lord. That is why the writ petition is filed, my lords.
Based on the FIR, the articles are required to that effect, my lord. We will keep the articles till the investigation completed. Later on,
What he's saying is, the complaint is only for 22 grams.
Yes,
These Nethavati and co had deposited, hypothecated 950 grams.
And they are not the accused, my lords.
So if there are 950 grams which is there, why do you want to seize 950? At the most you can seize only 22 grams.
that I'll take instruction, my lord.
The instructions and Tajjan are the problem. Learned AG, the submission of learned counsel for the petitioner is that the complaint has been filed only as regard theft of 22 grams of gold.
Not theft, my lords. He has pledged it with one Gajalakshmi Finance, and they have closed the door. And he is not that Manjunath is not available for recovery of 22 grams of gold. Now the persons whom Netravati and all have they are the customers, my lords. They are not the accused in that FIR. Those people, whatever have pledged as a gold, now the police is trying to seize that gold from me, my lords.
What is their relationship with Manjunath?
My lords, in the annexure B, last 3 lines, my lords. ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಆರೋಪಿಯಾದ ಮಂಜುನಾಥ್ ಬಿನ್ ಲೇಟ್ ನಾರಾಯಣ ಮತ್ತು ಫೈನಾನ್ಸ್ ನಲ್ಲಿ ಕೆಲಸ ಮಾಡುವ ನೇತ್ರಾವತಿ ಹಾಸನ್ ನಗರ ಸುತ್ತಮುತ್ತ ವಿವಿಧ ಗ್ರಾಹಕರು ವಿವಿಧ ಬಗೆಯ ಚಿನ್ನಾಭರಣ ಕಡಿಮೆ ಬಡ್ಡಿ ದರಕ್ಕೆ ಗಿರವಿ ಇಟ್ಟಿದ್ದು ಸದರಿ ಚಿನ್ನಾಭರಣಗಳನ್ನು ನೇತ್ರಾವತಿ ತಮ್ಮ ಮಗನಾದ ಶ್ರವಣ್ ಕುಮಾರ್ ಮಂಜುನಾಥನ ಸ್ನೇಹಿತರಾದ ಪೀಟರ್ ಅವರ ಮಗನಾದ
They are not co-accused.
No, my lords. Accused is only Manjunath.
Notice clear ಆಗ್ತೀರಾ, but they're not accused. Submission of learned
Page number
counsel for the
31 is a
petitioner
FIR, my lords.
is that 22 grams of gold are alleged to have mortgaged with Gajalakshmi
Finance, Hassan City.
Finance, Sri Gajalakshmi Finance at Hassan City. And thereafter, the said gold has been pledged with with the petitioner by Ms. Netravati, Shravan Kumar, and
Peter and Danny.
Peter
and Danny.
and Daniel. The respondent police has issued a notice on 14/5/26 for production of the gold pledged by them. The petitioner having produced the same, the respondents are now seeking to seize the entire 950 grams. Learned AGA seeks for and is granted 10 days time to obtain instruction and make a submission as to why the entire 950 grams are proposed to be seized when the complaint is only as regards 22 grams. As also to make a submission as to whether Netravati so and so
That's
are
still then-
accused in any of the proceedings filed.
Interim order till then, my lords, not
Respondents are restrained from seizing the entire 950 grams.
976 grams.
976 grams. Correct, 976 grams till the next date of hearing. It would however be open for the response to seize 22 grams, subject matter of the complaint.
Much obliged, my lords.
Serial number 61.
In terms of the decision in so and so, the gold detail, in terms of so and so.
62.
62.
Anil Thomas.
Madhu, you will appear?
If I am given instructions to appear in this matter.
Shri Madhu N. Rao submit that you would be appearing for respondent 1 and 2. Registry is direct, print his name as such and delete the name of Shri N. Munni Krishnan as that appearing for 1 and 2. Ready?
Lord, only thing is, a gift city we'll have to, my lord, it's within India only. He'll give an undertaking, my lord, permit us to, my lord, give that 0.22 million because, my lord, there are deadlines. Huh?
Payment to, you have to make payment to.
Yes, my lord.
From
There are
this
deadlines, yes. And
coming
it's
to
within
you
city, my
only.
lord, I'll give it an undertaking also.
Absolutely, my lords, I have no instructions on this. My only submission in clarity, my lords, I'll come back as early as possible, my lords. If any time.
Tomorrow.
Tomorrow will be.
Early as possible. We already given you 15 days.
I just got.
When first month,
There's some, I must say, there's some inconvenience today and tomorrow, not for me, for my officers. So therefore, my lords, it may be taken on Monday.
Monday.
Please.
When is the last day for payment?
Please, my lord.
Last day for payment?
Ide.
So, see,
I
there are
understand.
other consequences which flow.
I understand.
Shri Madhu N. Rao seeks for and is granted 2 days time to obtain instruction and make a submission as to whether the petitioner could be permitted to make payments of the due amounts to Gift City.
Gift City. That Eddie, my lord, that is.
IFSCA, the International Financial Services.
No, it's all
Authority.
Gift City.
Gift City. Pre-list on 29th at 2:30
That
p.m.
very specific
30th
point.
ಆಗ್ಬೋದಾ?
On that very specific point.
ಅಷ್ಟೇ ಅವ್ರಿಗೆ
My
ಬೇಕಾಗಿಲ್ಲ.
lord, can it be on
The rest of the proceedings can go on. 30th.
30th ಯಾಕಂದ್ರೆ ಅವತ್ತು 2:00 ಒಂದು ಇಲೆಕ್ಷನ್ ಪಿಟಿಷನ್ ಹಾಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ 29th.
30th.
Please.
I got
Date.
it yesterday.
He gets one more day.
Lord, we can never grudge my lord giving him, my lord. Especially when he comes.
You are getting.
No, ultimately, my lord.
Serial number 63. Nagaraj Iyer.
Yes, madam.
My lord, petitioner is the papesh of owner, my lord. The deputy director, without intimating her, has removed 250 cards from her shop, my lord. She
Has
totally
removed?
had 250 cards. She
And
only
now how
have
many cards are there with you?
only 250 cards, my lord. I
This
had only
had come last
240.
time.
Yes, my lord.
Minimum guaranteed is 500 or 850.
800, my lord.
800, rural
Urban
area,
Urban area.
urban area.
Not received instructions.
We give you time for instruction. This is also on 10/6, 15 days. Because
The
We give you that
endorsement last
opportunity.
occasion I had pointed out, not
Then
the
we'll stay it
endorsement.
now. Learned AGA seeks for, and learned AGA seeks for,
Last occasion I had accepted notice, my lord.
I to saku 15 days. Now if we start adjourning, today it's come, we'll do it 1 month later.
Please, I will.
Learned AGA submit that she has yet to receive instruction, as such seeks for a short accommodation. Though no indulgence is required to be granted, such time is granted. However, the re-allot the cards ಹೆಂಗಮ್ಮ ಕೊಡಕ್ಕಾಗತ್ತಿದು? This prayer we can't give you. If you have asked a different prayer, we can't tell you what. This prayer we can't give you.
That's okay.
It is granted in the interest of justice. Relist on 9th July
Please.
In the fresh matter list, ma'am.
in fresh matters.
Great.
64, Ashwath CM.
For petitioner. Yes.
Praise for a short accommodation, my lord, to receive the instructions in COCA Act.
Please don't ask for time when it is listed. Kekoka. You challenge the permission.
Permission, approval.
And AGA seeks for and is granted 2 weeks time finally to obtain instruction, file his objection, get ready to address arguments. Relist on 17 July. It is made clear that no further adjournment would be granted.
65, Nikanta Sharma.
In this matter, I have been instructed to take notice for the respondent 1 and 2, my lords. I'll file my objections.
Yes, what is this matter?
It's related, I don't have the papers with me, but I understand it's something related to viva voce, my lords.
I have served the copy to the Vidyalata.
I have not.
I have
Is
served
only
only
today,
representation to be
to
considered.
consider the representation.
today I was informed, my lords. I don't know what the paper.
Prayer torso.
In fact, now I was informed, so I.
No need to adjourn. Where required you ask for adjournment?
Please, I'll look into it.
We'll direct you to consider the representation. You pass your orders in accordance with law.
Lords, the schedule itself, I'm not sure if it's infructuous, my lords.
So you inform him that it cannot be considered now.
My lords, 1/6/2026 to 11/6/2026. Wide intimation letter 30th of April.
His name was there in the initial list.
Yes, I'm not- that's
We have seen the papers. That is why his name was there in the initial list. He was called for interview. Subsequently, another list has been submitted where his name has been deleted for the viva voce. Viva voce is still not been held. So whenever it is to be held, consider it.
I may be
Petitioner
permitted to
is-
file my power, my lords. Week's time.
Nitin Ramesh submit that you would be appearing for the respondent. Register his direct print his name as that appearing for respondents on Vakalatnama being filed and delete the name of this BV Vidyalata as that appearing for respondent number 1 and 2. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that once earlier on 30th April 26, the petitioner was given intimation, 30th April, 10 December 24, he was intimated to participate in the viva voce. Subsequently, by way of a notification dated 30th April 26, his name is not found mention of, and as such he had submitted in the list and he has not been called upon to participate in the viva voce, and as such a representation had been submitted by the petitioner on 35/26 at Annexure A, which has not been considered. Since the representation has been submitted, it is for the response to consider the same and pass necessary orders, either accepting or rejecting the request made by the petitioner. Needless to say, if an order of rejection is made, it's to be accompanied by reasons. This being more so since the name of the petitioner was earlier called upon to participate in the viva voce, and now his name is deleted. Hence, this court passes the following order. Writ petition is allowed. mandamus is issued directing respondents to consider the representation dated 35/26 at Annexure A within a period of 2 weeks from the date of receipt of a copy of this order.
Great, great,
It is made clear that this court has not expressed any opinion on the entitlement of the petition.
great.
66. Sumati, yes.
Petition on this.
Yes, madam.
This is where actually access to the road has been blocked.
Yes, madam. Whether this ramp will obstruct the ingress and egress?
Look, I'm just producing some.
Yes.
Look, at present, they have raised the poles. Lots, it blocks the entire access, Milots.
That is what you said. That's why we are asking.
Yes, Milord. Now, Milord, before Milord, I mean, on this particular matter, Milord, what I would like to submit, Milord, for this road, NH earlier 207, which is now 648, NH 648, Milord, road was completed, construction was completed, and then Milord, police department and deputy commissioner's office came, I mean, approached us based on some public demand that there is a requirement of foot overbridge. So in across 80 kilometers, total 70 locations were identified that here this is required. And based on various safety measures, IRC, all these looking into this 17 locations were identified at 17 places where exactly it is to be located. So now one of this is where petitioner has some grievance.
She is not worried about you putting it up. She is only worried about her ingress and egress.
Yes, Milord, that is what
You are
Milord,
giving other people the benefit, taking away her benefit is
Milord,
what.
no, Milord. So that is what Milord, there is a Milord because it is right now it's under construction. So there is apprehension and you see lots of structure coming near your property. So if it is, I mean, understandable. But Milord, what information I have got, based on that, Milord, it is Milord that ingress egress are not affected.
No problem. We'll record that submission.
Yes, Milord.
What you do is you will give you 2 weeks time. You place on record the.
Milord, I have produced, Milord. If your lordship look at this photograph produced by them shows, Milord, it is blocked.
That
Measurement.
Just one. Photographs, what they have produced, you have produced is fine. You produce a sketch where the ingress and egress would be.
Yes, Milord. That is what, Milord, I mean.
Yes. Where is it?
Milord, first 2 pages, like I mean, have explained that how much we and all this. So now, if your lordship look at even in that paragraph 2, structural clearance and impact assessment, a physical verification and review of the layout plan at the site confirms that the ongoing construction poses no restriction to the landlord's right of way building setback. The FOB structure.
So that is the applicable rules. You have produced a line diagram. You have produced graphs. Instead of a line diagram, you could have produced a schematic of the location. Line diagram is only showing how the foot overbridge is.
18 meters away from the building and
place on record a sketch where they will have the ingress and egress. What is the extent of ingress and egress?
Yes, Milord. I will just, Milord, page 3, Milord. I mean, where diagrams are there, that drawing.
That's a line diagram of the overbridge,
Milord.
of how much you will climb, what is the height, etc.
Yes,
It doesn't give the access.
Milord, no. So, because Milord, they have to ultimately use this for their entry, Milord. There is a road, and on that, Milord, if your ship look at just next page, we'll get some idea, Milord. Next page where photographs are given.
Yes.
Milord, there is this building under construction is petitioner's building behind, Milord.
Yes.
Yes. And this here, that structure will come. And this structure, if your ship look at it, there is a width, which is mentioned also in the diagram, that what is the width. They say at least 3 cars can enter at a time. That is the width.
What is that? 6,000 mm.
Yes, that is a 6 meter. So they say it's a 2 meter, less than 2 meter is the car's width. So at least 3 cars can go together, and like that building, I mean, it's because they also will have some entry. It's a commercial building. There will be some entry. So 1 vehicle will go at a time. But still from here, 3 vehicles can go. It's a 6 meter, and there is a width left hand side, because this is coming in front of the vehicle, that 6 meter, that part. That is the width. If your lordship look at again that photograph, lordship would see that there is this second portion of the diagram comes in front of the building. Now when we look at the even height from that photograph, that height is more than 2-storied, Milord. So any vehicle can easily pass through.
Correct. That's why we are asking you, Instead of making the submission, put it on record that what is the width, what is the height.
That,
And,
that
make a
is,
sketch of the property, make the boundaries of their property. What's the problem in doing that?
we'll do that. But here, we have mentioned what is the height and what is the width.
Face a sketch, madam.
Please.
So it is clear that to everybody, not an interpretation later.
Yes, yes.
The counsel for respond number 1 and 2 submits that the ingress and egress of the petition's property would not be blocked. There would be a right of way of 6 meters, which would be provided, which is provided between the two pillars of the foot overbridge. The said submission answers the grievance of the petitioner for now, but Learned Counsel for respondent 1 and 2 is directed to place on record a sketch of the property of the petitioner with demarcating the property of the petitioner as also the national highway, identifying the location of the pillars and the gap between the pillars, as also the height of the pillars, to ascertain what is the width and what is the height which should be available.
That memo may be taken on record.
The counsel for respondent has filed a memo enclosing
Drawing and photograph.
technical comments, line diagram of the foot overbridge and photographs, which is taken on record.
Obliged. Date.
Released on 17 July.
Obliged. It maybe if it is clarified that there is no stay or interim order.
There's no stay.
But still, they are not allowing us to do work.
So long as the ingress and egress are not adversely affected, respondents are permitted to go on with the construction of the foot overbridge. They are not worried about the foot overbridge.
In case if it is obstructing, there will be demolition.
We'll get it removed.
That is
Order.
Once we get the sketch, we'll do that.
Obliged.
Hearing on IA, serial number 67. Yana Naik.
Tenar Naik, 9 Director, Karnataka State Tourism Development Corporation.
BL Sanjeev.
BL Sanjeev is Director to.
My humble request, Your Lordship, file the objection, detailed objection. In this case, only short point, Your Lordship, I am seeking direction to the authorities, direct the parking of airport, at airport, Your Lordship. Whatever vehicle we have attached to the case.
Just one. Geeta Devi has filed it. Compliance of office objection raised on SOB filed by Geeta Devi Papanna.
Yes.
Registry is directed print the name of Ms. Geeta Devi M. Papanna as that appearing for respond number 2. What is this impleading application that you have filed, Mr. Naik?
Impleading two authorities, Your Lordship, who are controlling authorities, Your Lordship.
They are from which department?
Same department, tourism department, Your Lordship. Tourism department and parking authorities. Assistant Transport Director. Assistant Transport Officer and Manager, Your Lordship.
This we can't grant you. What is this prayer, Mr.
No. My humble request, Your Lordship.
You have to comply with the applicable policy.
Hello, because the policy, it is not policy, Your Lordship. When vehicle is attached to the government, they are collecting charges from me also. When they
You
are
are a taxi service provider, you be a taxi service provider. You are not the government. Petitioner
I
is
am
before
not
this
government,
court
Your Lordship.
seeking for, you are not the government. Petitioner is before this court seeking for the following reliefs. Essentially, the relief which has been sought for is a direction not to collect parking fees by the Kempegowda International Airport Limited. The petitioners being taxi drivers operating under license from the Karnataka State Tourism Development Corporation. There being various other taxi service providers like Uber, Ola and private service providers who are required to make payment of parking charges. There cannot be any differential treatment provided to the Karnataka State Tourism Development, provided to the taxi service operated by the KSTDC. the relief sought for being non-maintainable, the petition stands dismissed. Pending IA stand disposed.
Serial number 68. Nagaratna SK.
LRs of respondent, madam.
LRs of one Rudrappa who is actually dead. He's not been arraigned as a party here. His no mission.
Notice ಹೋಗಿದೆಯಾ notice? Has notice been issued?
No, Swami, ಹೋಗಿಲ್ಲ. First time it's come before the
First time. 24 matter ಇದು.
24 matter. There were several office objections. In fact, these persons were made parties in the writ petition. Subsequently, I was told
In
to
the
file
compromise
a
decree.
Yes, madam.
Yes, why are you asking for this?
Compromise decree is challenged.
What are the facts for us to issue notice?
Your
If we don't,
Yeah,
every
your-
local compromise is being challenged.
compromise has been challenged. The suit
On
schedule
what
property.
ground?
These petitioners are not the parties to the said suit, my lord.
Not
The first respondent files a suit for specific performance. Even before that, my lord, the first respondent files a suit for partition against the petitioners in respect to the same property that is pending consideration before the court. Meanwhile, a suit for specific performance is being filed by first respondent against respondent 2 and 3. And the suit is decreed by way of compromise within 2 months, my lord. Within 2 months, the suit
When
is
did you
decreed.
file a suit for partition?
Partition is annexure E, my lord. Annexure E is the suit for partition filed by respondent number 2, who is now no more, my lord. Their LRs are to be brought on record. I have filed an application.
Respondent number 2 is no more.
No more, my lord.
You are his legal heirs.
Respondent-
Respondent number 2 entered into the compromise in OS
Respondent
217.
number 1 and 2. Respondent now, 1 is dead, my lord.
Respondent number
1 Rudrappa.
Subramanya is respondent number 1.
Now, Subramanya is the person who filed a suit for specific performance
Correct.
in OS 217/19.
You are claiming under Rudrappa.
Rudrappa and his wife, Chaudamma.
Chaudamma.
They have filed a suit for, Rudrappa has filed a suit for partition, which is at annexure D, my lord. I have produced the plaint in the said case. That in that, my lord, item number 2 is the suit schedule property. 12/1, my lord.
So even Rudrappa's right was inchoate.
Yes, my lord.
Issue notice to respondent number 1. Your IA is for?
IA is to bring the deceased Rudrappa's LRs on record. In fact, I had brought them on record, but office objection was raised to file an IA, my lord. So I have filed an application to bring them on a record. Prior to filing of writ petition, he was dead.
First defendant in OS 158 Antira. What is this one?
158 ಅಲ್ಲಿ Rudrappa is ಅವರು Rudrappa ಇವರು Rudrappa sir. ಅದು ಕನ್ಫ್ಯೂಷನ್ ಆಗುತ್ತೆ.
There are two Rudrappas.
158 ಅಲ್ಲಿ plaintiffs was filed the suit for partition.
Illa madam, please check. 158, the first defendant is Lakshmamma.
Lakshmamma is Rudrappa's wife. Here she is second
But
plaintiff.
then your
Second
application
petitioner,
saying proposed LRs of Rudrappa. Please
No.
check your application properly. Counsel for the petitioner is granted 2 weeks' time to verify the application made and make a submission released on 17 July. There seem to be a lot of errors.
Yes.
Serial number 69 urgent, serial number 70. Yes, Ramamurthy.
Yes, Mr. Ramu.
Senior citizen.
70. 69. Urgent.
70. Serial number 70.
My lord.
Yes.
My lord, serial number 69, interim order to be extended, my lord.
69 interim order extended.
Macho.
There's a bereavement in his family. They did not inform me.
Lordship will recall this as senior
Lord,
citizen matter.
I was called upon to furnish how I could maintain the petitioner. In the registry, I
senior
have
citizen
filed the details.
matter.
And
There was an application filed by the senior citizen before the tribunal. Tribunal cancels the gift deed against which he challenged. There was an interim order that was governing that arrangement. The lordships had directed him to secure instructions on what would be the maintenance amount that you're ready to pay. Not, I was also asked to secure instructions.
Yes, both of you, yes.
But I have something
That was
to
on
say.
8/6/26.
Yes. Yes, ma'am. My learned friend has
I
filed a
furnished-
memo in which he says,
they have not furnished anything, how much they require. They have not furnished anything, my lord.
Both of you are counsels, you can talk to each other. It doesn't need to be only in court. There's a canteen, coffee is available. You can discuss there.
Can I say something?
Yes.
And
They have given,
she's
their
capable
submission
of,
is that 8,000 will be paid. I will show you the photo of the senior citizen.
Just one moment, just one moment. Let's understand this. Financial condition of the is found vis-a-vis the petitioner. All is for.
Look, this is more like a husband and wife maintenance dispute where you're saying that 50 rupees tips and all is being said. This is her father that she's talking about.
This is the next set of litigation, which is still overtaking husband and wife litigation. Senior citizen litigation has become the most now. So you are ready now to pay 8,000 rupees.
8,000.
Finally, after all this story, it is 8,000 rupees.
yes, because
I have something
earning
to say.
capacity itself is, she earns about 8,000
legal
rupees
submission is
as a
going to be-
maid. And 2,000 rupees from the government, 6,000 rupees maid, and 2,000 rupees from the government under the scheme. Whereas husband is an auto driver, and he earns about 400 rupees per day, and out of which he has to pay, including the auto he hires, and per day excluding the expenses, the diesel and the 180 rupees we paid for the owner of the auto. Yeah, around 400 rupees he saves every month, every day. So 20,000 rupees around month the husband earns. She earns about 8,000 rupees. So 28,000 rupees. In addition to it, her son is a second PUC file and he has to pursue his studies further. So 28,000 is their capacity, out of which 8,000 rupees. And whereas the father's earning income is around 3,88,000 rupees per year. And he himself requested the tribunal to pay 4,000 rupees, each son to pay 1,000 rupees. So 4,000 rupees they readily agreed.
That is the situation today.
Yes.
The parents in the evening of their life have to request for
She
the
is
children
looking
to take
after
care
it
of them.
because
After they have taken care of the children and children have reached a particular stage. If not for them taking care of you, they would not have earned any money.
no, in
Just
the
want to
house
show your
itself.
lordship.
Let him make his submission.
I just want
This
to
is
show-
not acceptable, Mr.
Just show the photo. He is not able to physically travel.
You are
and
giving
come.
us the iPad.
No, just a photo. Just a photo.
Last time you took it away.
He can walk 1 kilometer.
Show your lordships, the petitioner and how old he is, and he has medical bills to pay. Not ideally. But my legal submission is going to be this.
Yeah.
In your lordship's judgment in Venkatayam, indicated that there the party who had approached had indicated that he's not going to maintain. But I have a slightly different take. Not when a gift deed is given, it is given on the premise that with a legitimate expectation of care and dignity being respected through his old age. Here, when he goes and makes that application to the tribunal, although it's a continuous obligation to maintain and prevent any neglect, when he went and made that application, that was after having suffered years of neglect, he making a clear conscious choice that he wants to revoke the deed. And when he makes that decision to go and apply or not, at that stage your lordship will have to see whether there has been neglect. Now to see, Lord, whether are you now ready to maintain, will ignore those years of neglect. So, Lord, when I make that exercise of choice by going to the tribunal and making that application that please set aside because I've suffered years of neglect, and the entire consideration on which that gift was done was that my daughter will take care of me at the evening of my age, Lord. The lordship will have to see at the time when I filed it.
That aspect we can no longer consider since Supreme Court has already dealt with it and only one condition has been imposed, that there is a maintenance. If there's no maintenance, and when we find the document to be ex facie fraudulent, that is when we intervene. Otherwise, we don't
Yes,
intervene.
no, what I'm trying to say is the
Position to point of time of neglect
at the
is
time,
not
because
only
it's a
the
continuous
maintenance
obligation.
in terms of money, but in love and affection is what.
Love and affection, one issue, Lord. Of course, maintenance will include having to take care of me by ensuring that my medical bills are paid. Lord, he's bedridden, he needs medical help. And if you Lordship were to read this memo, it seems as if, she's doing it for the sake of doing it. Not that's the idea that I was trying to say.
Yes.
Yeah, Lord.
Yes, Mr. Ramurthy.
This is because even 2 days back, they said he was laid up with fever and so out of things. But the 1 kilometer or 100 kilometers having gone to the market, he has come there. He was walking and he is well and healthy. And every photo they have taken.
Thank you for certifying your father's ill and healthiness. Thank you for the certificate.
Yes.
You are ready to only pay 8,000 rupees for both of them to be taken care of. You don't need to reserve the property. We'll cancel. That's not maintenance.
Yes.
We had asked you to get instructions.
And house major portion they are staying and one portion she is staying. And there is no need for any shelter. That is there. Only for the maintenance. She is looking after the father because she is nearer. She is in the house itself, right side. But whereas the sons are in different places.
We can't say anything to you on these because it will not look good.
But her.
You will have to advise your client properly.
Yes.
8,000 rupees to be given for two people, whether anybody can survive on 8,000 rupees at that age with their medical and all the other requirements.
She will look
You want the
after.
property. But you say only 8,000, ask the sons also to pay.
Their financial condition also may Lordship may kindly.
We'll cancel the gift deed.
Yes.
Let her take care of them. If they are taken care of properly,
Will it
maybe they will
always-
give the gift to her only later or leave it to her. It's their property, not your property. That is the mistake. If a son or a daughter wants to get some property, let them earn the.
And the medical, they will attend to the medical aid as well.
ಎಷ್ಟು ಕೊಡ್ತೀರಾ ಮಂತ್ಲಿ ಎಷ್ಟು ಕೊಡ್ತೀರಾ ಅಂತ ಅದಕ್ಕೆ ಕೇಳ್ತಾರೆ
8,000 rupees.
ಅದ್ರಲ್ಲಿ ಆಗಲ್ಲಪ್ಪ ಅದ್ರಲ್ಲಿ ಆಗಲ್ಲ 8,000 rupees when they are at that age 75 80 years old, not possible. You're not ready to take care of their medical health. Third, you want to get instructions once more or get proper instruction? We'll have it another day. Speak to each other.
Yes.
See what you can resolve.
Yes.
That kind of a submission will not.
I will speak to him.
There's nothing being paid in the interim as well for the last 12 odd months.
We'll dispose of the matter in its finality, whether this way or that way.
Not ideally, if they were to pay 25, 50,000, he's not going to live for more than 3-4 years. They would have got the property and whatever maintenance also will come.
What is the value of the property?
25 into 30 site.
What is the value?
35 lakhs, that is what it is said. That is my
You would
information.
rather
She
pay
gave me.
50,000, get the property than having to lose the
35
property.
lakhs.
In
Good sense
35
must
lakh
prevail on
property, when you are getting, you want to pay 8,000 rupees per month.
I will discuss with my friend.
Please,
and,
Please advise.
yes.
If they don't agree, she doesn't agree, it doesn't matter.
I will discuss with my friend also.
But 8,000 is not a good ground. Shri S. Ramurthy has entered appearance for the petition, delete Girish MK as that appearing for the petitioner. The counsel for the petitioner has filed a memo enclosing his submission. After reading the submission, the gist of the submission is that the petitioner is willing to make payment of a sum of rupees 8,000 per month for maintenance of the respondent father and mother, and as also the mother who is not a party to these proceedings. Respondent number 2, the mother being maintained by the respondent father. The said offer made is not acceptable to the counsel for respondent number 2. Counsel for the petitioner seeks for and is granted 10 days time to obtain better instructions and make a submission. Relist on 17th July. Interim order earlier granted is extended till next date of hearing.
Date yavada? Brief.
71, T. Sheshgiri Rao.
Date.
17 July. Astrology, try and solve it.
Yes, I will just show.
If your client is telling you the property is 35 lakhs, it is worth much more.
Okay, 35 lakh property. Yes, I'll just.
71.
There was an order passed on 10/1/25, interim stage. This court felt that there is no order of cancelling the gift deeds. And yet, after such an observation is made, and after the state is notified, the Assistant Commissioner has directed the registration authorities to cancel the sale deed, the gift deed. And that has led to the amendment. 10/1/25.
Service is not complete. Why are you arguing?
Service, they're residing in the same place. They're not receiving the notice.
Take out hand summons.
I'll take out hand summons. Your Lordship may fix a date in the next week.
What is this amendment that you sought for?
Because now they have challenged they have cancelled the gift deed.
IA 1 of 25 has been filed, challenging subsequent order passed by the Assistant Commissioner, being of the considered opinion that the
Notice issue. Subsequent notice not issued to the registrar.
subsequent notice issued.
Yes, and cancellation.
For cancellation of the sale, gift deed. Being of the considered opinion that the same would have to be considered to completely and effectively decide the list between the parties. IA 1 of 25 is allowed counsel for the petitioner to carry out necessary amendment and file amended petition. Issue notice to respond number 2 and 3, emergent notice returnable by 20th July.
And by hand also.
While issuing the notice, the amended petition, the registry is directed to include the amended petition. The counsel for the petitioner is also permitted to serve the amended petition along with the documents by way of hand summons on respond number 2 and 3.
Interim order was there.
Extended.
The correct address, insufficient address.
Insufficient. Residing in the same address sometimes. Yes.
72, yes, Rajshekar.
My lord, appearing for respondent number 5, I would like to submit memo of citations and memo of document, my lord. Regarding memo of citation already presented
This
in
matter. Directly don't go to memo of citation.
72 minutes, office note minutes regarding dispensation. Second minutes regarding office objection on the statement of the objection.
It's not even been heard. Why are you going to memo? Ian copy?
Office note 2 minutes that regarding statement of objections on IA minutes that may not survive. Or since minutes the impeding application that on the last 8 minutes it came to be allowed. Office note 2 says minutes the objections on
Based on SOB on
SOB that
IA 1 having been allowed, there would be no need to rectify the objections on the statement of objections to IA 1 of 26. What is this production of certified
minutes dispensation minutes next year?
IA 1 of 25 is allowed. You have filed your objections?
Objections minutes on 18th minute they have filed minutes. I like to file a rejoinder minutes.
Going to file rejoinder.
Please. My lord, you had mentioned to file it on 19th, but I served it one day prior to them.
Very good.
18th minutes they have filed.
So you want to file your rejoinder?
Please,
and what do you want to file?
Memo of citations and memo of documents.
The respondent number 5 party in person has filed is memo of citations with citations. Copy you have given them?
No.
Copies thereof have been furnished to the counsel for the petitioner, as also learned AGA. The said memo is taken on record. Counsel for the petitioner seeks to and is granted 10 days time to file his rejoinder to the statement of objections. Rejoinder, if any, to be filed on or before 10th June after serving a prior advance copy on the party in person by way of email at the email ID to be furnished by the party in person to the counsel for the petitioner. Relist on 17th July. You want to file your counsel for the petitioner to also file his list of authorities along with authorities on or before 10th June 26 after serving a copy there prior advance copy thereof on the party in person.
Interim order.
Interim order earlier granted is extended.
73, Gurudatta K.
Petitioner, my lord. Yes. Respondent 2 in this matter.
So Puneet, you are appearing for respondent.
2, my lord.
ನಿಮ್ಮ ಹೆಸರು?
Hiremat, my lord.
Sri Somnath as Hiremat has entered appearance for respondent number 2. Delete Puneet as that appearing for respondent number 2. Yes, ready?
Please.
Yes, my lord.
Really.
My lord, this petition was filed challenging the order passed by the first respondent, directing the
Speak in the mic, please. We can't hear you well.
This petition was filed challenging the order passed by the first respondent, directing the petitioner to pay the maintenance amount of 15,000 rupees. My lord, the petitioner is a daughter-in-law of the second respondent, and petitioner has been passed away due to COVID. And on the compassionate ground, a clerical job was offered to her, and she is working in that clerical job, earning a
What is her
meager income.
salary?
Sorry, my lord.
What is her salary?
Approximately 40,000 rupees, my lord.
40,000 per month.
Approximately. Yes.
Who received the benefits, insurance benefits and all the other benefits?
My lord, as per the instructions what we have got, benefits were passed on to the second respondent, my lord. Second respondent.
Yes.
Around 12 lakh rupees was passed on to the second respondent.
How much was received?
Around 12 lakh rupees.
And how much was passed on?
Entire amount has been passed on to the second respondent. That's what claims. Yeah. And the petitioner is having 2 children to maintain, my lord. So, and the entire earnings, whatever comes from that job, is goes to the maintaining their family and children education. And the second respondent is having nearly 5+ acres of income generating property, agricultural land, and from which he is earning an income, my lord, to maintain themselves. And petitioner, the second respondent is also having a daughter. And my lord, the fact is that as per the section 2A and C of the maintenance and welfare of the parents in the
This is
Citizens
only
Act.
a question of amount. Can we refer the matter to mediation? Are you agreeable for mediation?
Some 2024 ಇಂದ ಇಲ್ಲಿವರೆಗೆ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಒಂದು ಪೈಸೆ ಕೊಟ್ಟಿಲ್ಲ. ರೆಸ್ಪಾಂಡೆಂಟ್ 2 ಪ್ರೆಸೆಂಟ್ ಇದ್ದಾರೆ ಸ್ವಾಮಿ. ಕೈಂಡ್ಲಿ ಟು ಹಿಯರ್ ಬೈ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ 2 ಇವರು. ಇಲ್ಲ ಹಾರ್ಟ್ ಸರ್ಜರಿ ಆಗಿ ಸಫರ್ ಆಗ್ತಾ ಇದೆ ಸ್ವಾಮಿ. 16,000 ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಮುಂದೆ, ಒಂದು ಪೈಸೆನೂ ಕೊಟ್ಟಿಲ್ಲ. ಅಲ್ಲಿ ಸ್ಟೇ ಆದ್ಮೇಲೆ 2024 ಸ್ಟೇ ಆಗಿದೆ. ಇಲ್ಲಿವರೆಗೆ ಆದ್ರೆ 2 ವರ್ಷ ಆಯ್ತು ಸ್ವಾಮಿ. ಎಷ್ಟು ಒದ್ದಾಡ್ತಾರೆ ಮಗು, ತಂದೆ ಮಗಂದು ಇರುವಂತ.
ಮೀಡಿಯೇಷನ್ ಹೋಗ್ತೀರಾ ಇಲ್ಲ ಇಲ್ಲೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ? ಎರಡರಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಹೇಳಿ ನಮ್ಗೆ
ಆಗ್ಬೋದು.
Because it's only a question of money. ಬೇಗ ಅಲ್ಲ ಆದ್ರೆ ಒಳ್ಳೇದು ಅಂತ is what we thought.
Please.
Left to you.
ಆಗ್ಬೋದು ಸರ್ mediation.
My lord, one more submission. As per the maintenance and welfare of parents or senior citizen now, daughter-in-law is not falling in the definition of either children or relatives, my lord.
We'll read that into relative. We are reading that into relative.
Okay.
In relative, she will come in.
Okay.
May not be children. Both the councils submit that if the matter is referred to mediation, there is a possibility of amicable settlement being arrived at. In that view of the matter, the director, Karnataka Mediation Center, is directed to appoint a suitable mediator to try and mediate the disputes between the parties. Since the order is passed in the presence of both the councils, they shall be present before the director, Karnataka Mediation Center, without requirement of any notice on 3rd July 2026 at 2:30 p.m. Fourth Saturday, Saturday 5th full day na mediation center. 10:30 a.m. on 4th July. Released on 23rd July to ascertain the progress in mediation. It's made clear that if the mediation is going on successfully, the file need not be sent back. Interim order earlier granted is extended till next date of hearing.
One submission.
Some amount you have to pay. You can't be. You can't say I won't pay anything. You are earning 40,000 rupees.
This is having 2 children to maintain.
Some amount you have to pay.
Kindly to direct the interim amount can.
Interim order
ಹೆಂಗೆ determine ಮಾಡೋದು ಇವಾಗ?
ಅವ್ರು ಸಫರ್ ಆಗ್ತದೆ. Kindly to see the reports of the ಹಾರ್ಟ್ ಸರ್ಜರಿ ಆಗಿದೆ ಸ್ವಾಮಿ. ಇಲ್ಲಿವರೆಗೆ ಅದ್ರ ಮಗನಿಂದ ಒಂದು ಪೈಸಾ ತಗೊಂಡಿಲ್ಲ ಸ್ವಾಮಿ. ಅವ್ರ ಪಾರ್ಟಿ ಇಲ್ಲೇ ಇದ್ದಾರೆ, ಒದ್ದಾಡ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ. Kindly to.
Till mediation completes, probably interim order may be extended, my lord.
ಆದ್ರೆ ಇಲ್ಲಿವರೆಗೆ 2 ವರ್ಷದಿಂದ ಸಫರ್ ಆಗ್ತಾ ಇದೆ ಸ್ವಾಮಿ. 2024
mediation is a ground for adjournment ಅನಿಸ್ತಾ ಇದೆ.
No, my lord.
Argument ಮಾಡಿ.
No, she is also in, not in the right condition to pay the maintenance.
You are receiving your salary.
At the same time, my lord.
Some amount you have to pay.
The respondent is also having an income, my lord. He is having a 5+ acres of land, coconut yielding land, and he is earning nearly 40,000 per 2 months by selling the tender coconut, and also is having a coconut farms from which he is getting a good income, my lord.
ಆ ಏಜ್ ಅಲ್ಲಿ ಏನ್ ಅಗ್ರಿಕಲ್ಚರ್ ಮಾಡಕ್ ಸಾಧ್ಯ ಆಗುತ್ತೆ ಸ್ವಾಮಿ. ಇರೋದು ಒಂದೇ ಮಗಳು, ಒಂದೇ ಮಗ. ಅವರು ಕೂಡ ಅವ್ರ ಗಂಡನ ಮನೆಗೆ ಹೋಗಿದ್ದಾರೆ ಮಗಳು ಸ್ವಾಮಿ.
And the second respondent,
ನೋಡ್ಕೊಳ್ಳೋರು ಯಾರು ಇಲ್ಲ ಸ್ವಾಮಿ.
second respondent is also having a daughter, my lord. So
Senior citizen matters are getting something needs to be.
ಸ್ಪಾಟ್ ಆದ್ರೂ ಅಮೌಂಟ್ ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ರೆ
Panindra,
ಲವ್ಲಿಹುಡ್ ಇವರ
do something. It is emotionally draining on this both sides.
Relitigation mediation.
Nodi mediation, nodi. After that we'll hear you.
some amount ಆದ್ರೂ ಬಂದ್ರೆ
Some amount we have to hear you and pass a reasoned order.
Please.
If you want to argue, if you're not agreeable for mediation, we'll take it up for hearing here. There's no issue about it. But if you can settle it well and good, it will be, but it cannot be a ground for adjournment.
it's not on that ground, my lord. So because
That is why we have listed it on that day. Sariyagi ಏನು ಆಗಿಲ್ಲ ಅಂದ್ರೆ we'll take it up on that.
ಹೌದು.
wait for
74.
Modification.
Passed over matter.
74.
If the modification will have to go before the same judge.
No, it's actually, it is the interim order stayed the impugned order, but while also directing me not to.
IA 1 of 26, do you want to press or not press? You want to press it, will have to go before the same judge. As simple.
No, I'll have to, because it's a modification, because there is a direction, not.
Registry is directed to, ಯಾರಮ್ಮ ಮಾಡಿದ್ದು?
My problem is, Lord, your Lord, otherwise, can I suggest, let them.
ಕಲಬುರ್ಗಿಗೆ ಹೋಗ್ಬೇಕು ಫೈಲ್ ಹಾಗಾದ್ರೆ.
Lord, may I just, your Lordship may keep that pending for the present. Let the government at least come out. They have not even filed counter or any version. So, Lord's, at least for.
Communication, my lord. Kindly see their prayer, my lord.
You want to file objection, don't want to file? You'll file. And AGA 6 is granted.
10 days time.
10 days time to file a statement of objection. Relist on 17 July. Submission of learned counsel for the petitioner is that he does not wish to press IA 1 of 26 for now is placed on record.
For the present.
For now.
Please.
Still
number 43,
Passed
my
over
lords.
matter, my lord. Officials are present, my lords. Passed over matter, officials are present. EPMP matter, my lords. List 2, seal number 3.
List 2 serial number?
3, my lords. They are tendering their apology. And
What have they done now? They have issued notice?
Yeah, we have
or no?
issued notice, my lords.
When?
On 23rd of June. Next notice will issue on 6th of July, my lords. They have tendered their apology. We'll comply with the.
This is becoming the reason for all the illegal constructions.
I'll also
Despite
monitor.
court
my
orders, if you don't do it, what is the point? How do we accept the apologies? We'll ask.
By 6th July, we issued a provisional order, my lords. We'll
ಏನೋ
follow.
mistake ಮಾಡಿದ್ದಾರೆ ಬಿಟ್ಟು.
Lords, may I request this, my lords may,
Just a minute.
my lords may revive this writ petition, keep it pending, my lord. Let the procedure be completed because.
That is a better idea.
Please,
Lords, we'll comply, my lords.
You comply.
Yes, yes.
IA 1 of 26 is allowed. The petition is restored. That counsel for respondent number 1 to 5 has filed an apology of respondent number 1 to 5.
1 to 5.
The same is taken on record.
They're also present, my lords, officials.
They are also present. Their presence is noted. Order sheet signed, man. Next milestone is 6th.
6th, my lord, 6th July.
Relist on 17 July.
Seal number 43, my lord.
My lords, Seal
number
one,
43, my lord.
one correction, my lords. 13th July, my lords. 13th July is the next date.
It's 17 July.
Yes, great, my lords.
76 BWSS.
Seal number 43, my lord. Any date, my lord, so first week of July, my lord.
Any date first week of July ಆಗಲ್ಲ.
Please.
You can't put that. Next date is all after
Because of
17
this is the, my
July.
lord, senior citizen act, my lord, because
ಪ್ರಸಾದ್ ಏನ್ ಮಾಡೋದು?
one property they are enjoying and this is another property. For
See, you
livelihood
don't
purpose.
reach because on each of those days, more than 100 matters have been posted already. And there are going to be 40, 50 new matters.
I will take.
Don't reach. Take chance andre hinge.
Serial number
Then ಆಮೇಲೆ
76.
ಮತ್ತೆ ಹಿಂಗ್ ನಿಂತ್ಕೊಂತೀರಾ?
Serial number 76.
Any date, my lord. If I could mention serial number 81, fresh matter keeps getting listed under hearing on IA.
81 fresh matter.
Even day before yesterday, it was listed under hearing on IA. If I could request Your Honor to direct the office to list it under fresh matters day after.
81 IA 1/26 is allowed.
Your Honor, allowed
Relist
it on
on,
the day before yesterday also.
relist on
Yes. Getting listed under hearing on IA, supposed to be listed under fresh matters.
relist on 30th June.
My lord, it's
Your Honor, may
93,
say
my
fresh
Just a
matters.
moment, we are coming in line.
Your Honor, may kindly say fresh matter, otherwise again.
Fresh
then it's
matters.
great.
Yes, madam.
These
Huh?
are reporting settlement in the matter. It was passed over counsel for the petitioner.
Consensus has been reached, my lords. A date may be fixed, my lords.
Parties have to come?
Parties are here, but then the
Are here,
compromise-
then?
No, it's not ready.
Not ready. Okay, 48, both the council submit that the settlement has been arrived at. They will be reporting settlement if the matter is taken up on.
Any date, my lords, that's convenient to the court.
Settlement, you tell us any date that parties are going to come. 29th at 2:30 PM under the caption reporting settlement.
Disclosure to the court. The dispute in that particular case is about 4 to 5 gift deeds, which were all cancelled by the order of the AC. One of the gift deeds, one scheduled property in the gift deed, it's subject matter of an RSA filed in 2018. That is
We can consider it only that. Please examine it properly. You examine and make your submission, we'll consider it on that. Yes, madam.
93, my lord.
Huh?
There is urgency in the matter, my lord. Kindly I'll next week, my lord.
93.
It's a tender matter, my lord.
Awaiting service on respond number 3. Respond number 3 has not been served.
Yes.
So, awaiting service. So,
Next
yes,
week, my lord,
70.
kindly, my lord.
82, my lord.
Huh?
Direction, but I thought for a mandamus for registration of crime. Compared to Madilla.
Non-compliance with office objection. Comply with the office objection.
76, my lord. 76.
Hmm.
Lord, tender has been stalled, my lord. BWSSB, my lord. All the project works have been stalled.
Yes.
Next week, anytime.
Parole. 77. 87. What is it for?
State government reject my application. If I
Who is to be impleaded? What is this IA2 for impleading? ಯಾರನ್ನ implead ಮಾಡಬೇಕು? Then we have to issue notice. Is there a standing counsel for the association? Is there a standing counsel for Para-Olympic Committee?
Sachin BS.
Sachin BS. Issue notice on IA2 of 24. Shri Sachin BS, standing counsel, is directed to accept notice for the proposed respondent. Counsel for the petitioner to serve 2 sets of the petition along with annexures on the said counsel, released on 17 July. One ನಿಮಿಷ ಅವರು ಇದ್ದಾರೆ. interim order. Yes.
Any
80?
date?
Huh?
Lord, IA has been filed. I am for respondent number 5. Lord, I need to file 6. Lord, I need to file an objection. Lord, IA is replica of an interim. It has been served.
When will you file your objections?
Lord, a week's time, Lord, I will file an objection. No, my Lord. Lord, I will establish my jurisdiction, my Lord.
Order illegal, unlawful, ಎಲ್ಲ ಅಪೀಲ್ ಬಂದಾಗ ಏನಾದ್ರು ಹೇಳ್ಬೋದು.
76, my lords.
Yes.
76, my lords. BWSSB matter, which the work is all stalled, my lord. Now, my lord, if it starts raining, my lord, entire
Raining.
work is stalled.
76.
Anytime next week or.
76, IA 1 of 25 is allowed.
There are 2 other matters, which may I request to connect with those matters.
76.1. IA 1 of 26 will be taken up along with the main. Statement of objections you have.
My lord, first matter we have filed, my lord. By
There are
next
2
time
other
we will
matters,
also.
Lords. I am for the petitioner in that matter. 2 other matters may I submit.
Who is Ranjit Chiplunkar? Who has filed the impleading application.
my lord. My lord, the work has been allotted to him, my lord.
A week's
He is
time
the
is
successful
granted.
tender.
A week's time is granted to the impleading applicant to comply with the office of, 3 days' time is granted to the impleading applicant to comply with the office objection raised on the application. If compliance is not.
appearing for the impleading applicant, my lords.
You are appearing for Mr. Ranjit Chiplunkar.
Please, my lords.
Then why are you not complying with the office objection?
Plus, office objection may be overruled, my lords.
Very nice. We can't overrule all those things. You serve a copy on them. Without serving a copy, you're saying WhatsApp.
Served, my lords, already served.
3 days time is granted to comply with the office objection. If not complied by next date of hearing, IA 1 of 26 will be liable to be dismissed for non-prosecution. Same. What is IA 2 of 26 in 76.1?
Lord, vacating, my lord, I filed my vacating IA, my lord.
1 of 26 is vacate. 2 of 26 in.
2 of 26.
For impleading, my lords.
Impleading, same order. What are the other connected matters?
Yes, there are two other matters.
Lords, may I
Connect
submit
with
my
so and so.
The interim order may be extended in 76.
Connect with so and so. Relist on 1st July. The respective counsels for respondents are permitted to file the respective statement of objection and get ready with arguments by that date.
Lordship, serial number 46.
Further adjournment would be granted.
Lordship, serial number 46.
Lord, they have
E in
moved the-
29.
Lordship.
Lord, it was given date for 29, my lord.
86 and 29 date given Act
Yes, my lord. They have moved the matter, my lord, without informing us, my lord.
December.
Please, my lord.
29th in the you have advanced it to 24th. What is this?
Lordship.
My lords, I appear for serial number 84 petitioner, my lords.
Lordship, serial number 46.
My lords,
Lordship.
my lords.
Good of sir.
Passed over matter.
Passed overs ಎಲ್ಲ third.
46.
Passed overs third.
46. Serial number passed over.
3rd July. Passed overs 3rd July. ಇನ್ ಮಿಕ್ಕಿದ್ದೆಲ್ಲ ಯಾವ್ದು ರೀಚ್ ಆಗಿಲ್ಲ 17th.
Interim order extended.
ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 84 ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬೇಕಿತ್ತು.
ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಮೇಡಮ್.
ಓಕೆ
ಚೆಕ್ ಮಾಡ್ತೀವಿ ಫೈಲ್ಗೆ ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
ಥ್ಯಾಂಕ್ ಯು ಮ್ಯಾಮ್, ಥ್ಯಾಂಕ್ ಯು.
ಆಗಲ್ಲ ನೀವ್ ಯಾವ ಡೇಟ್ ತಗೊಂಡ್ರು ಆಗಲ್ಲ. ನಾವು ಕೊಡೋ ಡೇಟ್ ತಗೊಳ್ಳಿ ಅವತ್ತಾಗುತ್ತೆ. 17 ಜುಲೈ.
ಮೇಡಮ್
ಪಾಸ್ಟ್ ಓವರ್ಸ್ ಮಾತ್ರ 3rd ಜುಲೈ.
ಸೀರಿಯಲ್ ನಂಬರ್ 29th ಇತ್ತು ಅದೇ ಡೇಟ್ ಅಂತ ಕೊಡಿ ನಮಗೆ.
ಈಗ ನೀವು ಅದನ್ನ ಅಡ್ವಾನ್ಸ್ ಮಾಡ್ಕೊಂಡಿರೋದ್ರಿಂದ ಯಾರು ಮಾಡಿದ್ರು ಅವ್ರಿಗೆ 17 ಜುಲೈ.
ನಂದು 79 lot 1.
79 ನೀವು 14% ಯಾವತ್ ಬೇಕು?
Every time I am getting the this one.
ಯಾವ ದಿನ ಕಾಯ್ಬೇಕು? ನೀವು ತಾನೇ ಕಾಯ್ಬೇಕು.
ನಾಳೆ ನಾಡ್ದು ಯಾವಾಗ ಕೊಡಿ?
ನಾನು ಪಿಟಿಷನರ್ ಆ ಕೇಸಲ್ಲಿ.
At the earliest.
ಇಲ್ಲ ಅದು 14% ಅಪ್ಪ.
At the earliest.
14% ಮಾತ್ರ ಅವ್ರು ಕೇಳೋ ಡೇಟ್ ಕೊಡ್ತೀವಿ.
At the earliest. Every time I am getting ನಾಳೆ ನಾಡ್ದು ಯಾವಾಗ ಕೊಡಿ?
ಹೇಳಿ ನೀವ್ ಹೇಳಿ.
ನಾಳೆ ಕೊಡಿ. ನಾಳೆ ಕೊಡಿ.
ನಾಳೆ ಹಾಕ್ತೀವಿ.
ಓಕೆ
ಮೇಡಮ್ ಇಂಟೀರಿಯರ್ ಆರ್ಡರ್ ಇದೆ ಅದರಲ್ಲಿ.
ಯಾವ್ದ್ರಲ್ಲಿ?
79 ಅಲ್ಲಿ.
ನೀವು ಯಾರಿಗೆ?
ಪಿಟಿಷನರ್ ಅದನ್ನ ನಾನು ಪಿಟಿಷನರ್.
14% ಇದಾರಲ್ಲಪ್ಪ.
ಇಲ್ಲ ಮೇಡಮ್ ನಾನು ಪಿಟಿಷನರ್
79
ಜಗದೀಶ್ ಗೌಡ.
ಸ್ಲಾಟ್ 1 79
ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ. ನಿಮ್ ಕೇಸ್ ನಂಬರ್
ಸ್ಲಾಟ್ 1 79 ನಂದು.
ಇದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಫೈಲ್ ಚೆಕ್ ಮಾಡ್ತೀನಿ ಇನ್ಮೇಲೆ ಗೊತ್ತಾಗುತ್ತೆ.
ಸ್ಲಾಟ್ 1 79
79 ರಾಮಚಂದ್ರ ಅಲ್ಲ.
ಹೌದು ಹೌದು ನಿತಿನ್ ರಮೇಶ್. ನಾಳೆ ಅಲ್ಲ
ರಾಮಚಂದ್ರ ಹೆಗ್ಡೆ.
Bharti ma'am. Ma'am, this matter was listed on Tuesday. Yeah. So Lordship has asked.
Listed or it is going to list?
It is listed. So Lordship has asked us to submit that.
It is reserved. Reserved or?
Your Lordship has asked us to submit that.
Madam 86.
86 17.
Madam 28 ಕೊಟ್ಬಿಡಿ madam. 20.
ಅವತ್ತು ಬಂದು ತಗೊಳ್ಳಿ.
ಅವತ್ತು ಬಂದು ತಗೊಳ್ಳ ಆಯ್ತು madam.
ಸೀರಿಯಲ್ ನಂಬರ್
80 17th
29th ಇತ್ತು ಮೇಡಮ್ ಅದೇ ಕೊಡಿ. ನಿನ್ನ ಫೈಲ್ ಬಂದಿಲ್ಲ.
ಅಲ್ಲ ಈಗ ಅಡ್ವಾನ್ಸ್ ಮಾಡ್ಕೊಳ್ಳೋದ್ರಿಂದ 17th ಈಗ.
ನಾವು ಅಡ್ವಾನ್ಸ್ ಮಾಡಿಲ್ಲ ಮೇಡಮ್.
ಯಾರು ಮಾಡಿದ್ರೋ ಅವರಿಗೆ ಅಷ್ಟೇ. ಅಲ್ಲ ಇಲ್ಲಿದೆ ಅವ್ರನ್ನ ಕೇಳೋದ್ ಬೇಡ ಇಲ್ಲೇ ಇದೆ ಅದು.
ಫೈಲ್ ಬಂದಿರಲಿಲ್ಲ.
29th ಇತ್ತು ಡೇಟ್.
ಮೇಡಮ್ 14% ಫೈಲ್ ಮಾಡಿದ್ ನಾನು ಇವಾಗ ಮೇಡಮ್
14% ಯಾವತ್ ಬೇಕು?
29th ಕೊಡಿ ಮೇಡಮ್. ಅದೇ ನಂದು 80 ಸೀರಿಯಲ್
80 ಕಡಮ 14% ಯಾವತ್ ಬರ್ತೀರಾ ಯಾವತ್ ಕಾಯ್ತೀರಾ? ಯಾವತ್ ಬರ್ತೀರಾ ಯಾವತ್ ಕಾಯ್ತೀರಾ?
29th
ಆಯ್ತು.
ಮೇಡಂ 85 ನೋಡಿ ಮೇಡಂ.
ಅವ್ರು ಯಾರು? ಇವ್ರು ಯಾರಂಗಾದ್ರೆ ನೀವು ಪಾರ್ಟಿ
78 ಮೇಡಂ.
ನೀವೇ ನವೀನಾ? ಇವ್ರು ಯಾರು?
ಅದರಲ್ಲಿ ಪೆಟಿಷನ್ ನಂಬರ್ 2 ಇದ್ದಾರೆ ಅವರು.
ಸೀರಿಯಲ್ ನಂಬರ್ 78 ಮೇಡಂ.
ಕಳಿಸ್ಬಿಡೋಣ ಇರಮ್ಮ. 78 17th ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
91
17th July.
Madam, 85, madam.
85, 17 July.
91.
91, 17 July. Visil ಕೇಳಿ sir.
Serial number 78, madam. List number 1.
78, 17th July.
Okay, madam.
Serial number 90.
90, 17 July.
17.
ನಮಸ್ಕಾರ ಮೇಡಮ್. ಮೇಡಮ್ ನಮ್ಮ ಮೆಮೋ ಪ್ರೊಸೀಡ್ ಮಾಡಿದ್ರೆ 15th ಗೆ ಹಿಯರಿಂಗ್ ಕೇಳಿದ್ರು. ಅವರು ಅದು ರೀಸನ್ ಸಬ್ಮಿಟ್ ಮಾಡಿ ಅದು ಅಪ್ಲೈಮೆಂಟ್ ಹಾಕಿ ರಿಜಿಸ್ಟರ್.
ಅಲ್ಲ ನಿಮ್ಗೇನ್ ಲಿಸ್ಟ್ ಆಗ್ಬೇಕು, ಲಿಸ್ಟ್ ಆಗಿದೆ ಅಲ್ವಾ? ಈಗೇನಾಗ್ಬೇಕು?
ಅದು ರಿಜಿಸ್ಟರ್ ಹೋಯ್ತು ತಿರುಗಿ ಬಂತು ಮೇಡಮ್. ಅದು ಈಗ
ಯಾವತ್ ಬಂದಿತ್ತು ರಿಜಿಸ್ಟರ್ ಮುಂದೆ?
15th ಬಂತು ಮೇಡಮ್.
15th ಗೆ ಅಲ್ಲಿ ಏನಾಯ್ತು? ಎಷ್ಟು ದಿನ ಕೊಟ್ರು ಟೈಮು?
ಟೈಮ್ ಅವಾಗಲೇ ಪ್ರಶ್ನೆ ಕ್ಲಿಯರ್ ಮಾಡಿದ್ರು ಮೇಡಮ್. ಅವಾಗಲೇ ಪ್ರಶ್ನೆ ಕ್ಲಿಯರ್ ಮಾಡಿದ್ರು. ಆಯ್ತು
ಕ್ಲಿಯರ್ ಮಾಡಿದೀರಾ? ಅಲ್ಲ ಕೋರ್ಟ್ ಅಲ್ಲಿ ರಿಜಿಸ್ಟ್ರಾರ್ ಎಷ್ಟು ಟೈಮ್ ಕೊಟ್ರು ಅಂದಿದ್ದು. ಅವ್ರು ಕೊಟ್ಟಿರೋ ಟೈಮ್ ಆದ್ರೇನೆ ಬರೋದು. 1 ವಾರ ಕೊಟ್ರ, 2 ವಾರ ಕೊಟ್ರ, 1 ತಿಂಗಳು ಕೊಟ್ರ?
ಮೇಡಮ್ ನಾನು ಅವತ್ತೇ ಕ್ಲಿಯರ್ ಮಾಡಿದ್ದೀನಿ ಅಂತ ಹೇಳಿದ್ರೆ ಕ್ಲಿಯರ್ ಮಾಡಿದೆ.
ಈಗ ನಾಳೆ ಬೆಳಗ್ಗೆ 10:30ಗೆ ಬನ್ನಿ. ಇವಾಗೆಲ್ಲ ಹೊಟ್ಟೋಗಿರ್ತಾರೆ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ. ನೀವು ಬಂದ್ರಿ, ನಾನ್ ಕಳ್ಸಲ್ಲ, ಇವಾಗ ಹೋಗಲ್ಲ, ಅವರೆಲ್ಲ ಮನೆಗೆ ಹೊಟ್ಟೋಗಿರ್ತಾರೆ. ನಾಳೆ ಬೆಳಗ್ಗೆ ಬನ್ನಿ. ಅಲ್ಲ ಕಳ್ಸಕ್ಕಾಗಲ್ಲ.
ಸೀರಿಯಲ್ ನಂಬರ್ 65 ಯಾವ ಡೇಟ್ ಹೋಗಿದ್ನ?
65.
ಈಗ ತಗೊಳ್ಳೋದು ಬೆಳಗ್ಗೆನೆ ತಗೋತಾರೆ.
65 ಅದು ಅಲೋಡ್. ಅದು ಡ್ರೈವರ್ ಅದು ವೈಭವ್ ತಾನೆ ಕೇಸು?
ಹೌದು.
ಗೊತ್ತಾ ಕೇಸ್ ಗೊತ್ತಾ?
ರಕ್ಷಿತ ತೋರ್ಸು.
ವೈಭವ್ ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕು ಅಂತ ತಾನೆ? ಅತ್ತಾನೆ ಡ್ರೈವರ್ ಪೋಸ್ಟ್ ಅತ್ತಾನೆ ಅಲೋಡ್. ಅದು ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅಲ್ಲ ಇದು ತಗೊಂಡೋಗೋರಿಲ್ಲ, ಅದು ತೊಂದ್ರೆ. ನಾಳೆ ಬರ್ತೀರಾ ನೀವು? ಅದಕ್ಕೆ ನಾಳೆ 10:30ಗೆ ಬನ್ನಿ. ನಿಮ್ಮ ಅಡ್ವೊಕೇಟ್ ಎಲ್ಲಿ? ಪಾರ್ಟಿ. ಅದಕ್ಕೆ ನೀವೇನ್ ಗೊತ್ತಾ, ಬೆಳಗ್ಗೆ ಹೊತ್ತು ಬರ್ಬೇಕು. ಇವಾಗೆಲ್ಲ ಯಾರು ತಗೊಂಡೋಗಲ್ಲ. ಕಳ್ದೋದ್ರೆ ಗೊತ್ತಿಲ್ಲ. ನಾಳೆ ಹಾಕಲ್ಲ, ಇನ್ನೊಂದ್ ದಿನ ಬರುತ್ತೆ. ಇದೊಂದು ಮೆಮೊ ಬುಕ್ ಅಲ್ಲಿ ಹಾಕಿರಿ, ನಾಳೆ ಕೊಡಿ.
ಆಯ್ತು ಮೇಡಮ್, ತುಂಬಾ ಧನ್ಯವಾದ. ಇಲ್ಲಿ ಯಾರೋ ಕಾಪಿ ಇಟ್ಬಿಟ್ಟು ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ ಮೇಡಮ್.
ಇರ್ಲಿ ಬಿಡಿ, ಬರ್ತಾರೆ ಹುಡ್ಕೊಂಡು ಆಮೇಲೆ. ಬರ್ತೀನಿ.